that thus admitting he was the uphill skier.
Okay? Did it bother you that now at the time you were in charge of all ski instructors, weren't you?
No.
What was your title?
I was the ski patrol manager.
Ski patrol manager.
Correct.
Okay. Ski patrol manager. Did it bother you that a Deer Valley employee, an instructor, whose report you read, blamed the male skier even though he didn't see it? Did that bother you at all at the time?
I don't see blame here. I just see thus admitting that he was the uphill skier.
Now, did it bother you, Mr. Graff, that on this report he never got the male skier's contact information?
No.
Now, you're sitting there a day or two later, you testified about it, and you read this report, and there's a crash that was serious enough to haul someone down off the mountain on a toboggan. And this man who's writing this report never gets the male skier's contact information. That didn't bother you?
That didn't bother me.
Did it bother you that Mr. Christensen never gave Gwyneth Paltrow's contact information? That bother you?
That didn't bother me.
Did it bother you that Mr. Christensen never gave his contact information to anybody?
None of these bothered me because at the time everybody skied away with the assumption that everyone was fine.
Okay, so your understanding was that everyone skied away even though a ski patrol person named Whitney Smith hauled Terry Sanderson off the mountain in a toboggan, and in your definition, that's everyone skiing away because they're all fine, correct?
Whitney Smith responded to Mr. Sanderson in a different location from where the collision occurred. So they all skied away.
Now, let me ask you this. This claims here that a man with 4 documented broken ribs, 2 of which were separated, broken, not just cracked, but separated. 4 documented broken ribs, said he was okay to 2 other ski patrollers that allegedly came by. Did that bother you at all?
That's my understanding of what happened.
Did it bother you that allegedly, is this yellow over here? But a patroller came by to check on everyone. Did it bother you that there was no log of that patroller?
No.
Didn't bother you. Okay. So nothing so far has bothered you, right? Okay.
These are just the facts.
Everyday life at Deer Valley, right?
Yes.
Okay. Now, did it bother you see this right here where my cursor is?
Yes.
That Eric Christensen, after this crash, goes to lunch with one of the most famous actresses in the world and her family. Did that bother you at all?
No, I think that's standard practice for ski instructors.
Did it bother you that 3 hours after lunch or so, that he then writes his report? That bother you? Did that concern you at all?
No, that's typical of what happens.
Did it ever occur to you that this instructor might be covering up bad conduct by himself to protect Miss Paltrow, a big spender at Deer Valley? Did that ever concern you or bother you?
No,
Did it ever concern you or bother you that he might be covering up bad conduct by Gwyneth Paltrow?
no,
Didn't you basically wink and a nod at this bad conduct? Wink and a nod at it.
can you define that?
You know what wink and a nod means?
No,
Well, actually you did, because we had a deposition on another case, but wink and a nod, as I'm using it, means you see something wrong, but you just wink at it and go on and don't do anything about it. Isn't that what you did here today?
absolutely not.
Okay? Why wasn't this instructor terminated for filing a false report?
This is his report. There's nothing in it that's false.
Isn't it true that you believe he wasn't fired because he did nothing wrong? He did nothing wrong,
Correct.
okay? And there was no cover-up by Deer Valley, correct?
Absolutely not.
Okay. No further questions, thank you.
Thank you, Mr. Sykes.
I just have one question, Your Honor, if I may.
Mr. Egan.
Good to see you again, Mr. Graff. Thank you for coming back.
Thank you.
Very nice of you. It's okay. He was cooperating yesterday. I think I just need to go back to the old technology again. Okay, so I just want to ask you, Mr. Graff,
Excuse me,
one question.
excuse me 1 second, I just got my computer.
Oh, yeah, go ahead. I just want to ask you, Mr. Graff, a quick question about the patrol log. Published this, we looked at it yesterday with you, Defendant's Exhibit 26A. You were asked questions, not today, but before you left the stand yesterday by plaintiff's counsel about this bad boot entry here. Do you see that?
I do see that.
And do you remember questions about how that was sort of a minor issue, and he was asking why that would be logged, but other major issues might not be?
Yes.
So can you explain what is a bad boot, and what would it require of a patroller who came upon that kind of a problem?
You know, I'm not exactly sure what this bad boot issue was, but it could be that a buckle was broken. It could be that, as funny as it sounds, could be they were on the wrong feet. You know, you see things like that. So there was some issue that Jess responded to, and it was as simple as a bad boot.
And might it require a toboggan down the hill if someone had a malfunction that they couldn't get down the hill?
Yes.
Okay, so, and then this section here, 1202, again, I'll use this little laser pointer, 1202 here, it, over in the nature of the injury discussion, it says skier collision and disorientation. Do you know who wrote that?
I don't know who wrote it. Whoever is manning the dispatch is the person who puts these entries in.
Okay, so would it be fair to say then that it would not be Whitney Smith that wrote that?
It would not be Whitney Smith. They're transcribing what Whitney Smith is saying over the radio. So Whitney Smith was on scene 2 minutes after the call came in. And then whoever was there wrote down what she said.
Okay.
And she said that she was on scene of a skier collision with the patient experiencing disorientation.
Right, and the jury has heard what her experience was, and you don't know anything further than you've already told us about that, correct?
That's correct.
Okay, thank you.
No further questions.
All right, you are excused. Thank you.
Thank you.
Is there a possibility the witness may be called back?
Not from us.
Yeah, very small.
Okay, so you're still under, I guess, this trial, so please don't discuss the case with any of the other witnesses.
Okay,
Thank you. Mr. Owens, is your next witness ready?
Yes, our next witness is Dr. Schur. We
we'll need an easel and to set up for him to draw, and we may need a second to do that.
Okay.
It's
Okay.
Go ahead and set up. Dr. Scher?
Yes.
Good morning. Come on forward here and be sworn in as a witness.
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And then take a seat here and adjust your microphone, and then please state your full name and spell it all out for us. Thank you.
My name is Irving Scher, I-R-V-I-N-G. Last name is S-C-H-E-R.
Thank you for being with us here today, Dr. Scher. Let's begin by just asking you what you understand your role here to be today.
To teach the jury about biomechanical engineering related to snow sports, in particular skiing.
And do you have an understanding of what plaintiff's biomechanical expert, Dr. Boehm, has said about this case?
I have. I've read his deposition testimony and his trial testimony, so I do understand what he's saying in the case, yes.
Okay, and you have opinions about his testimony, is that right?
That is correct. I have analyzed his biomechanical engineering analysis.
So the jury will get to hear your response to his analysis.
Exactly.
Okay, great. So before we get to that, let's talk about your background and training so they understand why you and not me are on the stand.
Sure.
Where did you go to school?
I did my Bachelor's of Science in Engineering at the University of Pennsylvania. I majored in mechanical engineering and applied mechanics. And then after undergrad, I moved west, and I got my master's and my PhD at UC Berkeley in the mechanical engineering department. And I had two disciplines that I specialized in. One was called dynamic systems. That's how objects move in space when forces are applied to them. And the other is biomechanical engineering. And that is the application of physics and engineering to the human body, in particular looking at how people get injured and how to prevent injuries.
And did you do a PhD thesis?
I did.
And can you explain what you worked on?
Sure. I was the last in a line of what we called skiologists. I studied the biomechanics of alpine skiing. I created load cells, so those are devices that measure the forces, and I put them in between the skis and the bindings, and I had different instrumentation on skiers, and it was the first time, or at least that I'm aware of, that anyone in the scientific community was able to measure the forces and the body motions of skiers from the top of the mountain all the way down to the bottom. And I did this with beginners, people who had only skied 2 or 3 days in their whole life, all the way up to professional racers. And so that's what I got my PhD in.
And this is actually measurements on the slope as people are skiing.
That's right, exactly. Yeah, I'm measuring the forces applied to the person and their body motions as they're skiing. Well, and falling. We did have falls as well.
Right, and so this is not just calculations in some ivory tower, but you're actually out in the field looking at
hands-on work, which is quite difficult when you have electronics and snow and water. It was challenging for sure.
And do you also do any teaching?
I did teach. After I graduated with my PhD, I did a small postdoc in the biology department at Berkeley. And then after that, while I was working for a company, I taught at the University of Southern California. I was in the physical therapy department on the medical campus, and I taught intro to biomechanics, and I also did research there at USC. And then I moved, I now live in Seattle, and I'm at the University of Washington. I have an affiliate professorship there. I'm an associate professor at the University of Washington, and I occasionally lecture, but mostly advise grad students.
What about professional licenses? Do you have any of those?
I'm a registered professional mechanical engineer in California, Washington, and Alaska.
And then in terms of professional societies, these groups of people that get together to research and work on a certain field, are you connected to any such organizations?
I am.
And what are those?
I am chair of a group called ASTM F27. If you've ever gone to a ski shop and purchased ski equipment or rented ski equipment and they set your bindings, what some people call DIN settings, that's based on the standards from ASTM, and I'm the chairman of that group. We also do other snow sports equipment. I represent the U.S. for snow sports equipment safety at the International Standards Organization, so the ISO. So if you go over to Europe, you'll have the same release and retention settings for your skis. Your bindings won't pull off your skis. They use the same standards that we've developed here in the U.S. I'm also president of a group called the International Society for Snow Sports Safety, and that's more academic than the other two organizations I was mentioning. We call it ISSS. ISSS is the premier organization worldwide to present and publish your snow sports safety research. And we have members from all over the world: Switzerland, Korea, Norway, obviously the US, Canada, Australia, New Zealand. It's quite a great group, and it's really the group that helped develop ski binding standards.
So you do some research on the safety of snow sports like skiing, correct?
That is my main focus of my research ever since grad school, and I've continued to do that now.
And then you also evaluate cases in a litigation context, is that right?
I do. About 15%, 20% of my work is forensic work. The rest is research and development.
So most of the time, are you doing research to try and improve the safety of skiers on the hill?
Yes, and I should say it's not just snow sports. I work in other recreational sports areas, water sports, mountain biking, other areas too, but snow sports is my favorite, my passion.
So let's explain to the jury what biomechanical engineering is, just because we could use a refresher.
Sure. Biomechanical engineering is the application of physics and mechanical engineering to the human body, but in a forensic sense, it's what links the event to the injury. So if you have some type of event and there's forces and motions in the event, in the accident, the forces are applied to a person, there's internal forces on their, like in their body at the joints or something like that. The amount of force and the amount of motion it takes to create damage to the body, that is biomechanical engineering.
And how's that different than medicine? They're both dealing with the human body, but what's the difference?
Sure. The medical field tends to take the injured person, figure out what's wrong with them, so diagnosis, and then try to get them better, so treatment, with an eventual outcome. So most medical training is after the injury, as opposed to what forces and motions create the injury. We like to think of ourselves on different sides of the injury.
Thank you. Can biomechanical engineers determine the forces required to produce fractures of bones in the body?
Yes, there's a lot of research on that, and that's one of the main areas for biomechanical engineering.
So is there scientific literature that describes the forces needed for, say, rib fractures?
There is, yes.
And you're familiar with that literature?
I am, yes.
And let's maybe ask a specific question about that literature. Given your knowledge of it, does a 70-year-old man need to fall on his side with his elbow between him and the ground to cause rib fractures?
No. So there have been a number of scientific studies, mostly done by biomechanical engineers, but there's other scientists who have looked at this as well. And what they do is they take cadavers or portions of cadavers and they apply forces to them. Sometimes they'll swing a pendulum into the side of a cadaver or to the front, or they'll have a plate, a very heavy weighted plate, contact the person arm down, arm up at 45 degrees, or they'll drop the cadaver in different configurations, and then they'll see what injuries are produced. And so when they've done this, in particular for chest impacts, what we find is you can get lateral rib fractures, according to the biomechanical engineering literature. You can get lateral rib fractures with an impact to the side with your arm down or with your arm up. But you can also get lateral rib fractures from compression, so front to back compression of the chest. So if I press my chest in like this, what happens is the ribs actually bend out on the side, and that can create fractures on the side, and that's quite common as well. So rib fractures are not just from side contact, it can be from front to back compression as well.
So let's get to what you did in this case. So what did I ask you to do in this case?
Basically, you asked me to evaluate Dr. Bain's biomechanical engineering analysis to see if it was accurate and correct.
And what material did you review? I think you already mentioned you read his transcript and you watched his trial testimony. Is that right?
I did, yes.
And maybe for the jury, in case they need a reminder, he had that green screen in the back of him.
Right, just the talking head.
Exactly. Speaking from Florida, I think.
That's right.
Right. And so let's just start with his analysis. Do you agree with it?
I do not. I do not agree with his analysis.
And maybe before we explain why, just give us a sense of what you understand his method and analysis to be.
Sure. As I've gone through what he testified to in his deposition and the trial, looking at his calculations and what he's done, to me, there's two parts to his analysis. The first is calculations to show that Miss Paltrow had to land on Mr. Sanderson in order to get the rib fractures that he got. And then there was a second part that basically said, because Miss Paltrow had to land on Mr. Sanderson, that could only happen with Miss Paltrow hitting him from behind. It couldn't happen any other way. It was impossible. So that's my understanding of the kind of the two parts, the main parts.
Thank you. We'll go over those in more detail. As you looked at his analysis, you read everything that he read, correct?
I did.
And did you read even more than that?
I had additional depositions, that's correct.
Of the various people that were at the scene of the accident?
That's right.
So let's get one thing out of the way. Do you agree with Dr. Bain that Mr. Sanderson's rib fractures did not occur during the initial skier-to-skier contact?
Yes, I think that's correct. There's no disagreement at this point, at least from the testimony I've heard. The skier-skier portion where they first contact, no matter which version we have, did not create the rib fractures. I don't think anyone thinks that at this point, so that's good. We agree.
And in terms of just a quick overview before we go into his calculations, which you can explain to the jury, do you believe that Ms. Paltrow's account, and I should say, are you familiar with her account?
I am.
And you heard her trial testimony?
I did.
And read her deposition? And
Yes.
do you believe her account of the collision is consistent with what you know about biomechanical engineering?
Object. Goes beyond the scope of this expert witness.
It calls for the evaluators.
Well, go your testimony.
Would you please approach the bench? Objections overruled.
Okay, so let's go back to that question. I was asking you, in your opinion, is Ms. Paltrow's account consistent with what you know about biomechanical engineering?
Yes, it is.
And maybe another way to put that is it consistent with the laws of physics?
It's the same question, yes.
Yeah, and
exactly.
Dr. Boehm, the jury heard, talked a lot about Newton's laws and the laws of physics, applying those to the evidence in this case. And again, in your analysis, as you apply them, Ms. Paltrow's account is consistent with those.
Objection lacks foundation.
Overruled?
That's correct. Ms. Paltrow's version, her scenario is consistent with the laws of physics and what we know about biomechanics.
And then the account that Dr. Boehm gave, and that is based on Mr. Ramon's account, is that consistent with the laws of physics?
I do not believe it is, and I can explain as we get into it.
Yes. Okay. Great. We'll explain that. Let's go to Dr. Boehm's calculations, so you can explain to the jury your analysis of those. We have an easel, and as I understand it, you would like to kind of draw so that you can show them what the equations mean. Is that correct?
That's exactly right.
Okay. So I'll grab the easel and then that board.
We can't block the judge. Judge, where do you want this easel?
On the screen?
He's gonna also need to see the screen, so is it okay if we put it right here? Are you gonna be able to see that?
I can't see it, but it's really more important that the jury see it, so I'm fine with that.
Okay. And I think, if it's okay with the judge, you can get off the stand and.
Yes,
Yep.
sure.
And there's your marker. Okay, so I'm going to pull up something that Dr. Boehm pulled up in his deposition. Do you remember seeing these documents? And for the record and for counsel, these are the notes in Exhibit 3 of Dr. Boehm's deposition. Oh, thank you, your officer.
I missed the question there.
Yep, no, you're fine. So I'm just pointing you to.
Before you, these are not admitted exhibits, though.
Yeah, I'm not asking them to be admitted. They were just shown in Dr. Boehm's deposition, so we're showing them here as well.
Okay, but not in his trial testimony.
He's responding to these.
You said deposition.
He also showed it in his trial testimony.
So
Oh,
direct-
trial deposition.
Yeah.
Yep.
I was
Withdrawn.
gonna say direct things to the judge, but
I recall this being flashed
Withdrawn.
during his deposition, or during his trial testimony.
Okay, thank you, Dr. Scher. So you recognize this page?
I do.
And I was just describing it. This was shown in Dr. Boehm's trial testimony, correct?
That's correct.
And he explained that these are his calculations.
That's right.
Okay, and there's another page as well. I think it's the one just before it, correct?
That's correct. This is where he starts the calculations for the ribs. We're concentrating on the ribs here because that's what he says determines how the accident happened. He said the head injury doesn't matter for that. It's only the ribs.
Okay, great. So since I have very little idea what's going on there, and you do, maybe explain to the jury what's going on.
Sure. Can we go to the page before this?
Sure. And maybe if you, it's just a little bit hard to hear.
Sorry, is that better?
Yeah, that's
Okay.
a little better. Yeah, thanks.
So he's using some basic equations for what we call the center of mass to figure out what happens when someone falls to the ground. Center of mass is if you were to balance someone on your finger, the point that you'd hold them at so that they stay balanced. It's usually a little bit below your belly button, kind of midline front to back, midline left to right. And so if you took all the person's weight, all the person's mass, and put it into one point, that would be the point that you're interested in. So that's what Dr. Boehm is doing in these calculations, is he's using that point for Mr. Sanderson. And this first part here, where he has this, that's an equation, x is position. So he's saying there's a certain distance that center of mass falls. And you can see that over here. That's 3.5 feet, or he does it in meters, 1.0668 meters. So center of mass falls to the ground. He's saying that there's no initial falling position, that's fine. No initial falling velocity, v is velocity. And then he has 1/2 acceleration times time squared. And that equation is correct. Acceleration here is the acceleration from gravity. So what he's saying is Mr. Sanderson's fall to the ground for the center of mass from 3.5 feet, which is probably about right, hits the ground within, and he calculates the time, he solves for time, 0.466 seconds. So that's the first part of that, which is great. The problem comes in that he then says the velocity at contact is 1/2 acceleration times time. And that is absolutely wrong. That is not the velocity at contact. The velocity at contact is just the acceleration times time. So he has this extra half. And it was unclear to me why that would be there to start, and I'm not sure why he put that in. But it creates problems for his calculations and his opinions moving forward. If we can go to the next page, I can explain that. So these are his equations. If you remember in his testimony, he said 4,000 newtons. And that's an engineering unit in metric for force. 4,000 newtons is roughly 950 pounds, I think, in English, but newtons is fine. Over 4,000 newtons, you get the rib fractures. So what is this equation here? I'll show you that and then explain why that 1/2 makes a big difference. So that equation there comes from, at first, kinetic energy. We label that as KE, which is equal to 1/2 mass times velocity squared for that center of mass. And then he's saying, okay, Mr. Sanderson, as he hits the ground, has a certain kinetic energy. That energy has to go somewhere. So what happens is a force is applied from the ground to his center of mass, and he decelerates over some distance. So you can see here he has 3 inches written here. That's important. So this kinetic energy has to be taken up by some force over a distance. That's some amount of work. And that will equal the kinetic energy. And then he divides both sides to get the force. The distances cancel on this side. So the force on Mr. Sanderson is 1/2 mass times velocity squared divided by distance. And that's exactly what we have here. We have 1/2 mass, velocity squared, and distance. Now, remember, he's doing this in metric. So that 136, that is in kilograms. That's equal to about 300 pounds. So here he has Ms. Paltrow and Mr. Sanderson's mass put together. So in this fall, he's saying, okay, the kinetic energy of both of them is needed here during contact. But can we go back to page 5? He uses the velocity here, the 2.29, that has the 1/2 in this. So if we go to the next page, yeah. So you can see he's using the wrong velocity. What happens is if you use the wrong velocity in here, let's do Boehm's as, we'll call this wrong. So what you get is 1/2 mass times 1/2 acceleration times time. Oops, that's squared. There we go. Divided by distance, and squared there. Correct is 1/2 mass acceleration times time squared. So that 1/2 goes into this equation. What does that mean? That means that this half gets squared, it becomes 1/4. So the force that Dr. Boehm calculated for this landing was actually 1/4 of the force he should have calculated. He was off by a factor of 4. So it shouldn't be 4,680 newtons. It should be 18,600 and some newtons. Actually, I have it here. 18,678 newtons. So he's off by quite a bit.
And if I may, Dr. Scher, this is obviously all at least new to me and maybe new to some jurors. What in the end is the takeaway there if there's that much of a mistake?
So there's two things. One is if there were 18,000 newtons applied to Mr. Sanderson's chest, we would expect much worse injuries. The biomechanical engineering literature for much less than that has many more rib fractures, internal injuries, all sorts of things. We don't see any of that for Mr. Sanderson. But the real takeaway and the importance in this case is the mass here. So because he does the 1/4, he needs the mass to be 136 kilograms. Now, if you redo the calculations correctly with just Mr. Sanderson's mass, so Mr. Sanderson is about 80.5 kilograms, or roughly 177 pounds, at least according to the medical records. If you do the calculations with the correct equations and only his mass, you get over 4,000 newtons when he lands. Actually, you get 11,056 newtons. So if he were to fall to the snow using Dr. Boehm's calculation method the correct way, then just Mr. Sanderson falling, not Ms. Paltrow involved at all, he could get rib fractures. This is not quite correct overall. Normally we use what's called effective mass, so all of Mr. Sanderson's mass wouldn't go through his chest. Maybe there'd be some force on his legs. If he hit his head, some force on his head. We typically would say maybe 50% of his mass would be appropriate for effective mass. So instead of the 80 kilograms, we would do, and actually I should put over here, this winds up being 11,000 newtons. And if we do the 40 kilograms instead for Mr. Sanderson, so, and that's, and we use the correct equation, we get sorry, I don't do the math in my head, 5,500 newtons, approximately. What this means is Mr. Sanderson can fall to the ground without Ms. Paltrow landing on him and sustain the rib fractures according to Dr. Boehm's calculation method. So if done correctly, he cannot say his opinion that Ms. Paltrow had to land on Mr. Sanderson to get the rib fractures, which means that this goes through the rest of his analysis. So the rest of his analysis is wrong. So this is really critical, that 1/2 that he did for the velocity, the wrong velocity, really threw the rest of his analysis into question.
So Dr. Scher, there's a lot more we could say about the calculations, I'm sure, and you would approach it differently than he did, correct?
That's correct.
But given the way he did it, if he did it correctly, you're saying that the conclusions that he came to are inconsistent with his opinion.
That's correct. Yes,
okay.
Exactly.
Okay, so, yeah. Okay, doctor, let's talk about skier collisions. You've, as you explained earlier, done research to understand what forces are like on the ski slope. In this case, how would you apply what you know about physics to understand the claims about the ski collision?
Sure. I would apply Newton's laws to the contacts, the different versions of the events, and see what makes sense, how it would unfold. Do the physics of the contact that's being testified to make sense? Is it self-consistent?
And this may be another opportunity to draw some pictures if you need to, so feel free to if it will help you. But you were talking about the center of mass earlier. How does that concept factor into how you would evaluate the evidence in this case?
Sure, yeah, if it's okay to draw again.
You may.
Thank you.
And I can see what you're drawing through the monitor here, so.
Oh, nice, perfect.
Great. And if you need more board or pages, we have them now. Is that correct?
I think we're okay with distance, right?
Okay, yeah, great. Go ahead.
So the thing to know with Newton's laws, force equals mass times acceleration, if you have some, and I'm going to draw two versions of a skier, and I'm not the best Pictionary player. I'm going to draw a top-down version, and I'll draw a side version. So let's start with the top-down. So if we have a skier, and here's the skier's head, and here's the skier's nose, and then we have two skis. The center of mass would be, as we mentioned, looking down somewhere around here. Now, if you have a force that goes through the center of mass, so let's say the force goes through, then the person will accelerate in this direction. They'll accelerate along the line of the force. But what happens when you have a force that doesn't go through the center of mass, it'll create an acceleration going in that same direction, but it'll also, there's a distance here, it'll also create a torque, which is equal to the force times the distance, that will cause the person to rotate. And that's really important because if the force does not go through the center of mass, there's always a rotation. So if you're hit on this looking down, this would be the right side, then the person's going to rotate counterclockwise in this image. The same thing is true if we look at a skier from the side. So if here we have our skier, and here's their pelvis and center of mass. That's our ski boot. And if the person, for example, has a force applied below their center of mass, then there's, again, some distance. That's going to create a torque and a backward rotation so that the person moves backward and falls back. There's two things to note with this for skiing in particular that's different than most other events. Skis have releasable bindings. So if I'm looking at this side view, the boot is held in by a heel piece and a toe piece. And so if you have someone pitching forward, if the ski slows and the person's center of mass moves forward, it'll create a torque on the boot and it'll release heel of the boot. And for someone of Miss Paltrow's size, that could be anywhere from, well, it's approximately 143 foot-pounds, so 143 pounds acting over a foot. Same thing is true for the top-down view. If we look at the toe piece for the binding, if there's a torque on the ski, a twisting torque, the ski will also release from the boot. And for someone of Miss Paltrow's size, it's about 37 foot-pounds. So in front of the boot, if there's 37 pounds 1 foot ahead, it'll release. If it's 2 feet ahead, it's half that value, so roughly 17. So these are the principles that we need to understand the mechanics of an impact and a fall.
So when we apply those principles to this case, what conclusions do you draw?
Sure. The first is that Miss Paltrow's version of events is consistent with the laws of physics and how people move and rotate.
And what about Mr. Ramon's version?
For Mr. Ramon's version, I couldn't get it to work. It doesn't match with the laws of physics. The complete part of his testimony just doesn't fit.
And so can you explain why it doesn't fit?
Sure. So Mr. Ramon's version, maybe I should sit down.
Oh, sure, yeah, go ahead.
So in Mr. Ramon's version, he says that he sees Miss Paltrow contact Mr. Sanderson squarely in the back. And he says that it's in the middle. It couldn't be any more in the middle than if he tried, or if she tried. And then also that she rode him down. I think the quote was something like, in his deposition, he says, like she couldn't have been on his back any more than if he had strapped her to his back, something like that. So as they're going down in Mr. Ramon's version, Mr. Sanderson goes spread eagle, arms out, legs out, and the key for me is that Mr. Ramon says that the inside edges of those skis that are going into this V catch, and Mr. Sanderson stops on a dime. And if that were the case, then Miss Paltrow would keep moving, and, well, maybe I should draw.
Sure, go ahead if it will help.
Yeah, I think so. Okay, so I'm going to try to draw a top-down version of this. So if we have Mr. Sanderson, and here are his skis. And then I'm going to use a different color for Miss Paltrow. How about blue? Miss Paltrow contacts him from the back. And now, this is the same whether one ski is between his or both skis. If the skis are apart, it's a little bit different, so we can get to that in a minute. But if her skis are between his, let's just say, then when he falls, and here is his, so they're moving in this direction. That was probably obvious, but I want to make sure that was clear. So now we're still looking down. Here's Mr. Sanderson's back. Here's his head. Here's one arm. Here's another arm. Here's one leg, the other leg. Now, remember Mr. Ramon says that his skis are in a V, spread eagle. So now, if that were to happen, then he stops very quickly, and Miss Paltrow is going to remain in contact somewhere around here, and her skis are going to stay underneath Mr. Sanderson. When that happens, it's like the center of mass continuing to move forward while the skis slow rapidly, which creates an upward force at that heel. It's going to create a heel release. But as you heard in the testimony, all the skis were on. It doesn't work. It takes actually very little force for this to release, the heel piece to release, in a scenario like this. So it doesn't match with physics. And it's the same way whether one ski or both skis are in between.
Okay, so how do you know this, especially about the bindings releasing? How are you confident about that?
My experience, I mean, I've seen tons of binding releases. I know how bindings work. It's just physics.
Right, and you've specifically done research on binding releasing.
Oh, yes, yes.
And you said earlier that there were other scenarios, the skis maybe between Mr. Sanderson's skis, maybe they're diagonal. Did you do evaluation of all those sort of scenarios, and did any of those work?
No, I couldn't get any of them to work. So the key is either she would come out of the bindings or she would be stuck on Mr. Sanderson. She wouldn't be able to move past him. If her skis stayed on in various versions of this, I don't know how she continues to move downhill the 10 feet that Mr. Ramon said she wound up if her skis are trapped underneath him.
And would you expect her to get an injury in any of these scenarios?
Well, certainly there's that potential, yes, a lower extremity injury for sure.
If, for example, her legs get stuck in one of the scenarios you mentioned.
Right. So, for example, if her ski is rotated out to the side going in that V with one of his skis, the other, whether it's on the outside or in the inside, can't wind up. So if her ski is on the outside, his ski is going to push her ski out. If this is her ski, as he's falling and moving into that V configuration, it's going to go from this position to here, and it's going to push her ski outward, which I would expect would create a toe release, a twisting release of the bindings, because it actually takes about 18 pounds of force, between 15 and 20, depending on how her bindings would be set. So very little force to release that toe piece. But even if it didn't release, then her ski winds up getting trapped by his, and she can't move forward. So, and in many of these scenarios, her leg would get twisted in a really odd way that would likely create injuries.
Okay, great. I think you can sit down again. And now what I'd like to do is ask you about whether you were involved in creating any animations that would help the jury understand your opinions in this case.
Yes.
And, Your Honor, if I may ask for permission to show the witness these animations so that I can lay some foundation, he can use them to teach the jury.
Yeah, we reserve our same objections on these animations, Your Honor.
Understood.
Restarting.
It's been plugged in, but it's now.
We're going a little over an hour. Why don't we take a recess while they straighten out the technology, and then we'll be back. You can step down, whatever you need to do. Thank you. Everything working now?
Yeah, sorry, that we had plugged it in before, somehow it got unplugged, so it's out of batteries.
Okay.
Dr. Sure is using the restroom.
Okay.
Back shortly.
All right. Why don't you go ahead and have the jury come in? Dr. Scher, you can take the stand. We're just waiting for the jury. Are you?
Loud enough?
Yes. Yeah, she's monitoring the audio.
Yes, you sound, yes, your audio's coming through.
Okay.
Thank you, Mr. Egan. You may proceed.
Yes, thank you, Your Honor. May I approach to show the witness the animation?
You may.
So this animation is number 5, correct?
It is.
It's called Close Up, and I'm going to play it for you. Is this one of the animations that you helped prepare?
Oh, sorry, Counselor. I just see it again.
Sure.
Which number is it?
Number 5. It's called Close Up. And it's 22 seconds. So again, Mr. Scher, Dr. Scher, you're maybe explain to the jury your involvement in creating this animation.
Sure, I worked with Brian Brill at Mountain Graphics on the impact and fall portion of this animation, it's not meant to represent exactly what happened, but generally the idea of one of the family of ways this could happen in Miss Paltrow's version. We don't know some of the exact details of how they contacted, how long they interacted, but it gives an illustration of what I'm thinking, my understanding of her version, where they she's contacted from behind and then fall to the right.
And does the animation make certain assumptions about various facts and testimony in the record in this case?
Yes, it does.
Okay, and you can explain those to the jury as we go through it.
Sure, yeah.
And the animation will help you explain what you said earlier about biomechanics, applying biomechanics to this case.
Right, exactly.
Okay, some permission to publish this to the jury, Your Honor?
We assert our ongoing objection to the animations or cartoons. They lack foundation, distort the reality, and are incomplete.
So animation number 5 is received for demonstrative purposes only to help this witness explain his testimony.
Thank you, Your Honor. So, Dr. Scher, I'm gonna let you take the reins here and use it as you need to explain, okay?
Thank you.
Is that all right?
Your Honor, we also object to the extent that this witness hasn't testified to any of the placement of any of the other skiers or bodies in this animation.
Mr. Egan, is that relevant to this witness's testimony of the other skiers?
No, he's gonna talk about the collision itself.
So you should ignore any of the other skiers that are shown in the animation.
Okay, so you can reverse it, Dr. Scher, to just before the collision, so we can focus on that and explain what you mean to show by this animation.
Maybe I can't. How do you?
You could press play again, and it will get to.
Oh, here we go.
Okay, there you go.
Yeah.
Okay, great. So, take us through, if you would, Dr. Scher, what this animation shows from your point of view as a biomechanics expert.
Sure. The first thing that you should be aware of is that this is Miss Paltrow's version of the events. So,
Dr. Scher, sorry to interrupt you.
Oh.
Just maybe pull your mic.
Sorry,
Yeah,
sorry
there
about
you
that. The first thing to be aware of is this is Miss Paltrow's version of the events. So that's what we're showing here. And as we move forward, I'll talk about the physics, kind of like what I drew earlier with the center of mass and the rotation, and that's the idea. That's what went into this. But again, this is not exactly what happened. This is just one of the possible ways it could have happened. So we have Miss Paltrow in black, Mr. Sanderson in the blue as they move forward in time. It's her testimony that his skis slid between hers. There we go. She felt a contact directly in the back, along her back. It sounded like her buttocks as well. The person was grunting, pressing against her, but they were on their skis for a period of time. If in this situation he's also moving to skier's right, which is in the left in this image, that will create, remember I had the force that was offset from the center of mass. That's going to create a rightward motion for her, but also create some initial rotation. Now, in this portion, there's a number of possibilities. She could be adding weight to her right ski because of the contact from Mr. Sanderson. When you ski, if you're in, let's just take a snowplow or what my kids call pizza position. If you weight the right ski, you turn left. So if she weights the right ski here more because of the contact, she's going to turn counterclockwise. The contact from Mr. Sanderson, if it's more to the right, will turn her counterclockwise. So as they're moving to the right here, there would be some counterclockwise rotation, and here her ski can catch, or she could pitch to the side, or they could both pitch to the side, they could both lose balance. We're not sure what happens, but as they're rotating, they're continuing to fall, and Miss Paltrow's version has them spooning essentially as they're coming down together, which would make sense if their legs got caught up. If he was contacting her below her center of mass, where his right leg was contacting her right leg, her thigh in that area. Also consistent with Miss Paltrow saying that her right knee was splayed open at the end, and she felt right knee discomfort. That all could happen there. So as she's rotating and he's rotating counterclockwise, they fall to the side. Now, at this point here in the animation, I guess maybe the next frame, if I can do it. Mr. Sanderson lands on his right side, maybe the right back. It's hard to say. If he lands on his right side, kind of like Dr. Bayham said, he needs to land on the elbow, that can happen. That can create lateral rib fractures. But that's not the only way. His arm could be out. He could land on the side and create lateral rib fractures. He could land on his side and a little bit towards the back, and Miss Paltrow could land on him. She could be fully on him, maybe with her buttocks or her back or some portion of her mass compresses his chest front to back, and that can create his rib fractures. There's a lot of different ways this could happen. I can't tell which one of those is right, but all of those are consistent with her version of the events. As they hit the snow, they would continue to move forward until friction slows them down. And it's also important to note, we haven't talked about the head injury, but hitting the back of the head or the side of the head, he could have his head turned. All of those are possibilities for him to contact his head on the snow. So that's not inconsistent as well.
Would it be helpful to show it in real time? You've been doing it kind of slow motion, which has
Sure.
also been very helpful. Maybe start from the beginning and just play it.
Objection lacks foundation for trajectory, speed, and direction.
Overruled. It's demonstrative of this witness's testimony only.
All right, thank you.
Okay,
Sorry, yeah, go ahead, Dr.
this
Schultz.
is from the beginning.
And if there's anything you want to comment on as it happens, feel free.
I think that accurately reflects the version that Ms. Paltrow testified to that matches the laws of physics and biomechanics as I understand them.
And would it be helpful to show, there's one other animation that has a little zoom in from the other angle. Would that also be helpful?
I think, yeah, it can't
Okay,
hurt.
let's show that then. Permission to approach, Your Honor, for that.
Okay. What's the number of this animation?
This will be number 4. It's called Zoomed Inside.
What was the last one, James?
Number 5. Oh, sorry. Yeah, thanks. Okay.
Wait just a sec.
Okay, Dr. Schur, so I'm playing you number 4, the zoomed in from the side version. Were you a part of creating this version as well?
Yes, this is the same animation but from a different camera view.
Got it. And will this animation also help you explain the same things you've been going over with the jury?
It's the same thing, sure. Yeah, I think it also visualizes, it illustrates my opinion.
Okay. Your Honor, permission to show this animation?
Subject to the same objections by the plaintiffs, the animation 4 zoomed inside is received for demonstrative purposes only.
4.
Okay, thank you, Your Honor. So, Dr. Schur, maybe since we've already gone through this slow motion, let's just play this one from the start, and then you can add anything that you can provide to the jury from this angle?
Sure. Here, let's play first, and then there we go. I'll wait until the contact point. So it's coming up. Here we go. There's contact, fall to the right. This one doesn't show the rotation quite as much, and we don't know the amount of counterclockwise rotation as well. There could be a little, there could be more or less.
Right.
We're not sure.
But if you go backwards a little bit into the moment of the collision, this one maybe shows. Does this one show the skis coming between the skis?
Yes, it does. And I think it's better visualized in this one.
Yeah, and again, what's the significance of that in terms of how the mechanism of the fall occurs?
Well, that's Miss Paltrow's testimony, and it works for the physics of them falling and rotating slightly counterclockwise. Frankly, if it wasn't both skis, if it was one ski between hers, the kinematics would be the same. For example, if his right ski were on the outside of her right ski, it wouldn't change the general kinematics. This is generally, and I keep saying generally because we don't know the exact details of it, this would work.
So if we flipped the positions of the parties, and Mr. Sanderson was in front, Ms. Paltrow came from behind, using this as a good visual for the jury, will you explain your opinions about what you would expect to happen on Mr. Ramon's account, I should say?
Well, Mr. Ramon's account is very different because in Mr. Ramon's account, Mr. Sanderson goes spread eagle and his skis go out into that V and the inside edges catch. And that changes the kinematics, the motion. It's a very different version of what happens with the contact. And
in terms, I guess we've covered that. So maybe we'll wrap up here. You've covered a lot of things, a lot of new things perhaps for members of the jury and those of us in the room. Will you summarize for us what are the main points that you want to get across for the jury here?
Sure. The first is that Dr. Boehm cannot say with any accuracy that Miss Paltrow landed on Mr. Sanderson. His calculations are wrong, and when you look at the equations done properly, Mr. Sanderson can land on the snow and sustain his injuries without Miss Paltrow falling on him.
And if I may, Dr. Schur, was it your understanding that Dr. Boehm's opinion was that his account was the only possible way the injuries could occur?
Yes, Mr. Ramon's version was the only possible way. He said Miss Paltrow's was impossible, which I believe is false. I think Miss Paltrow's version is possible.
Right, and would you say that Miss Paltrow's is the more likely of the two accounts?
Well, considering it's the only one that matches with the physics of what would happen in contact, yes, I think so.
Okay, and I interrupted you. You were going through your main points. What was the next one?
Well, I think we've covered it. The second thing is that Dr. Boehm cannot say that Miss Paltrow's version is impossible. That's absolutely wrong.
It sounds like you're saying, in contrast to Dr. Boehm, that there are various ways this accident could have happened, the injuries could have occurred for Mr. Sanderson. Is that right?
That's correct.
And you've evaluated the various testimony, correct?
I have.
And you've done a careful analysis from a biomechanical engineer's perspective on what different scenarios might be likely or how they would happen, correct?
Correct.
And is it your opinion that Ms. Paltrow's version is the more likely of the two versions that you looked at, Mr. Ramon's and Ms. Paltrow?
Yes, once again, it's the only version out of the two that matches with the laws of physics, the biomechanics of it.
Okay. Anything else you'd like to tell the jury that maybe I interrupted you on and you missed out on?
No, I think we're good.
Okay, thank you. And that's all for now, Your Honor.
Can you keep the screen there?
Sure.
You can turn it off. Well, actually, leave it on for right now.
On or off?
On.
On, okay.
Morning, Mr. Or do you prefer Dr. Schur?
Sure, that works.
Sure, Dr. Schur? Okay. This version right here. Can you back it up about to here on the scroll?
To here?
Yeah, and then go forward it out halfway between the last one. Okay, a little farther. Just before when Mr. Sanderson, who's also
Maybe it's easier if you do it.
well, could you just go a little bit farther forward? Just go slow. I just want to get Mr. Sanderson, who's sometimes called Dr. Sanderson.
Mr. Peter, would you mind putting on the remote that allows you to be picked up?
Okay, how about, can I use this?
Sure. Yeah.
Does that work? Is this working? Oh, wait, now it is. Okay, go a little farther forward, please. Okay, and then when we get, okay. Now, this is Terry Sanderson.
That's Mr. Sanderson, that's right.
Okay. So his right eye is, okay, go a little farther. Now, just another fraction, just a little bit farther. Okay. So, you have his head turned. That's based on your testimony that he is looking down the hill, I guess. Is that what you're saying?
I believe his testimony is that he's looking at a woman who's a little downhill to the left. He notices her, looks at her. I don't remember what the exact words are.
Okay, go a little farther. So his head, his left eye would be looking directly at Miss Paltrow. He would see her, right?
I believe so.
And it's inconsistent with his testimony. He didn't see her at all.
That's correct.
But he would see her there, wouldn't he?
I would think so.
Okay, go a little farther, just another fraction. Okay. Now, in this picture, you don't have Craig Ramon in there. Who, how far above would this point be? Where I just pointed. How many yards would that be above this image right here?
I don't know without doing a measurement, but I'm concentrating on the collision between Mr. Sanderson and Miss Paltrow.
Well, Craig Ramon testifies he was about 30 to 40 feet above. And so these objects are about bent over, maybe 5 feet high. So if we just flop over, 6 bodies, we'd get to 30 feet. That would be about right here.
I'm not sure.
Well, you're an engineer, highly trained PhD. You can't even guesstimate that that would be about 30 feet?
I can't tell.
Would up here be 30 feet? Don't you think it'd be a lot more than 30 feet?
Probably, but I don't know.
Well, you helped create this animation. You don't know the distances in your own animation?
No, I've concentrated on the collision portion. That's the biomechanics portion.
Okay, who did the estimates or guesstimates of the distances of the bodies of the other people?
So that's going to be Mr. Boggart, who's going to be on soon, I assume.
Okay, so this animation doesn't have Craig Ramon in the scene at all?
Not at this point.
Okay. Is it because the defense doesn't want him in the scene, so to discredit his witness account?
Oh, I don't think that's the case at all. You'll have to ask Mr. Boggart.
Okay, we will. Okay, let's see. Just go another little section.
going until you
Yeah,
say
just
stop.
go slow. I just want to go slow motion. Okay. Now stop right there. Now, do you know the time, how much time from the initial, let's say, impact of their bodies to this point would be? You did this calculation. This is your bailiwick. What you're talking about.
Do you mean in the animation, or do you mean in real life?
Right now. Yeah. Yeah, from the impact to this point, approximately. Is it like a fourth of a second, a half a second, a tenth of a second? Do you?
Ms. Paltrow says that they're in contact for a little while, a few seconds before they fall over. So I don't know what it is in particular in this animation, if that's what you're asking.
So you helped design this part of the animation, so you don't know how far it is. You just guessed it?
Again, we don't know exact timing and distance. This represents an illustration of the version. So, yeah, it is what it is.
It's an illustration of the version, but there could be wide variability in that version, right?
There is variability, but we have constraints on it.
The constraints are, it could have happened the opposite way, right?
The opposite way.
Ms. Paltrow hit Terry Sanderson.
No, I don't think so. Not with the testimony that's given. We have two versions. We have Mr. Ramon's version, and we have Ms. Paltrow's version. This is Ms. Paltrow's version. Mr. Ramon's version is very different.
Okay. Let's talk about that for a second. You're being paid, excuse me, you're being paid, what is it, $4.25 an hour for this?
No,
Is it more than $4.25 an hour?
it is.
$4.50 an hour?
Nope.
500?
It's 500 an hour.
500 an hour. And you billed something over $10,000 so far for your work?
That sounds about right.
More than 15,000?
No, I don't think so.
So between 10 and 15,000. Okay. You can turn that off for right now.
I'll just take it.
I think that's probably better.
No, please leave it there.
Oh.
I may come back to it.
What's the best way to, do I just disconnect it? Is that
Yeah, maybe just disconnect.
like that? Okay.
No, you're here to teach the jury, right? The defendant's version, correct?
Teach the jury the physics that would be helpful in understanding how to assess the accident.
So that's a no. You're not teaching the defendant's version.
I'm not teaching any version. I'm teaching the physics and mechanical engineering, biomechanical engineering that would help the jury.
I know it's hard for expert witnesses to say yes or no, but are you teaching the defendant's version?
I guess I don't understand the question.
Okay. Seemed like a simple question. Next, I'd like to talk about, did you review Dr. Gibby's testimony at trial?
No, but I did see some of his trial testimony.
All of it or some of it?
Some of it.
Was it more than 10 minutes?
Probably, yeah.
More than 20 minutes?
Yeah.
More than an hour?
I don't think more than an hour.
Okay. You didn't disclose anything about hearing Dr. Gibby's testimony?
I'm not sure what you mean, but I did see it.
Okay. You've never disclosed to the plaintiff your reports or your testimony ahead of this trial, correct?
Your Honor, may we approach?
Yes.
Are you an expert on broken ribs?
I am comfortable talking about the biomechanics related to rib fractures.
Have you done any papers or studies or research on ribs and rib fractures?
Me personally, no, but I've read the biomechanical and engineering literature relevant to them.
Okay. You haven't mentioned that biomechanical literature in specifics, correct?
I'm not sure about in specifics, but I think we mentioned it on direct.
Okay. So you said that Dr. Sanderson, or I'm just going to call him Terry. Terry was 70 years old at the time of this crash?
It was 69, but effectively 70 for biomechanics purposes.
Effectively because 70 is older?
No, because there's actually good information in the biomechanical engineering literature about the amount of chest compression required to create rib fractures for 70-year-olds.
And not 69-year-olds?
Well, it's actually the full distribution, but the paper that I'm thinking of from Agnew specifically talks about 70-year-olds.
You didn't mention that paper today?
No, but would you like it?
Not right now, thanks. I've not seen it. Let's see. Well, I'm going to go right to another point. You have this theory of rotation, correct? That the version you're calling Ms. Paltrow's version is a kind of a rotation version?
There is some rotation. It may be a little. It might be more than a little. We don't know.
Okay, so we don't know how much rotation there is, correct?
Sure.
Okay. I'd like to, well, let me see if this thing works. It didn't work last time. Guess it's working now. May we take a picture of this?
I think you've already done it.
Okay.
Or someone on your team has.
Okay, good. May I borrow a pen?
Your Honor, we would object to him writing on the witness's board.
It's not an exhibit. It's certainly fair game.
Okay.
So,
Well,
Doctor-
can we mark it as an exhibit, Your Honor?
Why don't you take a picture of it and you can use that, and then he can
Go ahead,
add,
take a
he can
picture.
add to it.
I
Okay.
mean, it is our board.
right, and in academic
We
fields,
don't have any questions right now, so.
in academic fields, it's common that people write on each other's drawings, correct?
I don't know that I've seen that, but I don't have a problem with you drawing.
Okay. So, you testified that Craig Ramon says Terry was hit directly in the back, and they went down, and Craig Ramon was somewhere above, 30 to 40 feet, and it happened in a fraction of a second, correct?
Yes, the fall, I would agree with that.
Okay, less than a second.
Sure.
Okay. So there was a scream. So and the scream occurred, and there was within a fraction of a second. And I don't believe Craig Ramon never testified where Miss Paltrow's skis were.
Correct.
So her skis could have been going underneath Terry, like this. So the pink ones would be Miss Paltrow's skis. Is that a version that is possible?
It is not.
It's you're saying it's not possible.
That is not possible with the version that Mr. Ramon states.
His version didn't talk about her skis. Now, here, I'll draw what her body, pink would be her body, still square in the back. Isn't that possible?
So, no, with Mr. Ramon's version, if I may, that is not possible. So, in this situation here, when Mr. Sanderson's skis go into a V, and I guess you're saying her skis are under his skis, which I'm not sure how that happens because the tips curve up, but we'll go with it. Somehow, she winds up in this situation getting caught with her left ski around Mr. Sanderson, and she would not continue past 5 to 10 feet, and I would expect a twisting release of her left ski.
Well, that's her version. I'm talking about Mr. Ramon's version.
No. I'm talking about what you just drew for Mr. Ramon's version.
Mr. Ramon's version, well, isn't it possible her skis could be pointing straight like this? And let me get it right here. So, yeah, so she could be going straight, and she could be turning left and up and hit square in the back, but her skis are pointed this way. Isn't that another version?
So for her skis to miss... Oh, no, it's not. Do you want me to explain?
In a second. I'm asking the questions here. So, so are you saying that her body could not be turned while her skis are going in one direction, or she's turning up to the left? Is that possible?
Not for Mr. Ramon's version. Is it possible in general? Sure. But in her version, I'm sorry, in his version, no.
This happened in a fraction of a second. I don't think Mr. Ramon testified that he has a videographic or photographic memory. Do you?
Well, he's pretty particular in his testimony about how she was on Mr. Sanderson's back.
Right, and he could, you see the circle I have? Let's see, well, actually, maybe I could do it I've got it wrong. Let's do it the other way. Her body could be like this, and her skis could be like this, too. And people turn all the time while they're skiing, and their skis are going one direction, but their body is pointed a different. Right here. Can you see me? You see that?
I see you turning, sure.
That's possible, right?
What you're doing in general is possible. Are you asking, does that match with Mr. Ramon's testimony? No, and I'm happy to explain why.
I think Mr. Ramon's testimony is, it happens in a fraction of a second. Mr. Ramon, a professional wannabe freestyle skier, likes to talk about ski angles, but the main part is the body. He saw the body, and then the bodies go down together, and she lands on top of him. You're saying that your versions, which you are not based on anything except your recreation of the biomechanics, are superior to an eyewitness. Isn't that what you're saying?
No, we have two versions of the accident. We have Mr. Ramon's version, and we have Ms. Paltrow's version. I have assessed both using physics and biomechanics, and I'm sorry to say Mr. Ramon's version does not meet with the laws of physics. It's not consistent, internally consistent, and Ms. Paltrow's is.
Well, I don't think Mr. Ramon's version was designed to be consistent with the version of events. It happened in less than a second, and we don't know the direction of the skis. In his version, he never testified to the direction of Ms. Paltrow's skis in any of his testimony. Isn't that true?
He did not testify to the direction of her skis. That's true.
Thank you. So, if Ms. Paltrow was seen down, turning up to the left, she hits Terry Sanderson square in the back, and they can fall down to the right, especially if her momentum going, well, you know, I'm not a biomechanical engineer. I'll try to do it right here. It could be her shoulder that hits him square in the back, couldn't it? He didn't say what part of Miss Paltrow's body hit Mr. Sanderson, did he?
He did not say. He said, well, here, I can tell you exactly what he said. He said,
Take your time.
he said squarely in the back. She couldn't have hit him in the back any better right in the middle than if she tried, and she couldn't have been back on his back any more than if he would have strapped her on the back, like a backpack.
Okay, but that doesn't mean her body was straight.
Might not be exactly straight.
Yeah, it could be off center, because she was skiing down. She's like this, and she hits him right in the back. Or maybe it was a little off center because Mr. Ramon only had the view for a few seconds. And then her arms wrap around, her arms could have wrapped around Terry Sanderson, right?
I don't think there's any testimony about that. Is it possible? Maybe, but
Well,
I don't
where
think
would
there's
they have
testimony.
gone? Down to the side? She went in like this?
In front of her?
I mean, the most likely, don't skiers ski like this usually?
Often.
Often? What are the other positions?
They can have her arms in more,
Okay,
and have them out more,
so she could be like
have her arms
this
down
and
to her
turn like
side,
this.
and the poles heading back.
Okay.
There's all sorts of options.
So in that fraction of a second, Mr. Ramon saw the collision. The screen was up here. He turns his head, and she could hit him square in the back. She could have her, at that point, her body could have turned and possibly hit her, but the point is the skis could have been going at a different angle, one or the other, and still cause this crash. And your versions assume those are not possible because you assume that there's only one way, that their skis were going parallel to each other. This is your only assumption, right?
Wrong.
You made assumptions that these are possible?
I looked at other angles, that's right.
And the testimony, though, you said there's no testimony about the angle of her skis from Mr. Ramon, correct?
That's true.
You've made a lot of assumptions, correct, to make these animations, right?
Yes and no.
I thought that would be more than one assumption.
There are
That's
some
a yes or no?
assumptions. Sure, more than one assumption.
Okay. Less than 100?
Sure.
Less than 10?
I don't know.
You don't know how many assumptions you've made, correct?
That's right. Sure.
Okay. Now, I know Council, Mr. Owens likes to do this a lot, like it's a touchdown, but on redirect, Mr. Ramon, did you see all of his testimony for this trial?
I don't know if I saw all of it, but certainly I saw a lot of it.
Okay. You saw the testimony last week, correct?
Is there any more than that?
There was a little bit yesterday.
Okay, I didn't see anything
Had nothing to
yesterday. I
do
was
with this.
traveling.
Had to do with that Mr. Ramon reported what he saw the same day and the same week 7 years ago. And you're recreating this, what, about 5 months ago, correct?
I don't remember when it was.
Less than a year ago.
I don't recall.
You don't recall when you consulted with Mr. Brill and made the animation?
This has been ongoing for a while. This case has been dragging on, so I don't know when it was.
So you've been working on this for, let's say, more than 8 months?
Sure.
You don't know?
Certainly we've been in contact with counsel for longer than 8 months.
For the record, Your Honor, I'd like to move to strike all of his testimony because this wasn't disclosed improperly. I anticipate the ruling, but I just want to, for the record, make the ruling.
It's overruled. It was disclosed properly, counsel.
Okay. What I'd like to do is understand that you've made a lot of assumptions, and the jury would like to know how reliable your opinions are. So how can that be reliable when you totally discount some major events like what the direction of Miss Paltrow's body was compared to her skis? And there is testimony about Miss Paltrow's body movement. Do you know that?
I guess I don't understand.
Prior to the crash? Just prior to the crash?
What version are you talking about? I don't know what you're talking about, sorry.
Do you know about the version of Carrie Oakes?
I don't think she saw the accident.
Have you read her deposition?
I have.
Okay. You realize she testified that one of the kids said, "Mommy, watch us ski," and the kids were up there on the left. Miss Paltrow was down on the right, which would tend to show that Miss Paltrow was looking up to her left at the point of collision?
I don't recall that.
Okay. So you're excluding Carrie Oakes' testimony, correct?
That's wrong.
You're including her testimony?
I considered it, sure.
And are there any assumptions you've made based on her testimony?
Not in particular that I can think of, but there may be.
So could you speak up?
Not in particular that I can think of.
Okay. Not particularly that you can think of about Carrie Oakes' testimony, okay? Are you an expert on head injuries?
I'm comfortable talking about head injuries from the biomechanics standpoint.
Have you ever studied or held yourself out as an expert on concussion?
If it's diagnosing or treating concussion, no. If it's the biomechanics related to the formation of concussion, yes, I've done helmet research and head injury research, in particular for snow sports.
Did you apply any of your knowledge about concussion to this case?
I certainly looked at it, but Dr. Boehm was very particular in his testimony that it was only the rib fractures that allowed him to say that Ms. Paltrow contacted Mr. Sanderson from behind. So that's what I concentrated on for the jury.
And you ignored his discussion about the head injury?
Oh no, I certainly considered it.
And it's not relevant in this case?
Well, in disproving Dr. Boehm, it's not relevant, but I'm happy to talk about it.
Okay. Well, it's not clear you disproved Dr. Boehm when you don't even know the direction of Ms. Paltrow's skis at the beginning of this. It's also, I think, a big assumption to say what the body position of Ms. Paltrow was when she hit Terry Sanderson in the back.
Sustained, and I don't, was there a question in there, counsel?
Just if that was accurate, I'll withdraw it. So you've never studied rib injuries. Have you ever testified about rib injuries before?
Could you clarify what the question is?
Have you ever studied rib injuries and testified about them in the past?
That sounds like two questions.
Have you ever testified about rib injuries in the past?
I don't recall, but it's
Okay.
likely.
Most likely you have?
I think so.
How many?
They're
have you
common.
testified more than 100 times?
In trial, probably 35 times, something in that ballpark.
In total, under oath, have you testified more than 100 times?
Including depositions, yes.
More than, less than 200 times?
I would agree with that.
Okay. Let me just check. That's all I have for now. Thank you, Dr. Scher.
Thank you.
Thank you, Mr. Bueller. Mr. Egan?
Thank you, Your Honor. Dr. Scher, we'll just be real quick here. Did anything Mr. Bueller asked you change your opinion that Ms. Paltrow's account is consistent with the laws of physics to your understanding and Mr. Ramone's is not?
That remains the same.
Thanks.
Mr. Bueller?
Just, I think you said this before, that you're an expert in the laws of physics, but you're not an expert in medical medicine or orthopedics or neurology, correct?
I am a biomechanical engineer. I am not a medical doctor. I do not diagnose and treat, but I do look at what forces and what motions create damage to the body.
Thank you.
That's all.
You may step down.
Thank you.
Thank you. May I call your next witness?
We call Paul Bogger, Your Honor.
Thank you.
Your Honor, before Mr. Bogger comes up to testify, we may want to take a 5 or 10-minute break. I want to address something with the court outside the presence of the jury.
We'll have to take one shortly anyway, so let's go ahead and do it now. Ms. Van Orman?
Your Honor, pursuant to our motion in limine, Mr. Bogger's testimony is going to be significantly limited in this case. The problem that I am foreseeing is that, I could be wrong, but it appears to me that counsel is going to try and use Mr. Bogger to then describe some further animations and place individuals on that animation. And I have significant concerns with that for a number of reasons. Number one, Mr. Bogger's not qualified to do that. He didn't take any kind of measurements, calculations, determinations of speed, force, physics, etc. in this case. But in addition, in his report, he does not make any mention of where people were, where they were placed. Any kind of discussion of him talking about the animation, and if he was responsible for putting the people somehow on that animation, he does not describe that in his report. He doesn't talk that in his report regarding participating in an animation. He provides no diagrams in his report, no discussions of where people were or weren't. So I don't think that it would be appropriate for him to even deal with the animation, or that his testimony that he's the one that was responsible for putting, say, Apple here and Moses here and that type of thing. That would go significantly beyond anything he did in his report. So that's my concern, and I wanted to address that now rather than a sidebar.
Okay, thank you.
Your Honor, may I quick take a photo of this?
Sure. Mr. Egan?
Yes, Your Honor. So I think our response would be that Mr. Bogger has poured over the records in this case, and he has, in producing these animations, made certain assumptions about what testimony might be consistent with the illustration that the animations provide. He can be very clear with the jury that he's assuming certain facts. He's not finding these facts. He's assuming that they're true. They come from the record. He can explain that they're rough illustrations. He's not made measurements and decided that, yes, this is exactly 30 feet. he can be subject to cross-examination on any point that might be inconsistent with testimony. He can explain that he chose to assume these facts and not other facts, and that if you assumed other facts, you might get different illustration. And then he'll explain that the assumption of various facts that are shown in the animations are consistent with his understanding of ski collisions and skiing generally, which he has decades of experience, not just with skiing himself, but with investigating accidents, collisions, hundreds and hundreds of them for various purposes, mostly not litigation, mostly to figure out risk management concerns, deciding whether certain skiers have to be banned from a certain resort or a ski area. He has ample experience to be able to discuss how to consider various factors in evaluating a ski collision like this that has complex testimony that's not all consistent. And the jury, in our view, needs to hear from a ski expert that knows how to do that and can explain to them the principles that he uses. He will not tell the jury this is likely what happened, or that I have found that this must be the case. He'll say, I've assumed these facts. He can be very clear about what he's assumed, and then use that animation to explain to the jury how to think through the case, given his ample experience with evaluating ski collisions.
So, Mr. Egan, I guess I'm still not hearing an expert opinion from Mr. Bogger, is it? Mm-hmm. That would have helped the jury. I mean, everything that I'm hearing has him weighing evidence, has him making decisions about what may have happened on that day, and that's invading the providence of the jury. It's not really going to help them.
Your Honor, I see it as, like, say, a medical malpractice case, which I'm more familiar with. If a certain set of facts might be in the record about what happened in a surgery, for example, then a surgeon, expert surgeon who has lots of experience reviewing records, but also doing the surgery himself, knowing what the training is, looks at the records, looks at the various claims, and you, as you said in your order ruling, I believe, yesterday, can say, if we assume these facts, given my expertise, I can say this makes sense, or this is consistent with my understanding of surgery. And so my proposal is that we use Mr. Bogger in that sort of way, where he can help the jury understand, given what he knows about skiing and given what he's seen in the record, that there are certain principles you can use if you assume certain facts to evaluate a certain collision, such that you're applying some rational principles rather than just generally going with a certain gestalt feeling about what someone said. You're actually trying to rationally go through how to evaluate a ski collision, which again, he has decades and decades of experience doing. And he won't say, he'll say to the jury, you're the ones that have to decide what happened. This is a very difficult case to decide.
Isn't your medical malpractice expert example, isn't that an expert that's coming in to evaluate whether the standard of care was breached?
Yeah, well, so yes, usually we would offer an expert in that way, but given your ruling, I'm just trying to use that as an analogy where we could still use expertise that would help the jury without rendering that final opinion, telling them, as an expert, you should do this, and I'm really the one that knows because I have tons of experience. Instead, he can say, here's how I evaluate these accidents, and let me show you how to do it. And then they have rational principles that come from his field of skiing and ski accident evaluation that help them, that they haven't heard from any ski expert that has provided to them that kind of a rational layout for analyzing the various complex
I guess, preliminary ruling on this witness the other day, yesterday. I'm losing track of the days here.
Me too.
I think I stated that he is qualified, certainly has qualifications, and can testify as to what a reasonable skier would do or not do in a certain hypothetical set of facts. But in terms of applying and weighing the evidence in this case, I think that goes too far.
Okay, so, but if we showed the animation and we made it clear to the jury that we're assuming certain facts, we're not weighing them. We're just saying, look, let's take these facts. We're assuming them. We're not saying that they're proven. We're just showing you how to analyze the facts, assuming these various parts of the testimony are true. That would be too far, you're saying?
That sounds like closing argument. It doesn't sound like what a witness can offer under Rule 702. He can talk about, I mean, he's an expert in skiing. He can talk about skiing dynamics. He can explain what a snowplow is, what parallel skiing is, what the rules of skiing are generally understood to be. But in terms of taking that next leap, I don't think he can say, I've looked at the deposition testimony and I can tell you who's at fault here, or I can tell you who did something wrong here. I just don't see, I think that's the jury's responsibility, and I don't want a witness telling the jury how to make its decisions or how to make a decision that's either an ultimate issue or one of the issues leading up to that ultimate issue.
So even him explaining his process for how to evaluate ski collisions would be too far?
To what end? Why does the jury need to know how he evaluates a ski collision?
Because evaluating ski collisions is a complex matter and he has expertise as to how to do that.
Yeah, you know, right now I'm just talking in a, or I'm responding to your question sort of in a vacuum. I don't know what it is he's offering.
If it would help, I could give you kind of an example. Like,
Sure.
If I could say, Mr. Bogger, when you evaluate ski collisions, and you've evaluated, you know, have established that he's evaluated hundreds of ski collisions. Have you ever evaluated collisions where there's conflicting testimony? Yes. When you approach that testimony, what are principles you use to evaluate that? And he can explain those principles. He doesn't have to talk about the facts of this case. He can explain, here are these principles. I don't think the jury's heard that. I think it would be helpful to them. I think it would be rational and it wouldn't be overbearing.
You're asking him how he evaluates credibility.
I guess that's true.
How does he reconcile different accounts?
Right, but we wouldn't, if given your ruling, we wouldn't go into applying it to this case. We would just give them the rational principles that would help them weigh the evidence. It wouldn't tell them how to do it. It would just give them a framework for doing it, which only he can provide. They have not heard from somebody that does this for a living, has done it, again,
And how does that vary from what the jury does? If you look at the credibility jury instruction that I've already read, for example, and how does that differ? I mean, where it talks about conflicting testimony, how does what he's offering provide any specialized knowledge? I consider that generalized knowledge.
Yeah, so I don't think he would just talk about, general principles of evaluating witnesses. He would talk about particular aspects of a ski slope or witnesses on a. If he were here right now, he could help me.
He is right here.
Yeah, right. He is right here.
So when ski accidents happen and people go to the ground, their skis get released. I could see that as specialized knowledge, just
Right.
like this witness offered something along those lines.
Yeah, no, that is an important thing. He can explain.
But in terms of this skier said such and such, and this skier said such and such, but this is how I evaluate that aspect of it. I think that's invading the providence of the jury.
Okay.
On deciding how to weigh testimony.
Okay. I mean, for the record, if I may, Your Honor, would just, I think we put this on before, but in case we didn't, we believe the motion to exclude Dr. Bogger or limit his testimony is untimely, and that Greg Skordas, their expert, whose report does much the same thing that Mr. Bogger's report does, should be limited in the same way. Again, just renew our request that he be able to speak to the jury about his evaluation of the ski accident.
So just again, my sort of ultimate conclusion on what I'm hearing on this motion to reconsider and on the response from the defense is that it's up to the jury to decide ultimately what the parties did, where the parties were positioned, and who ran into whom. So it's up for the jury to make those decisions. So as long as this witness steers clear of those areas, that's the main emphasis of my preliminary ruling, and I'll have to hear what's being offered.
Okay. Do you mind, I know I'm not an old man, but my memory has failed me. Those three again, who hit whom going backwards?
It's up to the jury to decide ultimately what the parties did.
Right.
In other words, leading up to, during, and after the accident. It's up for the jury to decide that. And various experts have given them some helpful information, like the biomedical expert gave testimony as to what the biomedical evidence reflected that would help the jury make that decision, just like this past witness gave the jury some biomechanical information that will help the jury make their decision about what happened in that accident, what the parties did, where the parties were positioned, and who ran into whom.
And the reason that you see Mr. Bogger as doing something different than, like, say, Dr. Schur just did, who took the jury through assuming these various facts. I'm not telling you that this account is true. I'm just taking as an assumption what Ms. Paltrow said was true. Let's analyze it. You're seeing Mr. Bogger as different, and I'm not totally sure how. Do you mind explaining that?
The plaintiff's witness applied biomedical principles in a methodical way to the different versions and then handed the jury that information. The biomechanical expert that just testified applied biomechanical principles to the different versions and gave that information to the jury to help them make a decision.
Okay. So
and what I see this witness doing is reading different accounts and reconciling them and wanting to give his reconciliation to the jury, which I think is too close to what the jury actually does. It doesn't help the jury from an expert standpoint.
okay. So it sounds like you're not persuaded that of our position, which is that he has skiing expertise similar to like a biomechanical engineer has, and can apply that to the facts in a way that would provide the jury with some, again, rational scheme to assess the accident that they wouldn't have otherwise.
Under Rule 702.
Right. Okay.
And the same is likely going to hold true to Mr. Scortis' testimony.
Okay. And you say likely.
I've heard you make kind of a motion. I haven't heard from the other side whether they're opposing that in some way.
I see. You're just waiting till you have more specifics.
If he's the same type of an expert, and I realize that he may not be a risk manager and he may not be a ski accident investigator for an employer, but it sounds like his testimony is along the same lines.
Right. Okay. So, just in terms of guidance on this ruling, you mentioned the bindings, and I apologize if we're going long. I just want to make sure that we
specialized knowledge,
right, so
that can help the jury in making their decision.
So in your mind, would something like recognizing that the positioning of the skiers, if one skier is uphill, applying a certain knowledge of skiing, that would suggest certain things about the accident. Would that be out of bounds?
I guess I have to hear the question, but it sounds like you're getting back into making conclusions based on an investigation. If you lay out some hypothetical facts to say if this skier was here and this skier was here, from a skiing standpoint, and then ask questions based on that, I could see that, but
okay.
It's feeling a little too hypothetical right now.
Sure. Okay. Thank you, Your Honor. Thanks for your patience with my questions.
Sure. Ms. Van Orman?
Yeah, just really quickly, circling back to why I raised this in the first place, is the concern with the animation. And so what I don't want, because Mr. Bogger apparently had some involvement in creating the animation, which was not designated in his report, nor was any mention on what his involvement was, what he did for it, how he placed anywhere. There's no discussion of any of that. I don't think that it's appropriate for him to comment on the animation and to say, well, yes, I saw that, this helps me because I'm the one who helped to place these people there. It would have been, again, by reading the depositions and applying, which is what the jury needs to do. So I would say he can't even talk about the animations because that just goes beyond the scope of his report, anything that he's done in the case.
I would agree.
Unless the foundation can be set. I mean,
I haven't heard anything that would establish a foundation.
We have been broadsided, Your Honor. We had a 37-page report produced a long, long time ago. There was a motion deadline that we respected months ago. These issues were argued 45 days ago, and then immediately before our witness is going to take the stand with this 37-page report, we get essentially a midnight filing and that guts half of his opinions. I don't think it's fair, Your Honor. I can't even read the darn thing. I'm focused on getting my witnesses ready. The untimeliness is very prejudicial to us, Your Honor, because we can't properly brief this in days.
Okay. I've already ruled that the initial motion was timely, and I made a ruling on the initial motion. The subsequent motion was not untimely. The court has agreed to reconsider the motion, and that's what I've done. And I don't feel that it's unfair or unduly prejudicial. You were aware of the issues with his report long ago.
But you ruled in our favor before.
What I ruled was that the initial motion didn't give the court enough to grant it.
Because they
And so then there was a
poorly
motion
briefed it.
Then there was a motion to reconsider that gave the court more information, and I can see that it would be, I mean,
You can't poorly brief
you don't want
a
to,
motion.
this would create an appealable issue. Do you want to do that for your client, is my question.
No, but I don't want to. They poorly brief something, the judge denies it. Then right before the testimony, they better brief it, and now we lose. I mean,
That's what trial is. This is trial. Things happen. The points that were raised in the motion are valid points. They're sound. They're based soundly in the law, and I want to make sure that what the jury hears is sound and not subject to any more risk of appeal than possible. So we'll take 5 before the jury comes back. Ready for the jury? Yes.
Judge, are you here to say yes? Yes, we're ready.
Okay.
I didn't know if anybody said yes.
I didn't hear anything, so they went to get the jury.
Everybody's kind of busy over here.
I see that. Thank you. Mr. Owens, you may proceed.
It's changed again.
Okay, Mr. Egan?
We call Paul Bogger our ski expert.
Thank you. Mr. Bogger? If you could walk right over here to the clerk, and she will swear you in as a witness.
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Good morning. Would you start by sitting down and then giving the jury your full name and spelling it once you get situated?
Thank you very much. Yes, my name is Paul Bogger, Paulbaughger.
Your Honor, I note that my computer is still there. Do you mind if I grab it?
Sure.
Thanks. Mr. Bogger, thank you for being with us.
Thank you.
Will you tell the jury what you understand to be your role here today?
Yes, I was retained to do an investigation to consider all the circumstances involved in the accident that you've been sitting through here. And I've also been asked to, if asked to assume certain facts, I could give opinions as to how that might work. Would that be plausible? Do I see this? I think maybe a lot of what I would hope to add today would be to sort of give the operational side, the skiing side, the things that we observe in accidents, and when we evaluate them, what we learn and what I pass on. I do a lot of teaching and training, which we can get into, but those are, I think, the sort of the key areas.
So do you have expertise to help educate the jury about the skier responsibility code?
Yes.
Or just reasonable principles about how to ski?
Yes.
What about how, like, for example, bindings and ski equipment might factor into how they might work in a certain collision?
Yes.
And why do you have confidence that you can explain that and with authority to the jury?
Well, I've been involved in working professionally in the ski industry for 37 years, and I've primarily focused on the outdoor, on snow, skiing, more specifically ski safety. That involves ski accidents. I do a lot of ski accident investigation. I mean, literally thousands and thousands. And I've done a lot of collisions. I've worked on a lot of collisions, and I haven't just done it at one ski area, my home ski area, but I actually had 4 ski areas that I did risk management oversight for, and I'm primarily a patrol director at my base, but then I moved into more supervisory roles that started to involve other ski areas as well, including one in Canada, one here in Utah that you're probably familiar with, Brighton. And those experiences of looking at these accidents in a variety of locations has given me quite a bit of information I can use to A, do the day-to-day use of that. Do we need to address certain issues on the hill? Do we need to remove a skier, for example, if somebody's unsafe? In bad collisions and bad accidents, we really do need to learn as much as we can. We get medical feedback. We just consider a lot of information. And then the last piece of that is I pass a lot of that on. I've been training and teaching people in the ski industry about accident investigation, skier collisions, skier safety for the last 20 years. And so I've been all over on that.
Do you have any higher education?
Yes, I have a degree in economics.
And what about certifications that are related to ski sports or skiing?
Yes, I would have a number of certifications. I'm not sure how many of them would bear directly on the ski accident part, but I'm an EMT, an instructor of outdoor emergency care, a licensed blaster, an aerial blaster, which means we can use explosives from helicopters and mostly for avalanche control. Well, I guess only for avalanche control. If there's anything else, probably be a big problem for me. I'm sure my license doesn't say that. But and then I have a number of schools that I've attended, avalanche schools and various ski risk management type things. And then, as I said, really the last 20, 25 years of my career, I've been mostly teaching and training others, whether it's in the National Avalanche School, which we actually just held here in Utah in the fall, or consulting for ski areas, working with the National Ski Areas Association on national safety campaigns, the National Ski Patrol System. I was on the National Safety Board, and so there's a lot of related things, but I think that's the gist. I've been involved in, I like to even say, as I've been referred to as an expert in this for a long time, and I've done a lot of trials and testimony on ski cases, but I always think of myself too as a student. I'm continually learning about it. I always want to know the next thing, and you think they're all the same, and a lot are fairly similar, but there's always something new and something different. So,
have you ever, in your capacity you mentioned of reviewing cases for litigation or giving testimony in court cases, have you ever done that in Utah before?
Yes, I had a...
when was that?
Well, I've had a number of skier collisions that I've investigated here now with Brighton. That's more my oversight, and I'm reviewing the accident records. And then when we have a bigger collision that has more issues and so forth, or a ski accident for that matter, I'll get involved and I'll start going through a review much like we've been doing here. And I had a trial, I think 3 or 4 years ago in Salt Lake. Solitude, the ski area, was involved. And Park City, I've had a couple of collisions at Park City that I've done expert reports and so forth. But those cases settled. But anyway, so yeah, and that's, again, I think what's different about what I do than, say, maybe what Mr. Graff would have been doing when he was the patrol manager, is that I do travel and I do go to all the different parts of the country, including the East Coast, for accidents and the investigations. And skier collisions happen basically everywhere, and that's been I'd say I've probably had 20 cases that have gone to trial that I've been involved in. Maybe they haven't all gone to trial, but at least that have been in litigation. And
are you aware of any studies, or have you done any measurements of how common ski accidents might be?
Well, I'm certainly, I work with people who actually are involved in the what we call the 10-year interval studies, and there's been 4 10-year interval studies about ski accidents and the mechanisms of ski accidents. I look at that data. I also, excuse me, I think you heard Dr. Scheer earlier describing the ISSS, the Snow Sports and Trauma, it's the International Congress for Ski Safety on that, and I've presented there. I've presented I can't probably keep track of all the different meetings and groups that I've presented to, but these are bigger groups, the ISSS, and then I also present papers and do peer-reviewed work. The International Snow Science Conference, ISSW workshop, hasn't that was dreamed up in the 80s. They haven't lost that part of it, but it's a conference. It's an international conference. 1,000 people there. I do reports on things that happen, ski area problems, in fact, one ski problem with the snow immersion suffocation. I don't know if you've heard of that. You might have heard of tree well fatalities. Did you remember? We just had one here in Utah. And so that would be something I would gather data on. I talked to the general manager of the ski area that it happened adjacent to, and talked to the folks from the Avalanche Center here, Forecast Center. And they have some educational outreach that they do. And I basically was at the front of the snow immersion piece. I helped coin that term, and we did it. I keep a database. I keep doing ongoing research. I see you have another question coming.
No, it's fine. Well, I was just,
it's
if you
an
don't
idea.
mind me interrupting, so when it comes to measuring how common ski collisions might be in a given region or in a given place at a given time, do you have any particular data you can offer?
Yeah, well, certainly. If you looked at, I mentioned those interval studies, the rate in skiing accidents, the total skiing accidents of collisions, is about 6 to 7% of all of the reported accidents. Now, I'm sure there's a lot of collisions where people just bump into each other and go on their way, probably a lot more of those. But ones that result...
Your Honor, I'm just going to object that I'm fine if this is just background foundation on Mr. Bogger's experience, but this goes beyond anything contained in his report.
I see it as background, so overruled.
Yeah, that's fine, as long as it's background.
Thank you, Your Honor.
Yes, so that rate at 6 to 7% is sort of uncanny from interval to interval, so 40 years of data now, and it's still the same. And now I use that metric myself because I'm looking at the 4 ski areas that I'm supervising, and then the other ski areas that I go to when I do investigations, I look at their data, because the first thing I want to know is what is that rate here? And it can vary throughout the season based on weather conditions and snow surfaces and so forth. But that's a metric, is are we doing okay? Do we have a problem? Is there something that needs to be addressed? And so I look at it, well, in all accidents, there's all kinds of data you can get from accidents, not just skier collisions, in that way, and then we try to pass that information on. Sometimes we target it towards safety outreach. You can look at a lot of safety stuff on the National Ski Areas Association website that anybody can log on to and look at the safety pages, and a lot of the stuff on collisions that's in there and skiing safely and so forth. I had a lot to offer in the production of all that.
Thank you. Do you have any knowledge of what the rate of ski collisions might be in Utah? How common they are?
Yes, and it would be almost identical. Yeah, there might be, again, minor variations from ski area to ski area, but if you looked at Deer Valley, for example, which I did, and I asked this question during my site inspection, and their rate is just right in there. It's probably 6%, 7%.
How many collisions, and I'm talking not ski accidents, but collisions where 2 skiers are hitting against each other, how many collisions like that have you investigated, evaluated in your career?
Yeah, I looked through sort of back through the accident review data that I keep, and to just look at what you saw the other day, the incident report form, and maybe it's got something like an additional patroller comment or a ski instructor's incident report. I looked through that and I figured there have been about 4,000 of those that I've reviewed out of about 44,000 accidents with just the incident report form that I've looked at. That's all accidents, but collisions, about 4,000. And then things that really got more investigated, where there was things like we're doing here, 550 is, so that's it's a lot of accidents and a lot of collisions
In those collisions,
over a long period of time.
Sorry.
Sorry, I
No,
just
you're
wanted to
good.
make,
Yes.
and nobody will think skiing is safe anymore. I
Yeah.
want to finish that.
So, when you've done those evaluations, what is your role? What are you trying to accomplish as you evaluate those accidents?
Well, sometimes we need to find the cause. Mostly we want to know the cause, and certainly that's how you can target prevention. But we also want to learn circumstances. Sometimes we have really bad injuries in these collisions, and it's important for us to make sure we know, is there somebody at fault, or people meeting the responsibilities? And so we're looking at that all the time, and part of that is we want to make sure, since we're all responsible as skiers, that includes the ski areas, me, you, if you're skiers, that we share safety and we all do it together, and we all have responsibilities, and if one of us is not doing our job, people get hurt. And so we need to evaluate fault at times, and we maybe address some people that we actually remove from the mountain. We've had people go in cop cars off of the mountain, but we're serious about it. We want our skiers to know that we're serious about it, and they feel okay bringing their kids there, that we're not just turning a blind eye.
So, in your evaluation of these various collisions, what have you learned about what the inherent risks of skiing are?
Well, certainly skiers face a variety of inherent risks, and those are often codified into, especially in states that have a lot of skiing in them, like Utah or Washington State or California. There's what they call like a ski safety statute in the regs, and so it will mention many times, it'll enumerate what some of those inherent risks are. Another place you can find those inherent risks are on trail signs. Are mandatory here in Utah, and that they're publicly displayed, but also the ticket back, sometimes that varies from place to place. But do you want me to list any of the inherent risks? Or?
Sure, yeah, just to educate the jury, given your experience investigating these various collisions and just your experience as a long-time advanced skier, what are those inherent risks?
Objection, Your Honor. Relevance.
Overruled.
Thank you. Yes, so things that you encounter as a skier, things that you could likely have a problem with if you weren't paying attention and weren't following your role, your duties, of things that we would identify under things like the Ski Responsibility Code, which we can talk about, but terrain changes, forest growth, bare spots, things that you might run into, objects, lift towers, grooming machines, snowmobiles. We try to keep those off the hill when people are around. But, that's part of the sport. People need to get, lift maintenance people need to get around the mountain. So snowmobiles would be in there.
Oh, sorry.
Yes, go ahead.
I was just going to say, what about inherent risks relating to ski collisions
Yeah,
in particular?
and that's where I was coming to.
Yeah.
So I wanted to give you the broad brush and then say, and things like inbounds avalanches, you can actually get, even if they do the mitigation, you can actually get into an avalanche inbounds, and that's a risk you hadn't seen identified for a while, but about 5 or 6 years ago we started adding that one. And collisions, skier collisions, or even collisions with lift towers and objects, but skier collisions, as we know, 6 to 7% of the accidents, we can eliminate some things, but an inherent risk you cannot. And the definition there is the risk is inherent in the sport. You cannot remove it without fundamentally altering the sport as it exists today. So that means following our good responsibilities and being prudent skiers, we can reduce the risk, but we can't eliminate it.
So does that mean that sometimes collisions occur despite people reasonably skiing on both sides of an accident?
Yes, that happens all the time.
And when you investigate collisions, do you sometimes, after a thorough review, conclude that you can't determine who was at fault?
Yes, that's common.
So just to put that in another way, in your evaluations, will you come to the conclusion that a certain accident is, and the evidence that you receive in gathering information about it is not clear enough for you to identify who is responsible for it?
Yes.
Let's talk about the skier responsibility code. You mentioned that.
Yes.
And it's been brought up before, but since you're the ski expert, let's have you teach us about it for a second. I believe it is defense. Give me just a second, sorry. Thought I had it right here. Yep, it's defense 91. Any objection to that being published? Or I guess I should talk to the judge.
No objection.
91 is received.
Okay, so let's put this up on the screen. It's also on your screen right there, Mr. Bogger.
Yeah, thank you. I see it.
And I'll turn it here so it's a little easier to see. Okay, so is this the skier responsibility code you were referencing earlier?
It is, and it's actually changed in the last few years, but that's the one that was in existence at the time of this accident.
Okay, got it. 2016.
2016.
February.
2016 February, that's correct.
Okay, and how do you know about this skier responsibility code?
Well, it's key, excuse me, it's key to all of the duties that we were just talking about in order for people, the skiers, for us to do our part. And it's a national code, started back in the 60s with the National Ski Patrol system before they had professional ski patrols at ski areas. And it's used all over North America. Canada has something called the Alpine Responsibility Code. It's very similar. It has a few more details on it. I've testified in trials in Australia talking about a code that they have, again, very similar to this. But these are basic rules of the road. You have to give people, so you can put some order into the chaos that is skiing. You know, skiing's very dynamic, as you know if you're a skier. And so you're trying to put some basic rules in that people can follow, their common sense. And, oh, go ahead.
Do you know, are there ways that skiers can become familiar with this responsibility code?
Yes, this is published at all ski areas. It's on trail maps typically, and you'd find them on big trail signboards too at the ski area. Websites will have it. There's all sorts of places you can go to find this, but it's everywhere.
Okay, and let's talk about the particular points here. I'll pull them out. Maybe should we just go through them one by one? Is that okay?
Sure, however you want to do it.
Okay, so the first one, always stay in control and be able to stop or avoid other people or objects. That seems fairly common sense.
Yes, that's if that one doesn't work, the rest of them aren't going to work.
And then the second one maybe is more important. People ahead of you have the right of way. It is your responsibility to avoid them. Can you explain what that means for skiers?
Yes, and the presumption is when people are skiing down a run, the people in front of you aren't going to have that rear view like you would. You'd be in a better position as an overtaking skier to see the people in front of you.
Got it. 3 is you must not stop where you obstruct a trail or are not visible from above. What does that mean?
Well, again, it's just about being visible. And so if there's a breakover in the terrain and you were on the bottom side of it, the skier that's coming from above isn't going to see you. And so it's to prevent surprises. And again, if you're skiing in control, if you're following the first rule, when you're coming up to terrain changes, that's one of the things that skiers have to manage is their skiing, their speed, their rate, their course, and most importantly, their lookout. That's what allows them, even if they come to a terrain change and there's let's say a small child taking his skis off on the downside of that hill, you're not going to run into him even though that person might not be following the code. You're not following it either if you just go tearing over the hill. You have to be able to be in a position to maneuver so you don't hit anything.
Okay, so if a skier were taking, are you familiar with the term GS turns?
Yes, giant slalom.
If a skier were taking GS turns, what principles here should that skier follow?
Well, with a GS turn, and again, just backing up for a moment, skiing is very dynamic. It's people that are changing positions relative to each other all the time, and people are going at different speeds. People are using different styles, and you're mentioning one of them. You know, short radius turn or a slalom versus a larger radius turn, more rounded turn, a giant slalom. And these are different styles, and there's no prescription for how you have to do it or even what your ability is, any of that. There's no speed limit. I mean, there's slow skiing areas, but there's no number. So the idea is skiers have to be able to be in control, and it's the lookout. In a GS turn, you're taking wider swaths of terrain. You're moving across more, you're using more of the available hill space. So again, if there was trail density that was suggesting maybe you should be skiing shorter radius turns, that would be a reason. But typically when people are skiing giant slalom turns, their speed is usually faster. And people that are skiing short radius turns, I mean, if they try, they can ski quickly, but most of the time, the turn is what controls your speed. So if you're making more of them, you're probably going slower.
What about, let's assume a skier is overtaking another group. They're just skiing through a group that's skiing slower. What responsibility does that skier have?
Well, again, as the overtaking skier, you're looking at the rule number 2, people ahead of you have the right of way. And when you're coming into a group, you now have less space to maneuver. And your lookout has to be sharper because you have more things to focus on. Again, remember, everybody's not moving in unison. They're moving dynamically, and people can turn suddenly. And so again, if you're a prudent skier, and this isn't necessarily covered in the code, but if I'm going to make an abrupt turn on a crowded run, that's a problem for me. If I didn't look, I need to look up. You know, it doesn't say you have to look uphill, but so the code gets you just so far. And I think, if I may, one of the things about the code is if you try to look at any one rule and say, for example, in a collision, because I have to look at this all the time in these investigations, or when I'm training people, I would have to tell them, never focus on just one. That's just one part of the puzzle. There's usually something else. And if I had a penny for everything that was involved, the failure of the lookout. For example, if I might have two skiers in a collision, and both are trying to be not the uphill skier, and I look at them and I'm going, but you were changing your positions, you had different speeds, you were merging and converging on each other. You both have the responsibility for your lookout. It can't just be straight ahead, you have to be looking. And that's part of why you have to go to number 1, and that's the king. And then you go through the rest of them, but you can't hang your head on just one. Now, in some accidents, it may be really prominent, and you can weight it that way. But I'm just saying, you need to consider all of this, and the lookout you can't forget.
Right. So, is there anything about what can you tell us about the rules of skiing reasonably that relates to skiing within your ability? Is that one of the rules?
Well, it's not a rule per se, but it is right here that you have to be in control. So that means for whatever slope you're on, whatever the snow surface might be, it might be a hard, icy day, and you're going faster, it might be a little harder to control your speed. You know, you need to then, it's not that different, I guess, from driving there, because, you know, if the weather's bad and your braking distance is bad, then you have to give more room. And I think creating space is a key, but you have to ski within your ability, and you want to assume that maybe not everybody's doing the same thing, and leave a margin.
Okay, so what about if take an example of a skier that may have certain physical disabilities? Does that skier have the responsibility to take account of those disability or those limitations and ski appropriately?
Yes, of course.
Let's move away from this for a second and ask you about a hypothetical that connects to Dr. Scheer's testimony. You were here when Dr. Scheer
yes.
testified earlier,
I was.
Correct? and he talked about bindings releasing. Do you remember that?
Yes.
And do you have knowledge about how bindings release in ski collisions?
Yes, I do.
So if you were to assume a certain skier came and hit another skier directly in the back at a high rate of speed, would you expect bindings to come loose, the skis to come off the skier?
Objection, Your Honor. Lack of foundation also not contained in his report in the lease. There is nothing mentioning any binding release anywhere in the report.
Sustained.
Let's try take another hypothetical. Give me a second to think it through. Let's forget about bindings and use that same hypothetical of someone skiing directly into someone else's back. Would you expect that person to launch over the next the person they hit, in a couple feet down the mountain?
Same objection, Your Honor. Lack of foundation.
Sustained.
Is there a space on the hill where skiers, let me think about it differently. If a skier were trying to avoid collisions and ski in a kind of safe and cautious place on the hill, where should that skier go?
Well, you could look for certainly terrain within your ability, and if you want to be cautious, you'd probably want to be on easier runs. And if you were wanting to be away from more people, specifically if you're concerned about skier collisions, and runs are getting crowded these days, you pick the right time, or you wait for opportunities. You can wait for traffic to go by and then you can go. Staying on the margins of the run is usually good because you only have one side to defend, if you will.
So if a skier were taking short radius turns on the right side of a run, would that be within the parameters you've just described?
Yes.
I did cut you off a little earlier when you were talking about the inherent risks of skier collisions, the things you learned about what the inherent risks are in skiing, investigating collisions. I want to make sure you got out what you wanted to on that point. Was there anything else?
Well, I mean, that's a big question.
Objection, fake.
Sustained.
Okay, Your Honor, may I take a second to consult with my counsel? Thanks.
Sure.
Thanks for your patience, Mr. Bogger.
Sure.
You personally went to the site of this collision, correct?
I did.
And were you there when Mr. Brill, maybe I should ask first, do you know Mr. Brian Brill?
I do.
And who is he?
He does animations, the ones that you've been seeing here, and he does them all over for ski accidents, I think he does other things too, but he's very, very precise in laying out the terrain and the features in the terrain. That, you know, the trees are all the right height and the shadows are correct and all of that.
Yeah, and you were here and you'd seen the animations before, correct?
I have.
Objection, Your Honor, this goes beyond the scope of his report. There's no mention of animations in the report.
Overruled at this point. I
And-
need to see how it's tied in.
Sure. I was just going to ask that given that you've been to the site of the collision, does the animation to you accurately portray the location?
Objection, Your Honor.
Sustained as to relevance, it doesn't matter. It was a demonstrative of the other witness's testimony.
Okay. In this case, what did you review?
I looked at all the deposition testimony, the documents, and various forms. We did the site inspection. I did work with Mr. Brill on the animations. I talked to Mr.
Objection, Your Honor.
Graf.
Strike. Relevance.
Sustained as to relevance. Why don't we take our lunch break at this time? It's just a little afternoon, and we'll take a recess and return at 1:30. Thank you.
Thank you, Your Honor.
Questions in light of the court's earlier rulings? Okay. We'll see you back at 1:30. Thank you. Thank you. The bailiffs are bringing in the jury and getting them ready. No, I won't bring them in the room until they're ready. Mr. Bogger, you can come back up to the witness stand. Okay, we're ready for the jury. All right. Thank you. Mr. Egan, you may continue.
Thank you, Your Honor. All right, Mr. Bogger, we just have a few more questions, and then we'll get you off the stand here. First, is it your opinion that both Mr. Sanderson and Ms. Paltrow had the responsibility to exercise reasonable care to avoid a collision with each other on the day of their accident?
Yes, that's correct.
And you're familiar with Ms. Paltrow's account of that collision, correct?
Yes, I am.
Have you heard her testimony, in the trial testimony that she gave to this jury?
I have.
And you also reviewed her deposition?
Yes.
And if you assume that her account is correct, is it your opinion that she did comply with the standard of care or the reasonable standard that you just said that was her duty.
Yes.
And if you assume her account was correct, did Mr. Standerson comply with that duty?
No.
And why is that?
Well, if you assume the facts that we're looking at Ms. Paltrow's version, then you'd have to conclude that at the moment of the collision, she was a skier below and was hit from behind. And that collision, I know I said there were a lot of other factors, but in this case, that seems to be the key factor. And that's where the failure of someone's lookout at the last minute, even if they can be in control the entire time, making great slalom turns, whatever it might be, but you can be a very good skier and you can be skiing in control, but if you have a momentary failure and there is someone below you of your lookout, then you have a collision. And by definition, if you have that collision, that's not in control because you can't stop and or avoid anything below. So by definition, that's skiing out of control, even if it's momentary.
Did you review the evidence relating to Deer Valley's paperwork and obtaining of information about this accident?
I did.
And do you have knowledge of the standards for ski resorts in terms of that kind of a investigation of an accident?
Yes.
And did Deer Valley comply with that standard?
Yes, based on the facts that they had in front of them, yes.
And did you see any evidence of inappropriate documentation?
No, what I reviewed looked like it would meet the industry standard of care. It would be very similar to all the ski areas that I visited and know I'm familiar with their record keeping and so forth. These are typical business records kept in the course of business.
In your experience, thoroughly investigating over, I think you said 500 ski collisions, do you sometimes conclude that the evidence does not allow you to determine who is at fault?
All the time, yeah. Sometimes you just don't have enough information. Sometimes you have conflicting information, and you just, there's plausible versions, and you can't know which one's right, and you just have to realize that you're not going to be able to determine fault. So that's common enough.
Okay, that's all my questions. Thanks.
Thanks.
Ms. Van Orman?
Good afternoon.
Good afternoon.
I'm going to be really, really quick with you. In fact, we're just going to do the opposite of what you just testified to. So you were just asked if Ms. Paltrow's version of the accident, assuming that was true, would Mr. Sanderson have violated the skier's responsibility code? We're going to flip that. You've heard Mr. Sanderson and Mr. Ramon's version of the accident. Assuming those were true, they would have complied with the skier's responsibility code, correct?
Correct.
And Ms. Paltrow would have violated the skier's responsibility code.
That's correct.
All right. And in fact, the skier's responsibility code, it applies to all skiers. They all have to follow it, right?
That's correct.
No matter if somebody has a disability in their eye or if they're turning to look at their children to watch them ski.
All skiers have that responsibility at all times.
That's all I have. Thank you.
Thank you.
Mr. Egan?
That's all, Your Honor.
Thank you. Mr. Bogger? Thank you. You may step down. Mr. Egan, you may call your next witness, or Mr. Owens this time.
Thank you. Your Honor, Stephen Edgley, MD. So Dr. Edgley, the court wants to swear you to tell the truth. There's a lot of stuff here.
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can have a seat.
Good afternoon. Would you begin by stating your full name and spelling it for the jury?
Stephen R. Edgley, That's a Stevenedgley. Yep.
Okay, Dr. Edgley, are you employed?
Yes,
Where are you employed?
at the University of Utah.
And are you over the acquired brain injury division?
Yes, physical medicine and rehab is my specialty, and I'm over that section.
How old are you, sir?
49.
Okay, and just background, undergraduate degree, where was that?
I studied psychology with a pre-med emphasis at BYU. My med school training was in Chicago at Loyola University in Chicago. And I did a 4-year residency in physical medicine and rehab at the University of Utah.
And then did you go there? Did you stay at the university?
Yes.
And have been for how many years?
Overall, 20, yes.
Okay, and do you hold an endowed chair at the university?
I do.
Do you teach? Are you a professor there?
I do.
And you personally had an acquired brain injury, is that true?
Yes. So I had a stroke in 2001, 21 years ago.
And did that event play a role in your area of study?
It did. I was initially matched for a residency training in ophthalmology, actually. I took 1 year off to deal with the recovery aspects of my stroke, and then began physical medicine and rehab residency training.
Are you board certified in your specialty?
I am.
You are a physician, MD, correct?
Yes.
And do you deal with people other than stroke people, other acquired brain injuries?
So in my practice, it's a very busy practice. 95% of my practice deals with acquired brain injury.
And what is that, as opposed to brain injury? Like if a baby is born with a brain injury, that's not acquired, right?
Acquired. So acquired brain injury encompasses strokes, traumatic brain injury, concussions, and a myriad of other brain injuries related to surgery, anoxia, near drownings.
Anoxia is like oxygen deprivation?
Yes.
Okay, and maybe a child who's found at the bottom of a swimming pool, rehabilitated, brought in, and they come and see you?
Yes.
About how many patients have you seen in your career?
So I have, let's see, I see about 15 separate encounters per day over 20 years. That equals over 65,000 patient encounters of acquired brain injury.
Thank you. And do you consider yourself an expert in brain injuries?
Yes.
And the fact that you have personally had an acquired brain injury, does that also give you additional insight?
It makes me kind of unique in that I have experienced.
Have you
Yes.
reviewed voluminous records in this case?
I have.
So the court complaint, records and reports from the VA hospital, is that fair?
Yes.
About 1,000 pages or so?
Yes.
And deposition transcripts, Gwyneth Paltrow, Terry Sanderson, the daughters, Sam Goldstein, Dr. Fong, all of those?
Yes, that's correct. Yes.
And medical records also of the Park City Instacare, Cognitive FX, Sam Goldstein. Have you reviewed those?
Yes.
Do you believe that you have the foundation to render expert opinions in this case?
I do.
The jurors have already heard that the patient, or I should say Mr. Sanderson, has a mild traumatic brain injury. Do you agree or disagree?
I think I have poured over the records. I think it's possible,
Okay.
but the testimonies are inconclusive.
Did you tell me that the most important things you look at are how long they're unconscious and how long they've lost their memory, amnesia?
That's correct. So that's going by the Cantu concussion grading system, which is preferable because it's the most objective and not relying on subjective symptoms from any patient.
Okay, so a concussion, if you hear someone has a concussion, are those your two lead questions? How long were you out, and how long is your memory out?
Exactly.
All right, and apply that to Mr. Sanderson, would you?
So it is unclear whether he lost consciousness. Now, let me be clear. So let's define consciousness. So when you are unconscious, you are totally lifeless and limp. Not speaking, not moving. That's unconsciousness. I based on the records, there is a very inconsistent evidence that he did in fact lose consciousness. So I am not able to state that conclusively.
Okay. What do we know about, for instance, Christensen was the ski instructor. He testified to no loss of consciousness. You with me?
Yep.
And Brad Falchuk has not gone yet. Ms. Paltrow has stated no loss of consciousness. Craig Ramon did say loss of consciousness. Have I sort of summarized some of the people who talked about that?
Yeah, and the plaintiffs himself has said, loss of consciousness, 5 minutes, and then again later 10 minutes.
Okay,
Yes.
so Mr. Sanderson kept changing what he
Yes.
was telling people, right?
Uh,
I don't know, a few seconds, 5
Yes.
minutes, then 10 minutes. True?
Yes, and I think that is why it's important to clarify loss of consciousness with the post-traumatic amnesia. So, the plaintiff will not remember how long he was unconscious, if at all. He will remember the first memory he had of that event.
Okay.
And-
So consciousness, I heard you say 5 minutes, and I just want to be clear. One of the ways we rate sort of the severity of the concussion is very short to no concussion, up to 5 minutes, and then over 5 minutes.
So
Is that true?
So to clarify, no loss of consciousness, but post-traumatic amnesia is a grade 1 concussion.
Thank you. Whitney Smith, I guess, was another provider who said no loss of consciousness. Are you aware of that testimony?
I don't recall.
Okay,
Yes.
Whitney was the toboggan person.
Yeah,
And
okay.
she asked it, she quizzed them, I guess, but let me move on. Okay, so even if Ramon's testimony is believed, that would put him only in the second category, less than 5 minutes.
Yes.
Okay, and first category is essentially no loss of consciousness.
Yes.
Okay, now let's go to amnesia. Applying what you've learned about Mr. Sanderson, how long was his amnesia after the collision?
That is also very ambiguous and multiple reports. I hear and read that he had a conversation with Eric Christiansen, which he does remember, which was traumatic in his opinion.
So Sanderson remembers Christensen yelling at him. True?
So
Is that what you're referring to?
yes, that is the allegation. Yes.
Okay, and he remembers his friend Craig Ramon talking to him. Are you okay? Are you okay? True?
Yes.
Okay, so what does that tell you about length of amnesia?
It was brief, if at all.
Okay, so you said that two big things we look at for severity of concussion is how long they're out and how long they could forget things.
Yes, and I will add, people experiencing brain trauma have a period of fogginess, and as the plaintiff himself said, quote, "I rung my bell."
Okay, at one point he said, I rung my bell. I hear you. Go ahead.
So I am not able to say, So, it is probably it is likely that he did have some confusion, but if he had no loss of consciousness and no post-traumatic amnesia, it can't really be called a concussion.
All right, fair enough. And confusion, let's just talk about that issue. He has memories at the actual incident site, correct?
I suppose. I don't think.
Sustain an objection, Doctor. That's when you do not answer.
Length of period of confusion. Do you remember what he told the toboggan person, Whitney, about whether he? Do you know if what Whitney observed in terms of his confusion level?
No.
Okay. She wrote alert and oriented ×4 or something. That's in evidence. I'm asking now to comment on it.
Overruled?
No foundation.
Overruled?
If Whitney, the toboggan person, observed no alert and oriented ×4, are you familiar with that term?
Yes.
And is it 4 out of 4?
Yes.
Like 4 is the best score?
Yeah.
I want to know what that scale means. Please tell me.
So let's see. Oriented to person, place, situation, and location.
Place, time.
Time. Yes.
I don't know. Okay.
Person, place, time, situation.
Did you say president or present?
No, person.
Person. Gotcha.
So.
All right. And the jury's heard on those issues, so that's okay. I asked Terry, would it surprise you if at the Instacare they found no confusion? He said no. Is that consistent with your knowledge of the events?
Yes.
Have you seen texts he was sending out, even at the bottom of the hill, about Whitney?
Overruled?
Go ahead.
I have heard about the text. Yes.
All right. Is it your opinion that if Mr. Sanderson suffered a concussion and it was mild, it was mild?
Leading.
That's
overruled?
Go ahead.
What's the question again?
Is it your opinion that if Mr. Sanderson suffered a concussion, it was mild?
Yes, it is. Yeah.
And is that based on the things we've been discussing, or are there any other issues? Loss of consciousness, amnesia, confusion.
Sustain.
I'm just wondering, are there other issues we ought to hit before we move on to your next opinion that go to that issue?
A helmeted low velocity impact. Also.
Low velocity impact. What does that mean?
So he was not going fast.
Okay, what do you know?
Like in a car accident. He was not going car speeds.
Okay. And you read, for instance, the depositions where they discuss it was actually kind of a slow fall.
Yes.
And that's important when determining how hard the hit was or something for the concussion severity.
Yes.
Thank you. Any other factors we've missed?
I don't think so.
All right, let's go to your second opinion here. None of the medical records support plaintiff's claim that perceived symptoms of cognitive decline are related to the ski collision. Is that your opinion?
Yes.
Maybe I'll flip it around. Comment on his symptoms. What percentage of his symptoms that he now complains of are related to the ski collision?
I can't really do that. I think it would be better to analyze what he had going on in his brain before and after the collision.
Please do that.
So the plaintiff, and I'm in no way trying to pick on the plaintiff, but he had a number of brain conditions. He had a stroke, which he lost his eyesight in his right eye.
Stroke.
Yes. He had evidence of a microvascular disease
In his brain?
in his brain. And probably most importantly, he had evidence of a hydrocephalus clear back in 2009. And let me talk about the hydrocephalus and
Okay, let me make sure we get the whole list, though. These are preceding brain problems from his pre-collision, true?
Yeah.
Are we showing this, whatever this exhibit is, to the witness and having him read off of that?
No.
He's not reading off of it, but please turn it around. It's a different topic.
Go ahead.
so
That was not a prop. That was getting ready to show it, but we'll go on.
yeah, okay. Restate
Yes, thank you. Okay, I heard you say, with regard to pre-collision brain problems that the plaintiff had, stroke, microvascular disease, hydrocephalus. Any others?
Not that showed up on the MRI of his brain in 2009.
He had a history of migraines. Is that something you'd put under that list or not?
Yeah. Yes. So.
Sustained?
Okay.
Pardon me?
I didn't even
Strike.
I couldn't hear. Just
move
okay.
to strike the answer.
Motion granted.
I didn't even know what his answer was going to be, by the way. I'm just trying to get this list together. But
So the answer is stricken, the jury must disregard it.
thank you. So, if you think of another one we ought to talk about, please tell me, okay? You said you want to talk about hydrocephalus. What is that word?
Hydrocephalus is where the ventricles have too much pressure, or a condition called normal pressure hydrocephalus, which is equally kind of devastating.
Dumb it down for me. Does hydro mean water?
Yes.
What does cephalus mean?
Brain.
Okay,
Yeah.
so.
Water on the brain.
And then this is very confusing. normal pressure hydrocephalus is not a normal condition. Is that true?
Not at all.
Leading overruled?
It's, I mean, when I see the word normal in a diagnosis, I think, oh, that's normal. But in this case, normal pressure hydrocephalus is or is not a good condition.
So, it is a well-recognized medical condition that is degenerative in nature, meaning it gets worse with time. About only 1 in 500 people between the age 60 and 70 have this, and it gets worse with time.
You said hydrocephalus means water brain. What does that mean? There's too much fluid in the head, or what?
It specifically means that there is too much fluid in the ventricles of the brain.
And what's a ventricle again?
Fluid filled cavities that feed the spinal column and eventually get resorbed by the body.
And you said it's progressive. Just comment on that. So let's say there were no ski accident. Comment on its progressiveness in Mr. Sanderson.
So it's been 14 years since that initial MRI. That's quite a bit of time. I would expect symptoms to crop up like loss of memory, like trouble with balance.
Okay. Let's move on to microvascular disease. By the way, I want to know if these things are related. If someone has the hydrocephalus like Mr. Sanderson, does he also have to have microvascular disease?
No.
All right. And do you believe the microvascular disease caused the stroke?
Yes.
Okay, so those two things are related.
So
go ahead.
A stroke of the central retinal artery is a harbinger of future strokes and a indication that there is microvascular disease.
So microvascular. Micro means small. Is that right?
Yes.
Vascular means like blood flow?
Yes.
All right, so small blood flow. So in lay terms, does that mean the passages of blood flow are narrowed in his brain?
Yes.
Sustained?
I'm trying to get to the most like 8th grade level, which is what I understand.
Yeah.
So comment on Mr. Sanderson's pre-collision brain as it related to microvascular disease, please.
So 2 points. So some microvascular disease can cause very small strokes, which are not able to be detected by scans, MRI, CT. Also, number 2, microvascular disease is a great risk factor for a future stroke.
Do you believe this, is this your opinion, all symptoms the plaintiff claims is explained not by the collision, but by his pre-accident conditions.
We,
I'm trying to get his opinion out there, Your Honor.
You can ask what his opinion is.
Yeah, sustained.
Okay, comment on your opinion on that issue, on the issue of his current claims as it relates to his pre-accident conditions.
So, in a more likely than not scenario, in this 76-year-old brain now, concussion symptoms should only last for 1 to 3 months. There is a wide berth of evidence that when the concussion symptoms last for longer than 3 months, it's highly correlated with monetary gains or litigation.
Explain that, please. Monetary gains or litigation. Go ahead. What's your point? And relate it, please, directly to Mr. Sanderson.
Your Honor, this goes beyond the scope of his expert report.
Could you approach, please? Sustained?
Describe the answer to.
And the question and answer was stricken, and the jury is ordered to disregard it.
Comment, would you, on the patient's pre-existing anxiety and depression?
So, he has been medicated for a number of years for depression and anxiety.
And do you believe those things play a role in his current condition?
Absolutely.
And just comment on that, would you?
So, also, when symptoms of concussion last for 3 months or longer, anxiety and depression and other psychiatric conditions are the likely cause of that prolongation.
The last sentence? I missed the last word, I'm sorry.
Prolongation.
Prolongation.
Yes.
Thank you for explaining that. Can you just comment just a little further about that? What do you, say it a different way for me, would you?
Yeah. So, the symptoms of a concussion should last no more than 3 months. When the symptoms of concussion last longer than 3 months, you start looking for, and this is highly correlated with underlying depression, anxiety, and other psychiatric conditions.
One thing you noted in your report was plaintiff has a history of seeking medical attention at an abnormal rate, 72 times in 10 years. Is that your opinion?
Leading.
Sustained?
Well, comment on how frequently Mr. Sanderson went to his doctors in the 10 years prior to the collision.
So I did note that he had an extensive history of seeking care.
And
Yes.
what does that tell you? Why is that important?
Two things. One, either he has many medical issues before the collision, or he is kind of hyper focused on his symptoms.
And that's pre-collision we're talking about?
Yes.
And then pre-collision, just as a part of aging, did he note a decline in his mental or physical activity, acuity level?
So, what's interesting is within 1 month of the collision, he went to his own family doctor and said, I feel like I'm getting old.
This is within 1 month before, correct?
Yes.
And did he say, I'm having a hard time doing the things I've always done?
Yes.
Leading.
Overruled.
And why was he feeling that way? Do we know?
Hearsay, Your Honor.
Yeah. So I
I'm just asking, do you have any thoughts on that issue?
Hearsay.
Sustained?
Well, using your medical opinion, I'm just wondering, what does that tell you as a reviewing medical expert?
Foundation.
Overruled?
Go ahead. I'm getting old and I can't do what I used to do. Go ahead.
Overruled? Go ahead.
So I have had many patients of his age say the same thing. Yes. And I think it's important to clarify one thing. So the brain is an organ, just like any other organ. With time, it accrues conditions, problems, just like any other organ. The plaintiff had evidence, including objective evidence on MRI and things like that, of these disease processes before the clinician.
Okay. And this was the stroke workup, is that where he had the imaging?
Yeah.
Before? And do Do you know of any of their plaintiffs' experts who actually reviewed the stroke imaging before the collision?
Foundation, Your Honor.
Overruled?
I do.
Did they?
Um,
Did any of the plaintiffs' experts review the imaging to your knowledge?
Not to my knowledge.
And if we're trying to figure out, hey, what's this guy's brain like before and what's this guy's brain like after, it would be nice to put those side to side, wouldn't it? And actually compare?
It would, and that's what the defense has done. Yes.
All right, let's just talk about aging. Have you seen? May I show him a document, Your Honor, before I publish it?
Sure.
Have you seen Defense Exhibit 103 and 103B?
I have.
And does that appear to be a true and correct summary of Mr. Sanderson's health before the incident?
It does.
Okay, and Your Honor, I move to publish it.
Any objection? We object, Your Honor. It's what we've talked about before. There's irrelevant medical information there.
I'm about to establish the relevance.
If he hasn't established it yet.
I'm going to admit 103 and 103B for demonstrative purposes only to allow this witness to illustrate their testimony.
Is this okay for a minute?
Sure.
This is the same thing, I just don't trust technology. So 103, and Doctor, do you have a binder right in front of you? Do you have a defense binder?
Yeah.
May I approach? Oh, can you see it right here?
Yes.
Oh, the monitor, it threw us the first week that the monitor wasn't working. Can we do the first third? All right. Can you see that okay, Doctor?
Yes.
And is this the note you were just talking about? Thinks he's gotten old all of a sudden, not doing things he used to do?
Yeah, it is. Yes.
And then, let's say that big. Then, blind in right eye, were you familiar with that?
I was.
And severely impaired in the other. Did you see that in his medical records?
I did.
Did you see evidence that he walked into walls before the incident?
Yes.
He would ask people standing on the right side of his field of vision to move so that he could see them. Did you see that in the evidence?
Yes.
One of the reasons he retired was because he had a stroke event that deprived his eye of oxygen, impacting his vision. Did you observe that in the evidence?
Yes.
If we're going to go through all these, it's going to be leading, Your Honor, every time.
Overruled?
He adjusted his skiing to one side of the slope to try to avoid hitting others in his blind spot. Did you observe that?
Yes.
He had to be picky about what days he skied to avoid days with lighting that would further limit his depth perception. Do you agree? Did you see that in the evidence?
Yes.
By the way, I mean, if I close one eye, do I have depth perception? Is it still three? Comment on that. Is it still three-dimensional or is it now two-dimensional?
You do want to
The scope of his expert testimony, Your Honor.
He's commenting about aging.
Overruled?
Okay, so I'm closing one eye. Does that hurt my depth perception or it doesn't?
That does.
Just comment very briefly.
Well, you have basically got a monocular and so depth perception will be severely impaired.
Prostate cancer, were you aware he to this day still has metastatic prostate cancer?
Yes.
It's not like it was cured, true?
Yeah.
And he is severely hearing impaired. Did you see that in the record?
Yes.
He has difficulty hearing higher frequency sounds like a woman's voice. Did you see that?
Yes.
Hearing loss is severe. Did you see that?
Yes.
Heart palpitations. Did you see reference to that?
Yes.
And he was on 2 heart medicines, 2 heart, just prior to the ski collision, 2 blood pressure meds for his heart.
Yes.
Is that related to the palpitations, or are those high blood pressure issues separate from the palpitations?
So they can be related to the heart. They can be related to anxiety.
Okay. Do you have an opinion one way or the other?
So I cannot speculate.
Okay, Mr. Sanderson is 76 years old and experiencing the effects of aging. Do you believe that?
We all are.
Is that a yes?
Yes.
Microvascular disease, we talked about that. Moderate diffuse volume loss atrophy, brain volume decreasing. Did you note that he had that prior to the ski collision?
So I read it on the report, yes.
Okay. And what does that mean? Do our brains all shrink as we age?
Yes. Some more than others. And
talk about Mr. Sanderson, please.
Brain atrophy can be caused by a number of factors.
Okay. Comment on Mr. Sanderson, please. What do we know? Why did he have that before the ski collision?
We don't.
Speculation.
That's
I
what
don't
I'm
know why
asking.
he had it before.
I'm asking if he knows it.
Overruled?
Tell us if you know why he had it.
I don't. It's a vague symptom finding, and it could be caused by a number of things. Commonly, people who drink alcohol excessively commonly have brain atrophy, but there are a number of other causes.
Did you see any evidence in the VA record that he sometimes drinks more than 6 drinks a night?
I did.
And did you see the advice from his providers was, don't do that anymore?
I did.
We want you to abstain from alcohol. Yes?
Overruled?
I did see that, yes.
All right, we're gonna move faster here. By the way, it says moderate volume loss, so mild, moderate, severe, are those sort of the 3 categories?
Yes, and that's referring to the MRI in 2009.
Retinal artery occlusion, we talked about that, that's the eye thing. And clotting in arteries delivering blood to brain. Is there anything you want to comment that you haven't talked about on that issue, number 9?
No, I don't think so.
Depression, you've talked about that. Anything more you want to say about it?
Depression and anxiety.
Okay. If he says, since the ski collision, I've had more depression and anxiety than I did before, what do you attribute that to?
So any symptoms past 3 months, I would attribute it to this multiple factors, not at the accident.
Okay, migraine we've talked about. Let's go. We're going to march through these very fast. In addition to going now, starting on 103B12, did you know he had degenerative disc disease in his back prior to the ski collision?
I did.
Did you see reference to a foot drop, that he, at least for a time, he actually was dragging his foot?
I did.
Weakness in his back and spine?
Yes.
Loss of sensation, did you see that?
Yes.
And just general back pain? Did
Yes.
you see that? Knee injury, yes?
Yes.
And that was actually from a ski collision? Do you recall this? Not a collision, a ski accident?
I did not know that, yes.
Shoulder injury, shoulder problems, do you recall him having those?
Yes.
And hamstring injury, right, torn hamstring?
Yes.
Osteoarthritis, did you see that?
Yes. And what may be more relevant to this case is the osteoarthritis in the neck region, which would make moving your head side to side kind of painful or difficult. That, along with the vision impairment, are, I think, relevant.
All right. My partners here are telling me I should wind up. Can you at least look at insomnia, respiratory problems, poor male sexual reproductive health, lower urinary tract issues, kidney problems, hypercholesterolemia, weight gain, and restless legs? Are those all conditions you saw in his pre-collision medical records?
Yeah.
And why are these things important when we're talking about aging?
It is a long list. Some of these conditions are more relevant than others.
Fair
but the some indicates that he is 76, and with 76-year-olds, sometimes I have multiple medical conditions like this.
And these were all pre-collision events, right? Pre-collision conditions.
Yes.
And what does that tell you in terms of his aging, like at 69?
Well,
that he was?
So like I said before, we all are.
Aging.
Yes. And so in terms of the brain as an organ, we talk about brain reserve, and we talk about cognitive reserve. Brain reserve tends to go down and down, starting at around age 25. It goes down faster with time and aging.
Okay.
Cognitive reserve indicates that the patient's ability to cope adapt, be resilient, and find effective workarounds for that brain decline, which we all are undergoing at various stages.
Let me conclude here. They're about to stand up and criticize you for not personally meeting with the patient. Did you personally meet with Mr. Sanderson?
No.
And what did his actual treating providers at the University of Utah, or excuse me, the VA, Veterans Administration people, what did they show on all their neuropsych testing?
So I did not press to actually meet and examine the plaintiff because I think it would be a kind of a condescending to him and also to me to go over a totally normal physical exam as the medical doctors at the VA had well documented records.
And they documented high average to superior in essentially all categories.
Sustained.
Can you comment on their findings in terms of some kind of graph?
So I think you're referring to the neuropsych test.
Correct. Just give us, and then I'm sitting down. Give us a couple, 2 sentences on that, would you?
So a neuropsych test is really like an MRI of the actual mind and its function.
And what was it as to Mr. Sanderson after the collision?
He had 3 neuropsych tests, and it was superior to above average.
Thank you.
And
those are all my questions. Thanks.
We'll take a short recess right now. Thank you. You can step down. We'll take about a 10-minute break. 10 minutes.
Judge, while the jury is not here, may I mention an issue?
Yeah, have them stop at the door. Go ahead, Mr. Owens.
So after this witness, there are 3 witnesses who haven't been able to testify, and so they're going to testify by deposition. Are they ready to go on Carrie Oaks? Because we withdrew that one, but we want to know, are they ready to
We
go?
can be ready.
And,
Yes.
and are you reading our parts too?
I don't know what your parts are, but.
We handed them.
Yeah, we got them about 15 minutes ago.
Right. It's just a matter of reading them, though. I just need to know, because otherwise.
We wanted to play video of ours.
But, you know, if the court wants us to read them, we'll read them.
Your Honor, we can't, Dr. Fong's video, as you know, took quite a while. We don't have that time if they want to call Carrie Oaks and rest. So.
Our video is 15 minutes.
No, but we're entitled to our talking too. So can we do it on paper, Your Honor?
What was the last question? I didn't hear.
Can we just do it all on paper, the reading back and forth? We don't have time to review their video.
Mr. Sykes, are you fine with reading the deposition?
Well, you know, Lawrence.
Actually, Kristen Van Orman is talking with James right now about it.
Right, but we're talking about like, we're going live here.
Right, and we've handed this to us, 15 minutes ago. We gave him our part a couple hours ago. We'd like to.
James is right here. I don't know who.
Well, did you talk to Kristen?
I did not, but as I understand, Kristen is
We're-
amenable to reading it.
We're
Is
trying to
that
get
correct?
Dr. Bain. We'll go along with that if we can get Dr. Bain, but I'm not sure we can even get Dr. Bain except
Get Kristen in here, would you?
2 o'clock for sure tomorrow afternoon.
All right, well, let's finish with this witness, and in the meantime, maybe it'll sort itself out. If not, I'll have to make a decision.
I'm trying to contact Dr. Bain right now.
Okay. Let's have the jury come in. Mr. Sorensen?
Thank you. Dr. Edgley, thank you for being with us today, and you've overcome a great deal to be able to be so accomplished, and we appreciate that. I'm going to go through a few questions pretty quickly, and I'd just ask if you wouldn't mind answering them yes or no, because they should be yes or no questions, and I think we can move this process along. Is it true, or is it the case that you're paid $500 an hour for records review and $700 an hour to be here?
I believe you have that information, and that is correct. That there is an opportunity cost by my not being at my regular practice. I'm not here for money. I get paid to offset the opportunity cost by my not being at my regular clinical practice.
Gotcha. So that is yes, though, those numbers are correct?
Yes.
Okay, thank you. And is it true that, and as defense counsel pointed out, you did not ever meet with or see Terry Sanderson, correct?
Yes.
Okay. So you were paid to review records and do sort of a forensic records analysis, correct?
Yes.
We went over what you had reviewed in preparation to give and offer your opinions, and I didn't see that you ever reviewed the records of Dr. Boehm. Is that correct?
I don't think they were ever given to me.
Okay, so that is correct. You did not review them.
I don't think so.
Okay. What about the records of Dr. Wendell Gibby?
Yes.
You did review them, or
Yes.
you did not?
I did review the devastation of Dr. Gibby.
Okay. That was not on the list of things that you said you relied on for your opinion. Are you aware of that?
No, I was not.
Okay. So is it your position that you did rely on some of Dr. Gibby's records to formulate the opinions you've offered so far?
So I did rely on the opinions of Dr. Gibby, yes.
Okay. And I did also not see that you ever reviewed the deposition of Whitney Smith, the EMT that we've heard from in this case. Is that correct?
I think that's correct.
Nor did I see that you reviewed the deposition of Carlene Davidson. Is that correct?
Who is she?
She's the plaintiff's former girlfriend that's offered testimony in this case.
So I did review her deposition.
Okay. And what about the man named Craig Ramone? Did you ever review his deposition?
Yes.
Okay. Neither of those last two were on the list of things that you say you rely on, so you were in fact partially relying on them for your opinions?
Yes.
Okay. I think we already covered it, but you did a forensic document review in this case. Is that correct?
Yeah, yes.
Okay. And in a nutshell, and I don't want to put words in your mouth, but you offered 5 main opinions in your expert report that you provided to us. Is that correct?
Right.
And really, because of court rulings, we're going to focus on 2 of those. Is that all right?
Yes.
Okay. Your first opinion that defense counsel went through with you is that compelling evidence indicates that plaintiff's concussion was mild and that he lost consciousness only momentarily, if at all. Is that your opinion?
Yes.
So you do believe that there's a chance he did lose consciousness?
And there is a chance, but more likely than not, no loss of consciousness. I have not seen any compelling evidence to formulate otherwise.
When you say compelling evidence, you're stepping into the place of the jury to weigh evidence, isn't that correct? Is that a yes or a no?
It's argumentative.
Sustained. When you weigh the number one opinion that you have that you've offered in this case, and you say that it wasn't compelling, is that because you weighed evidence?
I read, poured over many reports, many which were inconsistent, and I'm left to wonder, did he actually lose consciousness or not? I don't know. I would say more likely than not, the answer is no.
Okay. And for the reasons that you gave when defense attorneys were asking you questions, that's why you say that it was more likely than not that he did not lose consciousness.
Yes.
Okay, do you need to have a loss of consciousness in order to sustain a concussion?
No.
And is there dispute among your peers and those of your specialty into the actual definition of what unconscious means?
I don't think so.
So all of those that are in your specialty would say that a loss of consciousness involves, I don't want to put words in your mouth, but lifeless and limp is the way you put it. Is that correct?
Yes.
So if we've heard testimony before this that you can be unconscious or have a loss of consciousness but still be somewhat awake, just disoriented or not alert, that's not correct.
That's disorientation, not loss of consciousness.
Okay. Is it possible that the amnesia that you talked about with defense counsel is or could account for Terry Sanderson's inconsistent testimony about how long he may or may not have lost consciousness?
Yes.
Okay. So that is a very real possibility in this case.
Yeah, actually, you cannot comment on your own unconsciousness.
Gotcha. So then we would be forced to rely on the testimony of those that were there or those that reported what they had seen?
Yes.
Okay. We've heard some testimony earlier about a triggering event. Are you aware of things that could be considered a triggering event?
The concept, yes.
Okay. Is Alzheimer's disease caused by a triggering event typically?
No.
Okay. Is dementia caused by a triggering event?
No.
Okay. Is NPH caused by a triggering event?
No.
Okay. Can the presence of NPH exacerbate a concussion or the symptoms of it?
It can in theory, but only for a brief period of a time. Brief meaning weeks to months.
Okay.
Not certainly not 7 years.
Okay. And the jury's heard a lot of testimony about a condition called PCS or post-concussive symptoms. Are you aware of that condition?
Yes.
So is it your testimony that the presence of NPH could not be a risk factor in possibly leading to PCS?
Let me back up. So, you should be aware, if you're not already, that the DSM-5, which is the list of psychiatric conditions, the fifth and most current edition says that if a concussion lasts more than 3 months, look for other causes, and I believe that they have totally eliminated PCS from their diagnostic menu.
So, and I don't want to misstate the answer you just gave me, but is it your opinion then that PCS and NPH are not related at all then?
You're asking me to state a categorical answer. Yes. No. I cannot say that there is no small, association.
Okay, so when Dr. Boehm, for instance, testifies that it's rare, but PCS can occur after the occurrence of a concussion, is that accurate testimony?
I would like to, so I have an issue with the term PCS because I don't think it's, so whereas it was a valid condition, it's not, at least in the psychiatric world, it's not recognized as a condition now.
Okay, so, and maybe I inartfully asked the question, but essentially, if I hear what you're asking, or what your response was, and again, I don't want to restate for you, but you're coming at this from a psychiatric perspective, where PCS might be more of a clinical or medical diagnosis. Is that correct?
No.
Okay. Can anxiety and depression be risk factors for possibly having PCS?
Again, I take issue with the term PCS, post-concussion syndrome.
Okay, what about, and I think we're talking about the same things, but I believe I'm talking about post-concussion symptoms, and I don't know that they refer to it as syndrome anymore. Is that correct?
Yes.
Okay.
So if you want to talk about post-concussion symptoms, we can have a dialogue. Yes.
Okay. And maybe that's my fault for misstating it before. I'll ask you the same question then. Can NPH be a risk factor for post-concussive symptoms?
So NPH is a chronic degenerative disease that is likely exacerbated by a number of things. The immediate aftermath of concussion being one of them. But more likely, much more likely than not, the concussion symptoms would have long, years ago gone away, and what we're left with is a brain that has NPH, microvascular disease, history of stroke, and is 76.
Okay. And you said a history of stroke. I want to make sure the jury's clear. Mr. Sanderson had a stroke-like event in his eye. Is that what you're referring to when you say stroke?
Let me be clear to the jury. So the American Stroke and Heart Association considers a retinal artery occlusion as a stroke event. Yes, not a stroke-like event, a stroke.
Okay, but there's no scans, and you've poured over many in this case, that show any sort of brain bleed or any issues besides the MPH and other issues that we've talked about that would be related to that stroke event. Is that correct?
Yes.
And did you read anywhere in the medical records that you poured over that he had any sort of NPH symptomology before the ski crash in 2016?
NPH symptoms are insidious at onset.
Okay, and what are those? I think they're called the triads sometimes. What are the three main symptoms of NPH?
So this is a very layman's way of explaining it, but you have cognitive deficits, including memory loss. You have imbalance, and that can lead to falls. And you have urinary incontinence, loss of the function of holding urine in your bladder.
So just to recap, the triad is memory issues, ataxia, and then incontinence is typically how that's diagnosed, correct?
Yes.
Okay. And you did not see any of those symptoms in Mr. Sanderson before the ski crash in 2016, correct?
Before 2009.
And what were those symptoms that you read?
Well, no, before 2009, that's correct. But yet it was commented on the MRI of 2009. And given that those symptoms are insidious in their onset, happening over years, maybe decades. 14 years later, I'm not at all surprised to find the plaintiff experiencing memory and loss of balance issues.
Okay. Did you review any of the MRIs taken of his brain in 2017 after the collision?
Yes.
And did those MRIs that you reviewed, did those show any sort of a worsening of this NPH?
They commented on it. I don't know if the scan showed worsening.
Okay, so you don't know one way or another if it worsened or not, but they did mention that that condition was present.
Yes, and that NPH is a clinical diagnosis verified by radiology findings.
But nobody had diagnosed his NPH before as having the triad that we talked about before, correct?
I did not see any mention. Yes.
Okay. And you were asked a lot about the plaintiff's medical conditions. We had a board up here. We had a whole list here. Did you read anywhere in the depositions that you reviewed that any of the laundry list of medical issues that the plaintiff may or may not have had before the event kept him from being a world traveler or on the go or even skiing that day?
The fact that 3 weeks earlier, he said to his primary care physician, "I feel like I'm getting old." That is most likely based on, as you said it, that laundry list of conditions. They're taxing. They're no one condition is that problematic, but the complication of those various conditions do weigh on a person both physically and psychologically.
Sure. But then if that is the case, Doctor, how do you reviewed some of the daughter's depositions, as you said, how do you account for their accounts of what happened with their dad directly after the ski crash in 2016?
I'm not going to make the claim that there was not a transient decrease of function up to 3 months. But beyond 3 months at time, what decline he had was more likely than not already the ball was already rolling.
Okay. You testified earlier that you've been an expert in many cases that have gone on to litigation. Do you remember when you testified of that?
Yes.
Have any of those cases been ski crash cases?
No.
Okay. So this is your first ski crash related expert testimony?
Yes.
Okay. Do you know what confabulation is?
Yes.
And what is that? Will you explain it for the jury, please?
Confabulation means making information up.
And it's not just lying per se, right? It's not just you're grabbing it out of thin air. There's a little bit more of a clinical definition for it. Isn't that correct?
I don't know where you're going with this.
Well, it's not just confabulation is an actual medical condition. It's not just creating lies, correct?
It can be related to a medical condition, yes.
Is it often seen in situations where people have had a brain injury?
Yes.
Okay. So inconsistent testimony by the plaintiff may be attributable to confabulation if his story is to be believed that he has a TBI.
So to point that symptom, confabulation, to the brain, alleged brain injury, sure, it's possible, but plenty of other things could account for that symptom of confabulation.
Sure, but it is possible, as you just said, correct?
Yes.
And from the 2009 to the last scan that you saw, and I don't know when that was, probably the 2017 scan. Have you seen any of his symptoms, the symptomology that you reviewed earlier, getting progressively worse from an actual imaging standpoint?
No, but we're talking about clinical diagnoses backed up, only backed up by imaging. Yes.
Sure. But there's no physical, you can't point to any scans that say this is different than it was in those early scans in 2009.
Nor would I necessarily expect to.
Do you know what the medical term discordant means?
Yeah.
Okay.
We don't often use that.
Okay. And what does it mean?
Well, it means loosely that things don't make sense and don't add up.
Okay. You've been asked a lot about Mr. Sanderson's medical records and radiology reports that you reviewed. I'm going to show this first page of Plaintiff's Exhibit 6 to the jury. Do you see this radiology report right here?
Yes.
Okay. I'm going to zoom in here for all of us, and I can
move up to avoid the address on the bottom.
Sorry about that.
You want a Sharpie?
We'll just go. Do you read that that paragraph that starts with the word findings? Do you see that?
Yes.
Now, will you just read that first sentence for us right there?
Demonstration of a prominent ventricular system discordant with mild cerebral volume loss and sulcal prominence.
Now, you have the degrees and I don't. So, does that mean that the prominent ventricular system, the issue with that ventricular system that you described earlier, is discordant or not related to or different from the mild cerebral volume loss with sulcal prominence? Is that what that means?
So, I don't suppose to get into the brain of the neuroradiologist, but that is a valid conclusion. So
that's my layman's approach of reading a medical record, and I recognize you have that, and I respect your position. But the medical records that you reviewed, discordant is usually used before describing this ventricular issue that you described earlier. Isn't that correct?
I think we're talking about two separate things: the enlarged ventricles, and as a separate issue, the mild cerebral volume loss.
Okay. And short of going well beyond both of our expertise and sounding more like an idiot than I'm sure I already do, I think we'll leave that one there. But these aging conditions that you describe, is it also within the possibility of medical certainty that you've offered your opinions that Terry Sanderson's condition could be in fact related to post-concussive symptoms?
That is not what the medical literature shows, but so I would say much more likely than not.
It is possible, correct?
As far as anything is possible, yes.
Okay. Thank you. Let me just check with co-counsel, and I think that's everything I have for you. So if other witnesses reported massive changes directly after this ski crash in 2016, would you also attribute those massive immediate changes to the aging process?
Restate the question.
Sure. If other witnesses, ex-girlfriends and daughters, report massive changes in the plaintiff after the ski crash of 2016, would you also attribute their discussion of those massive changes to regular aging?
This is a complex question. He had distress over very real rib fractures. He had psychological and physical symptoms that do influence, a patient's global functioning. Rib fractures heal. Bumps and bruises heal. What we're left with long term, so I don't disagree with the fact that people around the plaintiffs said that there were big changes in his physical and psychological function immediately after the injury. But there was brain-related issues should have resolved within weeks to a few months. And what we're left with is a 69-year-old at the time brain with multiple problems.
Sure. But looking over the medical history like you did, you see that Terry Sanderson continued to try to seek treatment for something that was going on that he attributed to be fairly related to this accident, correct?
I would say that medical attention seeking behavior started before, and evidence by his primary care physician visit the 3 weeks earlier, and that was likely a ball that was already rolling.
So he was interested in his health before the ski crash. You've testified to that, correct?
Yes.
So he would be very interested in anything that he viewed to be very acutely changed. Isn't that also correct?
Yes.
So it would be part of that pattern to continue going to the doctor a lot up until you think that you're going to get some sort of resolution of your symptoms. Isn't that correct?
I don't suppose to know what was going on in the plaintiff's mind.
Okay. Thank you very much, Doctor. I appreciate it. Out from the back here. Last question. What do you perceive to be Terry's life expectancy going forward?
I have no information to base a opinion on that.
Thank you, Doctor.
Mr. Owens?
I'm going to read you what you told me your opinions are on redirect or on direct, and then I want you to tell me if anything has changed as a result of cross-examination. The compelling evidence is that plaintiff's concussion was mild and that he lost consciousness only momentarily, if at all. Is that still your opinion?
Yes.
Plaintiff's post-collision neuropsychological evaluation shows no evidence of impairment. Is that still your opinion?
It is.
None of the plaintiff's medical records support his claims that perceived symptoms of cognitive decline are related to the ski collision.
At this point, yes.
Another way of saying that is all current symptoms are explained by his pre-collision aging and degenerative diseases.
Overruled?
Much more likely than not, yes.
Then you were asked about a new word. Confabulation, like lying. You were asked about that, right?
Yes.
Did you review the deposition of Jenny Sanderson, the daughter?
Yes.
Did you observe she said that her dad would, in fact, be dishonest in order to get money?
Yes.
Objection.
Beyond the
That's
scope.
not an evidence.
No, that's not an evidence.
It is.
Jenny Sanders is not an evidence.
Yeah. Overruled?
And that he seeks attention and that the notoriety of this case makes him feel powerful. Did you read that?
I did.
And on our little break, you said it's outrageous. You said something was outrageous, that they would assert something. What? Do you remember what it was? His current conditions are related to the ski collision.
What's
Am I throwing you?
now? I'm picking my words very wisely.
Thank you.
The neuropsych evidence and the psychiatric evidence have long evidence to support that when a concussion like this alleged concussion lasts over months, there is a high concordance rate with the patient being involved in litigation and also media attention. Both
beyond the scope of his proffer testimony.
Overruled. Just asked how he explained the post-accident.
Both of which are hyper real in this case.
Hyper real means what?
Very well, real. Very real.
What is hyper real? I missed it.
So it's just a colloquial
Term.
for extremely, so extremely real.
What is again extremely real?
The factors of this litigation and the factors of the media attention around his concussion case.
So what of those things is hyper real? What are they doing to him about his current symptomology?
Well, so
I'm trying to understand his response, Your Honor.
Overruled. It goes to the weight.
You gotta dumb it down for me, please.
the fact that this is the first legal case that is ever televised in Utah makes it hyper real.
In what way to Mr. Sanderson? What is that doing to him, those facts?
Foundation, Your Honor.
I'm just trying to understand his comment.
Maybe you could go into a little bit more of the background behind this opinion?
Yeah, I'm trying to understand the point you're making, and then what it's based on. So you're saying this very litigation and the media attention is impacting Mr. Sanderson. Is that your opinion?
Overruled as a preface to the question?
Absolutely.
Okay, and then how?
So the litigation, so a lot of money is in play here.
And how is that affecting Mr. Sanderson's symptoms?
Foundation, Your Honor. He can't
Sustained?
So I'm being told to sit down. Have a nice day.
Mr. Sorensen?
Just one question for you, Doctor. Is hyperreal a medical term?
No.
Okay, so that's has no basis in any sort of medical literature.
I would say extremely real, extremely relevant.
Okay, but again, you never conducted your own psychological evaluation of the plaintiff, correct?
No.
Okay. So that would be pure speculation about his motives or anything like that?
Based on a number of studies and meta-analysis of cases similar to this.
So case studies, but nothing directly attributable or applicable to Dr. Sanderson.
Case studies So meta-analysis of actual things that are in the medical literature.
Great, thank you very much.
Okay, you may step down. Thank you. You ready for your next witness, or should we take our last break?
Your Honor, definitely let's take our last break.
Okay, we'll take a short recess. Short recess, thank you. I can see that.
We've come up with a plan for Carrie Oaks.
Good,
I guess I'm gonna be Carrie Oaks.
okay.
We just have to figure out who on our side is going to read the questions. Because there's only one additional question that was added by Wayne Owens, we're just gonna have the same lawyer read all of the questions, and I'll respond as Carrie Oaks.
So Noreen could do it.
Well, that's what I had asked.
You good?
Or
Sure.
Bob would.
I think it's nice to have both, of one member from each
You
team.
guys decided that. To read it.
So I have the hard copy. Are there any objections?
I don't think there are on the mark.
Okay, I'll follow along if you'll
Yeah.
key me in on where you're at.
Yeah, there's some, like, objection calls for speculation, but I think we're good with everything.
Okay, thank you. We're taking a short break before you begin.
Your Honor,
Yes.
one other thing on Dr. Richard Bain on rebuttal. We don't know this yet, but we would like to propose that to hit Dr. Bain, and if it's okay with the court, that we have him testify at 9 or even 8:30, 8:45 Thursday morning for a very short rebuttal.
Can we deal with this at 5?
Let's do it at 5. Thank you.
Well, it's hard for us to propose it if it's not approved, and,
You mean he's waiting for the word from you?
well,
That's part of it, Your Honor. He's
yeah,
trying to
this week
schedule
is
it.
his wedding. He had an emergency medical procedure.
Is his wedding?
His
His
daughter's
daughter's
wedding.
wedding.
Oh, okay.
His daughter's wedding. He had an emergency medical procedure. We notified the opposing counsel about 3 or 4 months ago that he couldn't do his, attend trial, and so,
Well, I'm not sure when your rebuttal case is, but if that's when your rebuttal case is, that's fine. We can come a little early
So,
on Thursday. If that's not when
we
you're,
deal with this at 5?
Yeah, we can do
I'm
it.
not in the zone.
getting back to Carrie Oaks, the witness, how are you going to allocate the time between the parties?
based on the time of the questions that they asked.
Well, the
So
thing is,
apparently there's one question for the defense and the rest of it's for the plaintiff. So however that works out to be.
Ours was about 15 minutes long. They proposed, I think, like a half an hour, 45 minutes of additional questions.
So we didn't call her, we didn't block her.
You had designated her as a witness, and we only wanted 15 minutes. If you want to just let us do our 15 minutes, and then we'll do yours.
Why don't we do this, counsel?
Noreen has a comment in response to that.
Yeah, so this is not going to take us 45 minutes to read the portions we've designated.
So let's go ahead and change questioners depending on which side has asked for that question, and then I'll be able to keep track of the time.
Oh, we didn't do that. We just marked jointly the time. It's literally, Your Honor, I would say their time is probably 5 minutes of the 15.
Total. Are you fine with 5 minutes? Okay. Then 5 minutes of the time will go to the defense and the rest will go to the plaintiffs.
That's good.
Okay, I wasn't involved in theirs.
All right. Thank you.
Thank you, Your Honor.
matter, Your Honor?
Let's wait for the other side.
Would you like me to go get them, Your Honor?
Yes.
Or is, okay. I'll
Yes,
be right back.
please. Thank you. Are we on the record?
Yes, we are.
Okay, we're back on the record. Council are present and parties are present. Mr. Owens?
Yes, thanks. So we're thinking this Carrie Oaks is going to go about a half hour, and then we're trying to figure out how to best use that other half hour.
Sure.
One option is, well, here's the question. How strictly, we now have essentially one full day of evidence left. How strictly are you keeping us to like 4 hours each left?
Strict.
Strict.
So when you run out of time, you're done.
Okay, so,
And I'm trying to be mindful of the jury.
so depending how much time is left, then we'll call Terry Sanders back to the stage, back to the pulpit.
We talking tomorrow?
No, if we have time before
Tonight, okay.
5.
Okay. Okay.
Thanks.
All right. Ready for the jury?
I assume that you'll explain to the jury what we're doing.
I will.
Okay, thank you.
Do you want to go ahead and take your seat?
Yes,
Okay.
sure. Do you swear me in?
That you'll read? No, I think not. The lawyers will point out any errors in your reading.
It's better than swearing at you.
What page are we starting on?
So,
We are starting.
the funny thing.
Okay.
And we're gonna try and, say, if you jump to the next page, we'll let you know.
Good.
Because it does jump.
Right. Thank you. And who's doing the questioning, Ms. Abarama? Okay.
Use your deepest voice.
I can do without the commentary. Thank you.
Don't make objections.
Thank you. You may be wondering why Ms. Van Orman is seated as a witness. We are now going to read a deposition, old school style. So the witness name is Terry Oaks.
Carrie.
K-
K-E-R-I.
Thank you for that correction. It's listed two ways in here. Carrie Oaks, and the person that will be reading Carrie Oaks' part is Ms. Kristen Van Orman, and the questioner will be Ms. Abarama. You may proceed, starting on page 6.
Judge, would you like me to state the page number and the line number?
I think if you, right now, just, whenever you skip areas, tell me where you're going.
Okay.
And probably
But
just the
otherwise, you-
page, don't need to do the lines.
Will
Yeah.
do. All right, starting on page 6. Good morning, Miss Oakes. Could you spell your name for the record?
Yes, it's Keri, and Oaks is Oaks.
And do you know about what year you started working at Deer Valley?
It's page 12, Your Honor. 1990. Actually, that was about that area, give or take a couple of years.
Page 16. Okay, when we talk about the incident or the ski collision or the ski crash or similar words, let's just agree right now that we're talking about the incident that occurred on February 26, 2016, involving Gwyneth Paltrow and my client, Terry Sanderson. Is that clear?
Yes.
Okay, now I would like to go through some of the parties to this case. Do you know my client, Terry Sanderson?
Not beyond seeing him on the hill that day.
Okay, have you had any other contact with him prior to that or subsequent?
Where I spoke with him, or no?
Okay, what about Gwyneth Paltrow? How long have you, or before this incident, do you know Gwyneth Paltrow?
That may have been the first time that I skied with her family. I don't recall exactly how many days I skied with them.
Page 18. Okay, 1 or 2 ski trips you've skied with Gwyneth Paltrow, correct?
Correct.
Sorry, if you could speak up.
Correct.
Okay, what about Brad Falchuk? Do you know who he is?
Yes.
Did you ski with him on the ski trip that involved this ski crash?
In what capacity?
I mean, did you meet him?
Yes, we met him.
Okay, and I understand you were teaching primarily one of the children with some of the children. Is that correct?
Not his children.
Okay, whose children were you teaching?
Gwyneth's.
And who are they?
Apple is specifically who I was with.
Okay, and were all of the ski trips with Brad Falchuk and Miss Paltrow's children, they were all on the trips with Gwyneth Paltrow, correct?
Correct.
You didn't ski with Brad Falchuk or the children on the trips where Miss Paltrow was not there, correct?
Correct.
Did you know who Greg Ramon is?
No.
Do you know who Eric Christensen is?
Yes.
How do you know Eric?
Through Deer Valley, we work together.
How long have you known Eric?
Since, I don't know the exact amount of years, but most of the time that I've been an employee here, I've known him.
Page 31. What did you discuss on the day of the collision with Eric Christensen?
In particular? What in particular?
Anything about the collision with Miss Paltrow and my client, Terry Sanderson?
A relief that everybody was safe.
And who was everybody?
Everybody, meaning both people who collided.
Miss Paltrow and Mr. Sanderson?
Yes.
Page 53. So just before the ski collision, please describe what was happening. Had you all met at the top of Flagstaff Mountain, for example?
Yes, we got off the chairlift, decided that we were going to go down to lunch, and...
Can I interrupt? When you say we got off the chairlift, who is we again? Just so we're clear.
The we would have been Gwyneth, Apple, and I were on the chairlift. I believe that Eric was with Moses. Then we met up with Brad, and I cannot remember exactly where his kids and their instructors were. They may have been down already, having the table for lunch, so we decided to go ski down Bandana to the Empire Lodge for lunch. Then as we started skiing down Bandana, it was not crowded at all. There was really nobody on the run. And Moses and Apple wanted their mom to watch them, wanted to do the side of the run, and she could see them ski. So we stopped to cross the run. The run was clear. There was nobody in front. It stands out in my mind because that's a rarity. Bandana was empty where we were, and so we had just crossed the run. And as I looked before we crossed the run uphill, there was really no one in sight, except farther up by a slow sign from where we were. And we crossed, made 2 turns, and then I heard the sound and looked over, and that's when I saw that they had collided, and we were both on the snow.
What was the sound you heard?
Just I heard her voice, and that's what caught my attention.
So I want to just go back over this slowly.
No, you just go to 56. Oh, sorry.
You inserted a word inadvertently.
I apologize. Then I heard the sound and looked over, and that's when saw that they had collided and were both on the snow. Go ahead and just read the rest of the page, that's fine.
And what was the sound you heard?
Just I heard her voice, and that's what caught my attention.
So I just want to just go back over this slowly. You started skiing down Bandana without Apple and Moses, correct?
I'm sorry, which page?
Still on 55.
Okay.
You want to ask that one more time?
Sure. So I want to just go back over this slowly. You started skiing down Bandana without Apple and Moses, correct?
And Gwyneth and Eric, correct.
And you said you crossed the run. Was that near the top of the run?
Near the top of the run.
When you say you crossed the run, does that mean you went skiers left?
Yes, we were on skiers right, and then we had slowed down, or actually, I believe we might have even stopped enough that we were in a group. And then I looked uphill before we crossed, just to make sure it was safe. And then the kids and Eric and I crossed the run.
To the left?
To the left, to skiers left.
And were Eric and you above Apple and Moses when you did this?
He was behind. He was above hill, and I was more to the side and a little above hill.
And then what happened after you started crossing to the left?
We crossed to the left and started skiing down the side, and then we heard, after, as I said, 2, maybe 3 times, heard the sound of, it was more Gwyneth sounded surprised. It was like a surprise sound, and, we looked over, and they were both on the ground.
When you started to cross to the left, did Miss Paltrow then go straight down to the right? Is that what she did?
She stayed on the right, but she did not go straight.
Were you able to see her while you were watching Apple and Moses?
Yes, I was able to see her.
How was she skiing?
She skis small, radius turns, consistent speed. At this point in time, it was slow because she wanted to be able to see the kids. They were not skiing fast because the kids are not fast.
Was she then going to stop and look up, or was she going to look to the left? Do you know?
She was not going to stop because we were skiing.
Okay. Is it your understanding Miss Paltrow was going to look to the left while she was skiing to her children skiing?
No, I cannot say what she was going to do. They were in her sight, and the goal was to ski down to the lodge for lunch.
When did the topic of Miss Paltrow watching her children come up?
Watching her children ski.
Excuse me. When did the topic of Miss Paltrow watching her children ski come up?
It was, Mommy, watch me, and we want to go ski this, and so we took them to the side. It wasn't a detailed plan on how she was going to watch. It was just a plan to ski down to the lodge.
Okay, and when Eric, Moses, Apple, and you started skiing to the left, was Miss Paltrow skiing on the right?
Correct. She was skiing on the right.
Page 68. Was Miss Paltrow agitated?
When she was first getting up, because she was very surprised and shocked, because that was her comment, was that he hit her.
What was her comment?
Her comment was that she was hit and was frustrated, but then as she got up and she checked on him. He checked on her. Everybody was quite calm. Nobody was agitated or yelling.
When did she ski off, Miss Paltrow?
I don't recall exactly. I believe she was there for most of the time, and yeah, she was there for most of the time. I think that when it was verbalized that everybody was okay, Mr. Sanderson verbalized to us that he was okay, he was fine, and that was his response to her checking. We checked. Ski Patrol checked. And so then at that point in time, that's when we said, okay, let's start. We can start dispersing because everyone expressed and we were acting as if they were just fine. It was just a collision, no harm, no foul.
And earlier you mentioned that Mr. Sanderson got up. Do you recall anyone helping him get up?
We were there, both Eric and I were there to help him. I don't recall that he didn't need us to lift him off the snow. I don't recall needing to give much assistance, but we were there for both parties to help them both and make sure they were both okay to our abilities and then assess him. From then, we would assess if there was the need for ski patrol to be called, but they happened to ski by and check themselves.
Page 71. And why didn't you write an incident report that day?
Because nobody, to our knowledge, nobody was hurt. Everybody left the scene on their own volition and everybody was able to leave. And it was, again, like just any other incident where people, got tangled up and everybody was okay and everybody left. And so.
Page 82. Did Gwyneth Paltrow say she didn't see Terry Sanderson before the collision?
She did not use that. I mean, he wasn't in front of her, so he was not in front of her, but she didn't use that phrase. She said, he hit me.
You're assuming she was in front of him, correct?
I saw that there was nobody in front of her when we were skiing, and so that's not an assumption. There was nobody on the hill with us in our immediate vicinity.
Page 106. Miss Oakes, just before the collision, Gwyneth Paltrow's children, Moses and Apple, wanted her to watch them skiing, correct?
Yes, we were skiing together down the final run, down to lunch.
Miss Paltrow was skiing down to the right, looking up at her children to see them skiing, correct?
She was skiing down on the right side. Her children were in her periphery.
Can you orient me one more time to what page we're on?
Sure, now we're on page 107, starting on line 14. So she was looking over at the kids to see them ski.
I can't say exactly where she was looking. They were in her periphery. She could see them while looking ahead to ski.
So Miss Paltrow was distracted, looking at her children while she was skiing just before the collision.
I would not say, I can't say that she was distracted.
Was Miss Paltrow looking at her kids while she was skiing down Bandana Run?
When I saw her, she was looking ahead at the run in front of her.
Was she also looking at her children skiing?
I did not see her looking at her children.
So Miss Paltrow was distracted when the collision occurred, looking at her children, correct?
She's not looking at her children when I saw her. She was looking ahead, skiing down.
So she wasn't watching her children. Is that what you're saying?
Yeah, I didn't. They were in her periphery. I don't know what she was looking at directly. I don't know that she was looking at them directly. She was looking ahead where she was skiing when I saw her.
At the moment of the collision, though, you had not seen her for 3 to 5 seconds, correct?
Probably 3 to 5 seconds.
So you don't know where she was looking, other than she was supposed to be looking at her children, right?
I don't know exactly where, that she was looking directly at them. I do know that when parents ski with their kids, it doesn't mean their eyes are glued on their kids. They can glance at them. They can see them in their periphery. And as long as the kids know the parents are there and they're in their visual, that's what the kids want. I don't know exactly what she was doing. The children were satisfied.
Moses and Apple wanted their mother, Gwyneth Paltrow, to watch them ski down Bandana, correct?
That's what they had said. Watch us ski this, Mom. Okay, that was the conversation.
Page 111. Okay, and then maybe you already answered this, but in that, when you last saw Miss Paltrow, the 3 to 5 seconds before the scream, did you observe whether there was anyone below her on the ski hill?
I observed that the area in the front of her was empty.
I think that's it. 111.
And that's it?
Okay. Thank you.
May I be excused, Your Honor?
You may.
Thank you.
That's subject to recall, right?
Right. Mr. Owens, you may call your next witness.
Thanks, Your Honor. Could we have a quick bench conference here?
Yes. Okay, the parties have stipulated a fact, and it looks like it will save us some time. Mr. Brad Falchuk, who may or may not testify later, depending on how much time there is left in the case, the parties have stipulated that he would testify were he to be called as a witness, that he did not see the accident. Is that correct from the plaintiffs?
Yes.
From the defense? Did the court correctly?
I believe so.
Okay.
He may or may not be called if there is time. Thank you.
All right, thank you. And so we'll now move to the defendants have a deposition to read.
Yes, we're going to try to get to the two kids' depositions. First,
Are we reading the entire deposition or marked
no, the marked version, Moses. So we're calling Peter as a fake Moses to the stand.
Okay. So
Steve,
Peter will read
have a
Moses.
marked copy? I don't think I have a marked copy.
And I'd like the lawyers to each read their side of the questioning so that we can capture the minutes used by each side.
I just need to get my copies back that I gave to them.
What if we, because we don't have two marked copies because we're doing this on the fly, what if we have, we'll read Apple, Moses, all the marked part, and you read Apple, all the marked part.
That's fine.
Let's do this.
Yes. Oh, that's right. That's right, they're not.
Actually, we're gonna share a copy.
You know what? You better keep it. Yeah, just in case.
Okay, this is kind of weird, but I'm the questioner and you're Moses.
Correct.
Do you recall how old you are at the time?
You need to start, tell us what pages though, please.
Thank you, page 7.
Let's just make sure that's where we're starting. Yes, page 7.
Line 22. Do you recall how old you were at the time?
9.
Okay, I'm turning the page.
I need to clarify that for me.
We're going to back up because there's some gray. Could you just spell your name for the record?
Protected identity.
Okay, so we all stipulate this is Moses Martin. I'm on page 7. As you know, we're talking about this ski collision that occurred about 4.5 years ago. Are you familiar with that?
Yes.
And I'm going to pick up where I was. Do you recall how old you were at the time?
9.
Okay, and you recall this ski trip in February of 2016, correct?
Yes.
About 4.5 years ago, correct?
Yes.
Okay, you recall skiing that morning that your mother was involved in the ski collision, correct?
Yes.
I'm now turning the page to page 9 at the bottom. Okay. When this ski collision occurred, do you recall where you were at the moment the ski collision occurred?
I do not recall where I was at the moment it occurred.
Did you see the ski collision?
I did not see the actual collision.
Okay, so let's just start maybe at the beginning of the run. You got off a chairlift, correct?
Yes.
And the run is called Bandana. Are you familiar with the Bandana run?
Yes.
Okay, at the time of the collision, did you, or just before the collision occurred, you were skiing from the top, is that correct?
Yes.
And who were you skiing with?
From what I recall, my instructor, Eric. Page 11.
Page 11, line 22. And you were skiing with Eric as your ski instructor just before the collision, correct?
Yes.
And do you recall who else was skiing with you at that time?
No.
Was your sister AM, meaning Apple, nearby?
Yes.
Do you know where she was in relation to you on the hill?
No.
Could she have been below you?
Yes.
You don't recall seeing your sister?
Not exactly, no.
Tell us what happened on the bandana run just before the collision. What do you recall?
I recall skiing with my instructor and briefly seeing the collision. And then he skied over and I followed him. And I saw my mother and a person behind her that he had crashed. Who had crashed?
Okay, did you hear a noise before the collision?
No.
And the person behind her, was that a man?
Yes.
Moving to the top of page 13, was this person uphill from your mother?
Yes.
How close were they, your mother and this other man?
As I recall, decently close.
Let's just say, this close, see my hands, they're about a foot, about 14 inches apart, or were they further apart?
I think something like that, but I'm not 100% sure.
Were they touching each other?
I do not remember.
Was her head above her skis, so her head was uphill and her skis were downhill?
Yes.
And the man that was nearby her, where his head where was his head in relation to hers or to his body? Was his head uphill or downhill?
Uphill.
So I'm just going to go back a little bit. So when did you first realize your mom was involved in a collision? How did you realize that?
I realized the equipment that she was wearing because I know that she wears what she wears when she skis. And then I realized that it was my mom. So I was standing around. I realized that it was my mother.
And did you hear a noise that told you there was something going on, a commotion or anything?
When I skied over, I heard my mom yelling at the guy.
What was she saying?
She was saying something along the lines of, "What the F word? You just ran into me."
And anything else that you recall at that moment?
No.
Was she standing up when she said that?
I do not fully remember, but I believe she was on the ground lying down.
Okay, did she get up by herself?
I do not remember.
I'm just going to go back in slow motion to, let's say, 3 seconds before this collision occurred. You were skiing with Eric. If you're facing downward, skier's left is on the left side and skier's right is on the right side. Do you know which side you were on the hill just before this collision occurred?
I was on the left side.
Do you know how far on the left you were?
No.
Do you think that...
But farish.
Okay. Were you closer to the left edge of the ski hill?
I believe so, yes.
And do you recall anyone else on the hill at that moment?
I do not remember.
Were there other skiers on the hill?
Yes.
About how many?
I'm not sure.
And so, what made you ski over to your mother? Did someone tell you?
I was following my instructor, but I did not know what was going on.
So you followed your instructor over to where your mother and this other man were lying down, correct?
Yes.
That scene, your mother and this man laying down, what else do you recall?
I recall skiing over, seeing a few people around them. I remember my instructor seeing what was happening. And then I remember my mom on the ground downhill of the man that was uphill from her. And I recall that they were both on the ground at the time that I skied over.
About how far away do you think they were?
I do not recall. About a foot, maybe?
I'm asking how far apart your mother and the man were when you skied over there.
I'd say a foot, maybe more.
Were they touching?
I do not remember.
And do you remember your mother getting up?
Yes, but not for a while.
Okay, how long was a while? Like, 5 or 10 seconds?
I'd say 2 minutes, maybe.
And how did she get up?
I do not remember.
Did she get up by herself?
I do not remember.
Did someone help her?
I do not remember.
Do you recall a large man next to the ski collision location?
I do not remember.
You said there were some other people there. What do you remember?
I remember seeing a few people, not a lot, but maybe 3 people, including my instructor.
So there was your mother, the man that was involved in the collision, and then there was your instructor. Were there any other people?
I believe so.
How many other people do you think?
I do not recall.
Like, was there 1 or 2 or 3 or 4 maybe?
I do not recall.
And then what did you do after you skied down to your mother?
I stood there wondering what was going on, and then I believe that afterwards we went to eat lunch.
I remember it. And who is we?
As I remember, it was being me and my instructor, and I'm not sure whether my mother came down afterwards or with us.
So you skied down with your instructor to the bottom?
Yes.
Of the hill?
To lunch.
So you skied down the hill with your instructor, Eric Christensen?
Yes.
Anyone else ski down with you?
I do not remember.
Just before the collision, your sister was somewhere in the area skiing with you?
I believe so.
Anyone else in the area?
I don't remember.
Do you recall Apple's ski instructor?
No.
Do you recall her being present, the ski instructor for Apple?
I don't remember.
Do you remember Apple's ski instructor's name being Carrie Oakes? Carrie?
I believe so.
So was anything said when you came down to the collision site where your mother and this man were?
My mother said to the guy, "What the F word, you just ran into me."
And then anything else that you recall?
Not that I recall.
Were people talking?
I believe so.
Was the man talking?
I do not remember.
When I say the man, I mean the man that was involved on the ground or the snow next to your mother. I think it should be on the snow next to your mother, correct?
What do you...
When I say the man next to your mother, the person that was involved in the ski collision.
Yes.
So that's...
I do not remember if he was talking or not.
Okay, do you remember if your ski instructor, Eric Christensen, was talking?
I do. I don't have a closer memory on that, no.
Did anyone besides your mother say that they had seen the collision?
I do not remember. I do not remember.
Do you remember talking about the ski collision at the bottom of the hill?
Vaguely.
What do you recall?
My mother saying that she got hit or ran into.
You said you went to lunch afterwards, correct?
Yes.
Did you discuss the ski collision at lunch?
I believe so.
What do you recall?
Not much.
Who was at lunch with you after the ski collision?
Oh, the only people that I remember are my sister, my instructor, and my mother.
Since the day of the collision, have you talked about the ski collision with anyone? Anyone else you've talked to about the ski collision?
I don't remember.
Do you think you might have talked about it with some other people?
I don't remember.
I'm now on page 25. When you skied down to the collision site before you left, did you notice any ski patrol or medical people come by?
I do not recall.
Do you recall any other people in green uniforms at the collision site besides your ski instructor?
I do not remember.
Before the ski collision, do you recall saying something to the effect of, "Hey, watch me ski"?
No.
Have you ever said something like that?
No.
After the collision, this is bottom of page 26. After the collision, when you were watching your mom and this man on the ground, did Eric appear angry at all?
Not at all.
Was he yelling, raising his voice, shouting, anything along those lines?
No, not at all.
Why are you so sure? It seems like your memory's a little faded in some areas, which is okay and understandable, but I want to know why you're so sure about this.
Because I remember him addressing the situation very calmly.
How so? What stands out to you?
He tried to find out what was going on and try and see how he could help everyone. He tried to help everybody get out of the situation safely, and yes.
Do you remember anything specifically he said?
Not specifically.
I think plaintiff's counsel, Lawrence, asked you some questions about, they were sort of vague about what have you seen? Said, hey, watch me ski. Maybe a better way to put this question. Have you ever told your mom, hey, Mom, watch this, before you decide to do something on your skis, if you'd like her to watch you ski?
I do not recall saying things along the lines of that.
Did Eric help your mother stand up?
I do not remember.
Do you remember Eric helping up the man that was involved in the collision?
I do not remember.
Do you remember skiing down with Eric after you left the ski site?
I don't know if it was exactly Eric, but I did ski down alone. I did not ski down alone.
Okay, how close were you to Eric as you skied down towards your mother when you realized there was some commotion or incident?
Close. I skied closely to him.
And then you stopped near your mother?
Yes.
And then how long after you stopped did you ski down? Was it like a minute or two?
I do not exactly remember. My best guess would be somewhere along the lines of 2 or 3 minutes.
So you were standing there about 2 or 3 minutes, you think?
I think so.
That completes the questioning, Your Honor.
Thank you. You may call your next witness.
Do you want to play Apple and you ask the question?
They're going to read another deposition of Apple.
Is that okay with you guys if they just do it?
Yeah. Just let us know the pages, because remember, I don't have a fully marked copy.
Thanks.
Can you just spell your name for the record, please? Oh, sorry. Page 11, line 13.
Protected identity.
And your last name?
Protected identity.
Okay, you understand that this is a lawsuit involving a ski collision at Deer Valley on February 26th, 2016. Are you aware?
Yes.
Microphone more toward the center of the two of you. Thank you.
Sure.
Okay, page 12, line 3. Okay, and do you recall this event back in February 26th, 2016?
Yes.
Okay, how old were you back in 2016? Were you
11. No, 12.
about 11 or 12?
Yeah. Yes.
Okay, what was your skiing ability at the time?
Intermediate, beginner,
Okay.
somewhere in between.
About how many times have you skied approximately for this date in February of 2016?
4 times.
Page 15, line 10. Okay, and do you remember your ski instructors on that trip?
Yes, we had Carrie, Preston, and then my brother's instructor, who I can't remember the name of, and one more female instructor that I also cannot remember the name of.
Page 16, line 7. Okay, that morning, do you remember skiing with which instructor?
Carrie.
Okay, and your brother was skiing with another male instructor, I think you said, correct?
Yes.
I'll just represent to you that his name is probably Eric Christensen. Does that refresh your memory?
Yes.
17, first line. Okay, so do you recall that the morning of February 26, 2016, when you were skiing with Eric and Moses and
Yes.
Carrie, where had you been skiing that morning before the incident with my client?
We were on the mountain
Carrie.
at the hotel, and that we were at. It was a ski in, ski out type of thing. We were mainly on the greens and blues.
Do you know about how many runs you had skied before the incident?
5 or 6, I'd say.
And were you skiing with Carrie that whole time?
Yes.
Was your mother skiing with you at the same time?
Yes.
Did your mother ever ski different runs when you were skiing with Carrie?
I don't remember.
Okay, your brother Moses, about what level is he as a skier?
Beginner?
Okay, now I'd like to go to the bottom before the ski collision that's subject of this case, okay?
Okay.
So, you were at the top of the ski hill, and I believe the run is Bandana. Do you recall the name of the run?
Yes, it was Bandana.
And why do you know it was named Bandana?
It was our favorite run.
Page 19. And you remembered the ski run because it's your favorite run, correct?
It was, yes.
And it was also the run you go down to the hotel you were staying at.
Yes.
Okay, next I'm going to ask you what you recall happening on that run, but before, do you recall this ski collision?
I did not see it, but I recall the events following it.
Okay, well, what was going on during the time just before the ski collision?
We were on our way to lunch at the lodge.
And who were you with?
I was with my instructor, my brother, my stepfather, my mother, my step-siblings, and their instructors. But we were all a bit scattered on the run, so some of us were in front, others were trailing behind a bit more.
And who was with your group?
I was ahead with my instructor, my stepsister, and her instructor.
Was Brad Falchuk with you?
No.
Sorry, that's page 20. So, just to clarify, at the time of the collision, there was you, Carrie Oakes, your ski instructor. There was IF, and then there was IF's instructor, who we don't know whose name yet. And then there was also your brother's instructor, Eric Christensen. And then there was your brother, Moses, correct?
Yes, but I was not with Moses and Eric. They were a little up the run. I was closer to the lodge at the time.
21. About how far away were you from your brother Moses, as you recall, just before the collision?
I would say I don't really know how to say it. I was further down the run. They were in the middle of the run. I was towards the end with my stepsister. I was not with Moses or my mother.
And did you know when the collision occurred?
Not the exact time, no.
Did you hear something before the collision?
I don't remember.
Did you hear a scream?
I did hear some commotion, but I was further down, so I decided to continue to go down to the lodge.
Okay, so when you heard the commotion, is that what you think is the collision?
Yes.
And when you heard that commotion, did you look anywhere?
I don't remember.
Did you see your mother after you heard the commotion?
Again, I don't remember.
So I'd like to know just the couple seconds before the collision, and then the couple of seconds after the collision. So only about 5 seconds of time. So you heard something, a commotion, right?
Yes.
And then did you see anything?
I don't recall if I had seen anything or not. I think that I did, but I don't remember.
Okay. And when you heard that commotion, you're with Carrie Oakes, your ski instructor, right?
Yes.
And where was she in relation to you? Was she above you or below you?
I believe she would have been in front of me. That is usually how we skied. She would lead me.
We're on 23 now. Okay, so the 5 seconds around the commotion that you believe was the collision, you were with Carrie Oakes and IF, and then the 3 seconds afterwards, what did you do at that point?
We continued to ski down to lunch.
And did you know at that time that there was a ski collision?
No.
When did you first learn that there was a ski collision?
When my mom had arrived at lunch after we had gotten there, about 5 minutes after.
And how did you learn about the ski collision?
My mom told me. She told us what happened.
What did she say?
She said she came in and I noticed that she looked a bit shocked, and I asked what had happened, and she said, "This a-hole ran into me. He ran right into my back." And I remember she did this motion saying that he ran into her back, and they both went down. But I remembered that's what she said.
24. So let's go back to the moment of the collision or the commotion. You heard the commotion. You didn't see the collision, but you continued to ski down.
Yes.
Did Carrie Oakes ski with you?
I believe so, yes.
And she skied with you down to the bottom.
Down to where we were eating, yes.
Okay, and when I say the bottom, I mean the bottom of Bandana Run, which is where the lodges and the
Yes.
eating places are. Is that clear?
Yes.
And so right after the commotion, Carrie Oaks, IF, and you skied down to the bottom of the Bandana Run, correct?
Yes.
And who is at the bottom of the run when you got there?
I don't remember. I just know that we were meeting everybody to eat.
Okay, I'm sorry to keep going back to the commotion. Did you see anyone else on the ski run at the time of the commotion?
Well, there were other people skiing, but again, I didn't really pay attention to what had happened. I just heard some sort of screaming going on above me, but I continued to ski down, and I don't remember if I turned around or not.
Okay, did you recognize the screaming? Whose voice was it?
It sounded like a woman, but we were so far down, I couldn't really put anything to it. It wasn't very clear.
Okay. How soon after you got to the bottom did your mother arrive?
I would say 5 to 10 minutes.
So you were waiting for her at the bottom?
Yes.
And what about Brad Falchuk? Was he with your mother when he arrived at the bottom?
I believe so.
Did he arrive sooner than she did?
I don't remember.
Well, I'd like to go back to the commotion and just let you continue and tell us, to the best of your memory, what happened. So you heard the commotion, and then what happened?
And then we continued to ski down, and we got to where we were eating lunch. We started to take off our gear and then sat down. And then shortly after, my mother, Brad Falchuk, my brother, I can't remember if my stepbrother was there or not, but everybody else followed in after I had arrived.
And who is everybody else?
To the best of my ability, I'm pretty sure it would have been my mother, my little brother Moses, Brad Falchuk. I would say 1 or 2 more instructors, and my stepbrother BF.
Okay, do you recall which ski instructors were there?
Again, I remember Carrie, my instructor, Preston, who skied with BF and IF, Eric, and I believe that there was one more female instructor, but I can't fully recall.
Okay, do you recall anyone else besides the people you've mentioned at the side of the commotion?
No.
We're on 27. So when you're at having lunch, was the ski collision discussed at lunch?
Yes.
And what do you recall about that discussion?
My mom was explaining what had happened, saying that a man ran into her back and they both went down. And she was in a state of shock. And she decided after that she was not going to ski for the rest of the day, which she never does. She always stays on. But she decided to get off because she was in shock, and she was in a bit of pain.
Did Carrie Oaks say anything?
I believe there was a conversation between them. I don't recall what it was about, but it was probably about my mom getting off the mountain.
Okay. Do you recall anything else?
I recall getting back onto the mountain for a couple more runs, and then I got off the mountain, and I think that my mom was getting a massage.
Okay. When you got back on the mountain after lunch, who were you skiing with?
I was skiing with Carrie.
Anyone else?
I don't remember. Maybe my stepsister?
Do you recall skiing with Moses?
I don't remember.
Okay. Were you concerned about your mother at the time?
Yes.
What was your concern?
Well, I never see her really shaken up like that, and she was very clearly visibly upset, and she had some sort of pain. I can't remember what, but she was in a little bit of pain, and I remember that's why she went to the spa to get a massage.
Did you discuss the ski collision with anyone after you left lunch?
I think that my step-siblings and my brother and we talked about it because my brother was closer to the collision, and he had also said that he skied into her back, and they both went down together.
This is Moses. Can you tell us more specifically what Moses said?
Well, Moses was kind of telling us what had happened. I don't know if he for sure saw it, but I know that he was with people that saw it, and so they had told him what had happened and that it was what he said.
He said that my mom got hit in the back. Oh, what did he say again?
He said that my mom got hit in the back and their leg, they both went down together after somebody had skied into her back.
We are on 30. Okay, when you finished skiing, did you discuss the ski collision?
Yes.
With whom?
I believe we talked about it at dinner and after. I was checking in with my mom to make sure that she was okay.
And what did you discuss?
I asked her how she was doing, how she was feeling. She said she was in pain. Again, I don't remember where exactly, but she did say that she was in pain. She had gotten a massage, I believe. So this was around dinner time, and we had just kind of gone over what had happened.
Did she say anything about my client, Terry Sanderson?
She had earlier in the day, not immediately after, but after 5 minutes after we all met at lunch, she said that he had skied into her back, and she called him an a-hole who had skied into her back.
Anything else you can recall?
I remember she was very frantic about it, so she probably said something along the lines of that, but that would be all that I remember to the best of my ability.
31. Okay, when you discussed it with your mother and you said she was frantic, what do you mean by that?
She was in a state of shock. She was very upset, and she was in pain.
Since that collision, have you seen your mother in that state of shock like that since that?
No, not like that.
So you discussed the ski collision that night at dinner, and do you recall you were staying at a hotel suite or something?
Yes, we were in a hotel.
The next day, do you recall what you did?
I believe we skied in the morning. I can't remember if we had left that day or not. The next day, I don't really remember much.
33. And do you recall how many ski instructors were with you at the time of the collision when you started skiing again?
I believe either 3 or 4.
And one was Carrie?
Yes.
And one was Eric Christensen?
Yes.
Was another one Preston?
Yes.
Was there anyone else that you recall?
I believe that there was one more person, but I can't be too sure about that.
Okay. Did anyone tell you they had seen the collision?
I don't think so, no.
Other than your mother?
No.
35. Okay, earlier I think that you said Moses and said other people had definitely seen the collision. Do you recall saying something like that?
I don't think that I said that.
What do you recall Moses saying?
I remember him sort of telling what happened. I don't know if he saw it or not, like saw the actual collision, but I know that he saw my mom on the floor.
I believe I said that he saw my... Let's see. Oh, that's you.
I believe I said that he saw my mom on the floor, but I don't think that he saw the actual collision.
Okay, so after the commotion or collision, you skied down to the bottom of Bandana Run, correct?
Yes, but again, I personally didn't see the collision.
Okay, but you heard this commotion.
Yes.
Did someone say to you ski down to the bottom of the hill after the commotion?
No, we did not think anything of it. We continued to ski down. I don't even know if we stopped.
The we includes Carrie Oaks?
Yes.
Did anyone ask you to wait by the side of the hill after the commotion?
No, I don't remember that I don't know.
That you recall? Do you recall seeing anyone going to help your mother after the commotion?
I, again, did not see the aftermath. I had continued to ski down, but I believe that people did help her.
And what makes you believe that?
Because I assume that she would have needed help up, and she was close to her boyfriend Brad, who is now her husband, at the time, and both my brother's ski instructors and I believe BF's ski instructor. So I'm assuming that they would have helped her.
But Carrie Oaks stayed with you down to the bottom of stayed with you down the bottom of the hill?
Yes.
What about Eric Christensen? Do you recall what he was doing after the...
I believe that he was with my brother, who was near my mom. So he was near the collision.
Okay, and do you recall which side of the hill you were on? Let's talk about skiers left and right. That means that if you're skiing downhill, the left would be the skier facing downhill to their left, and the same on the right. Do you know which side of the hill you were on ski?
I don't remember.
Okay, do you think you might have been in the middle of the hill, or the side, or near the edge of the run, Bandana?
I don't remember.
39. Can you be sure exactly that Carrie Oaks didn't stop and help your mom after the collision, or do you remember that at all?
I don't remember. I think that we were further down because I know that we got to lunch first, so I don't remember.
Okay.
I don't think so.
Do you recall before the commotion on Bandana Run saying something to the effect of, "Hey, watch us ski down the hill"?
No.
Do you recall if Moses said something like that?
No.
Do you recall if any of your other people in your group, like IF or BF, say something like that?
I don't know.
Okay, I'm just going to show you something here real quick. Do you recognize the person on the left there?
That's Carrie.
That's Carrie Oakes,
Yes.
42. So Carrie Oakes was recently deposed, Apple, and she actually has specific memories of being on the scene of the collision. Would you defer to her testimony of specific memories rather than sort of your vague memory that she has with you?
Yes, I could have easily been with another instructor. I believe IF had an instructor.
Lawrence, I think we have a picture of Eric Kenhe, which has a picture of him on the cover of it. He looks a little older than he did.
Oh, isn't he the one? Oh my God, I remember him so well. He was the best. Oh my God, he was the best. He would give us candies and he would tell us, yes, that's Eric.
Would you say he was under 50 years old?
I don't remember. I never really skied with him, so I never really saw his face. That's the end of it, Judge.
Thank you.
Yeah.
So, Your Honor, both Moses and Apple were ready, willing, and able to testify in person on Monday morning, but
Objection. Why don't we address that after I excuse the jury? Okay. I'm going to excuse you now until tomorrow morning at 9 o'clock. I will recess. Please do not discuss this case with anyone, including other jurors. Please do not attempt to learn anything about the case outside of the courtroom, including from other jurors. Please avoid radio, TV, internet, and newspaper reports on this case. Please keep an open mind throughout the presentation of the evidence. And finally, please do not form or express an opinion on the case until such time as it is finally submitted to you for deliberations. Have a good evening. Okay, Mr. Owens, what was it that you wanted to put on the record?
I would always prefer live testimony to reading transcripts, but the kids were not available. And mostly I just want to put that on the record. I was expecting to take over the case on Monday morning, given multiple assurances that I could do so, and I was not able to do so.
The multiple assurances were, if we're done, and we intended to be done. It sounds like some kind of a statement that we didn't do something we're supposed to do. And they took almost as much time cross-examining more on some of these witnesses, and that's why we didn't finish. In my humble opinion.
Yeah, you could have called them live. You still can call them live. But I understand that you wanted to put that on the record, so thank you.
They became unavailable.
All right. So we're going to take a short recess, maybe 5 minutes, and come back and work on jury instructions. Is that right? Okay. Just take a quick bathroom break, and we'll be right back, and hopefully we'll wrap it up by 1/2 the hour.
What time would you like everybody here?
8:45, be ready to go, because once all the jurors are assembled, we can start.
Perfect.
Defendant, oh, wait. Nope. Plaintiff's objections to Defendant Paltrow's non-stipulated jury instructions. The nature of the case we already resolved on page 4.
Just give us a minute, we're trying to find our.
Okay, sure.
We also have an extra copy, because we've had so many different versions. Is there,
I'm working off the one that was filed.
okay.
Your filing, which is your objection.
Do you have the filing date, Your Honor?
It is, I can give you the docket number.
Yeah, that would be good. The docket number is even better.
Plaintiff's objections is docket number 973. Are you with me on the defense side?
Yeah, are we looking at our document or their document?
Looking at their document because it contains their written objection.
Got it.
So starting on, I'm on page 6, defendant's instruction number 9. The Mr. Bueller, are you with me?
Not yet, Your Honor, I'm waiting for
Okay.
it to load. $973, Your Honor? Yep.
Are you with it? Or are you there?
I'm there. Let's see,
Okay.
what page?
It's 7, page number 6, fault defined. So this is the fault definition. Is there any reason why we don't just use the fault jury instruction from the model Utah jury instructions? I see that, I guess both of you started with that, but why not stick with it? Mr. Egan?
Believe it or not, we're still trying to pull this document up.
Okay, all right.
Sorry,
I'm looking at CV 201 on the model Utah jury instruction, 2nd edition.
Your Honor, we have it, and your question was, why not use the model
Right.
instruction?
Why not stick with CV 201?
I think, if I'm recalling this correctly, and it's been a bit, we were thinking that the model instruction doesn't incorporate the counterclaim, so we wanted to just make sure that it was clear that there needed to be a decision about fault for both parties.
Okay.
That's what I recall off the top of my head, Your Honor. So if I'm remembering correctly, it was kind of that second sentence where we say you must also decide whether Gwyneth Paltrow is harmed, and if so, whether anyone is at fault for that harm.
Okay. And there's also an objection to adding the word skiing in the second paragraph, just negligence rather than negligent skiing, because I think their claim is a little broader than just negligent skiing.
I see, because of the post-collision claim.
Right. I mean, I suppose loosely it's skiing because it's part of the skier code of conduct.
Right, yeah.
What to do after an accident, but.
Right, yeah, to me, I guess that's, I don't know that makes a huge difference to the jury. If they see skiing, I think they'll understand that it's the whole part of negligence.
Can you still argue your case if it just reads what the jury instruction does? And the wrongful act or failure to act alleged in this case is negligence.
Your Honor,
Sure.
we think just the generic negligence is used in all sorts of things, from skiing to autos to.
Yeah, you've got that in your brief, in your objection.
Sure, I mean, I don't.
So
Can you still argue what you need to argue?
Yes, I can. Well, this goes to a little bit of trial strategy. Is plaintiff resting? This will help me argue this very issue.
They haven't rested yet because you haven't finished your cross of their client.
So, sorry if I don't know this, but if I say I'm done with my cross, I'm going to call Terry in my case. I can still use leading questions, may I not? May I?
Sure, he's an adverse party.
Yes.
So yes.
So if I agree to give up my cross of Terry, they are agreeing to rest first thing in the morning.
This is not what we're arguing about right here. We're talking about jury instruction.
I actually, this affects my, first of all, I'm entitled to know if they're resting. The judge ruled, Your Honor ruled, that we would know each day's lineup the following day. I think they benefit from just having this open case because it's just this one other witness. And then now it's 2, now it's 3. And I want them to rest.
Well, if you'll decide whether you're done questioning Mr. Sanderson.
I hereby decide.
Pardon?
I hereby decide that I am done.
So do you have any more evidence to put on?
Well, we weren't prepared to talk about that. 2 of our team are obviously not here with us right now. If we can get on the phone with them, we could discuss that and come up with whether we are done and going to put anything else on or not. But I mean, we're here to talk
as I understood it, that was the only.
That's what I understand too, but.
Okay.
We've got 2.
Can one of you step out and verify that while we continue?
Yeah.
Okay, thank you.
Here's
so would you like to come back to this one then after you get that answer?
Yes, I intend to file a motion for a directed verdict on the issue of post-collision negligence.
On what? I didn't hear that, Steve.
On post-collision negligence.
Are you going to file something on it?
Well,
or are you just going to make it?
Depends how much work we have tonight.
Okay, all right. Well, as to this, okay, so then, well, it would be my inclination just to use the word negligence anyway, and you can, and if it ends up that it's only the before and to the collision that's at issue, then you can certainly argue that to the jury.
Okay, if our motion's granted, I would want that tweaked because I don't want them to be confused that there's a post-collision issue. It's only the skiing.
Sure, if there's a directed verdict on the post-collision issue, I think there should be some clarification of the jury.
Yeah, we agree if our directed verdict went
Sure.
too.
Okay, so in the meantime, then, that's the instruction as it will stand, and if the landscape changes, you can certainly ask for an additional instruction or a modification.
Okay.
Turning then to defendant's instruction 12 on allocation of fault. Is this also, Mr. Egan, in order to, well, you've already come to an agreement, it says here, so that one's okayed, right?
Yeah, it looks like that's
Number
correct.
12. Number 13, inherent risk of skiing. I think you've already, well, what's your, you would like the, an inherent risk of skiing instruction, and the plaintiffs don't want an inherent risk of skiing instruction. Is that right, Mr. Bueller?
Correct.
For the reasons stated. Could you just tell me again why it is that you believe you should have one? And have you evaluated the, wasn't there a case that had 3 factors in it somewhere on whether a was it Dutton, that whether a statute creates, whether a statute should be used? In other words, it talks about the protected class that's designed to protect.
Yeah, I do recall looking at that, Your Honor. I also am struggling to remember the particular name.
That might have been, I think it was in the
Donovan.
motions in limine, if I'm not mistaken.
That may be correct. And Donovan, I believe, is it didn't go into a significant analysis of that because it decided not to. The court decided it didn't need to rule on that point, if I'm remembering correctly, and so it just cited, I think, these other cases that you mentioned. And I can look and see if I can find.
And
quickly.
I have Donovan. Can I read one sentence from it, Your Honor?
Sure.
To be clear, we do not establish a categorical rule that an inadvertent fall by itself can never establish negligence. And we overturn RICI, R-I-C-C-I, to the extent that it established such a rule. I don't know if that's helpful, but the way my mind works is that means falls can occur despite appropriate care, and that's obvious.
Okay, I know where that's coming from. I actually marked that here, so. Anything else you want to add to your counter to the objection?
Yes, it is the law. I mean, it doesn't say, when it says you are assuming the risk of collision with other skiers, that is a legislative finding. That's not unique to ski resorts. I think it's just a statement of law. And skiing has inherent risks.
Okay. Anything else on that one? I'm gonna take that under advisement.
I'm gonna look for one other thing.
Okay.
Should we give them an update?
Yeah, an update, Your Honor, and I understand that as I stepped out to make the phone call, the defense said they would not be calling Terry Sanderson again.
Correct.
Is that correct? We don't have any objection to resting right now.
Okay. So
Rest.
so the plaintiff at this point is resting, and we can certainly do it officially in front of the jury so that they can see that you're resting. But
Sure.
but does that resolve your issues, Mr. Owens, going forward?
Yes, it does.
Okay.
Your Honor, in case it's helpful, and you may have already beat me to this, but it looks like Colosimo was the case.
That they were citing.
Yes. So, yeah, sounds like you beat me to it.
Yeah. And I read what they were citing as well, and I'll continue to consider that.
Okay, thank you.
Sure.
I do got one thought here.
Even though my name's on this Donovan case, it was Judge Pettit that made that ruling.
Oh, yeah.
I think I had the,
didn't even notice that
Thank
your name
you.
was
I
on
think
it.
I had the case in case it came back. Yeah.
All right, I found the inherent risks of skiing statute 78B for 402(1). It does say inherent risks of skiing, meaning the dangers or conditions that are an integral part of the sport of recreational, competitive, or professional skiing include, and then it lists a number of things, and one of them under subsection F, collisions with other or skiers. That is a legislative
Can you give us a citing?
finding. 78B4402 sub F. Now, I didn't read it word for word, Your Honor, but changing weather conditions are not part of our case. Variations in terrain are not part of our case. So I went straight to F.
And then how would you respond to that same statute that says that definition of inherent risk of skiing is as used in this part?
Yes.
How do you look at that? It seems as though they're defining the term for this statute.
The main thrust of this section is to protect ski resorts, but it doesn't say anywhere like this does not provide any defenses for skiers, and so the wording works with skiers and skiers.
If I don't approve this requested instruction, it doesn't mean that you can't argue that. It just means that there will not be a legal instruction, and I haven't decided yet, but you certainly can argue that there are inherent risks of skiing, and you can talk about what those are, and you can, as they're tethered to the facts of this case. That's fair game. It's fair game.
I appreciate it. They just won't know it's the law. It is true, and it should come. The law should come from the court.
Correct. And if and that's my decision. Does the statutory definition of inherent risk of skiing contained in 78B4402, does that apply to a skier-on-skier collision liability? Mr. Bueller?
Oh, just if the court changes its mind or considers.
I haven't made a mind.
Yeah, we would like another opportunity to discuss it, but it doesn't have to be done tonight.
Well, I need to know now what your arguments are so I can fully evaluate this.
We would say, Your Honor, it does not apply to skier on skier. That the main thrust of this, as defense concedes, is to indemnify ski resorts for accidents that take place upon their mountains, and not for skier on skier liability. That's always going to be available.
Okay. Thank you. So I'll take that one under advisement, number 13. Next, number 14. This is the one I was talking about earlier. Why not use the
safety rule?
Yeah, the violation of safety law, CV 212. Do you have that handy? The standard Utah jury instruction whenever there's an allegation of an ordinance or a law, a legislative enactment that creates a duty or is a safety law.
That's fine. We're fine with that.
We're fine with that, Your Honor.
Okay.
I'm sorry, Your Honor. I had it and then I lost it. Can you give me the number one more time?
CV 212.
212.
Yeah.
It's under the negligence.
Yeah, we have it now.
And then you take the actual quote from the ordinance and put it in there, the language from the ordinance itself. Do I have a copy of the ordinance?
should, I think we might have it as an exhibit, we can provide that.
Could you email that to my clerk?
Well, they've rested, so we shouldn't be doing new things that haven't come into evidence.
There was a witness that referenced the ordinance.
Right. I'm not sure.
And this is law.
But the document is a safety law. I don't know that any witness so testified.
Yeah. I believe Walker did, and I believe it came up with at least one other witness that I recall. I don't recall which one specifically right now.
I don't believe
So
Bogger did.
It's in Plaintiff's Exhibit 38.
What's Plaintiff's Exhibit 38?
Yeah, it's the reckless skiing ordinance of Summit County.
Okay, so Plaintiff's Exhibit 38.
Was not admitted, correct?
Was that one admitted?
The one they objected to, but we would, we don't, we would want it admitted.
Clerk's records indicate it was admitted.
Okay.
I can look back at my notes.
33 and 39 was excluded, but 38 was admitted.
So it wouldn't be appropriate, I don't think, to give the whole ordinance hand it to the jury, or maybe it is, but this is the place where that law should lie. And there was a witness that referenced the ordinance.
So referencing is not the same as, like, this is a safety law.
Well, I'll have to see the ordinance, but if it, is this basically it? Skiers have a duty to avoid reckless or negligent skiing? Okay.
The witness, Paul Bogger mentions it.
I don't think he mentioned it specifically, but in our objections, I believe we have quoted the ordinance in case that's helpful on page 7.
Okay, I think I understand arguments on that. I'll take it under.
Can I mention one other thing? There's been no, and this will be the subject of a directed verdict now that we know they're closed. There's been no comment that there's a violation of the post-collision, that there's a post-collision negligence, or that it caused any harm. And let me emphasize that for a minute. To prove breach of a negligence duty, they have to also show that it caused harm. By all accounts, well, I should say by Ramon's account, he notified them of the person who they say injured him, and Mr. Sanderson that evening texted, "I'm famous." He said that because he knew who he had collided with. So I believe that whole post-collision negligence claim, there's insufficient evidence both on breach of that duty and on causation of damages.
Why don't we address it when you make your motion?
Okay.
Defendant's instruction 24 on spoliation. What's the defendant's response to their objection?
Thanks, Your Honor. And as I understand your order, and this is important for the plaintiffs on closing, the court has precluded either party from commenting on it, on how this arose. So, for instance, I don't believe it would be fair for plaintiffs to say, "Hey, Mr. Owens in opening said that link is really important, and here it is." I wanted the jury to be advised that it came through my office. The member of the public identified it, was able to open it, and the court declined that, which is fine, but I don't want to be beat over the head with it. Now to the spoliation issue. The GoPro is separate from the link. The GoPro came from a telephone call Mr. Sanderson made to his wife, his daughter, Shay, who testified. She got off the phone with him, believing there was a GoPro video, and she typed it to her dad. I can't believe this is all on GoPro. The plaintiffs have denied there was ever a GoPro. I think everyone agrees that if there were a GoPro video of the incident, that would be the very best evidence. I believe the defense has made a sufficient showing that there's a possibility that there was a GoPro video and it was deleted, and that we are entitled to the adverse inference, if the jury were to find that the GoPro was deleted.
Why not use the spoliation instruction that's in the Muji's?
That says if I find, which means the judge. So I don't think it quite works. And
what do you mean by that?
Isn't the wording of the Muji spoliation one?
Oh, that's what you guys used. Yeah.
I have found.
I have determined.
Thank you. I don't have it in front of me, so it doesn't seem to work.
Right. So, Mr. Bueller, or I'm not sure who's arguing this, Mr. Sorensen, I think that there is sufficient evidence in front of the jury from which they could decide that there was a GoPro video, and so I think, and that it was in your, that your client had access to it. So I am inclined to consider a spoliation instruction, but not as it's currently written. I think it would have to be a permissive instruction. In other words, if you find that there was a GoPro, and if you find that it was destroyed, then you may decide that it contained information that was adverse to the plaintiff's case. In other words, it's not prescriptive. It's not requiring them to make that finding. They just can make that finding. Because there's different levels of spoliation instructions, and I think that's probably the least stringent.
And as we understand it, Your Honor, I think spoliation is a legal issue that you are supposed to determine. And so I don't know that it's a factual determination for a jury to find whether or not there was spoliation.
I think there is in this. I mean, I think in this case, a legal instruction could be crafted that would allow them to make factual findings and apply it.
Then, as we understand it, the factual findings are just Shay's written email. Those are the facts that would support
so far
a finding.
Right.
Okay. But there's no intent. There's not been any evidence to this point of any intentional destruction of that evidence or
yeah, there's a
of that.
There's a Utah case that says that you don't that a party doesn't have to show that it was intentionally destroyed, just that it.
Well, the language.
The language in the Muji says that, but there's a Utah case. Let me see if I can find it.
Spoliation case.
So I guess turning to the defendants, I'm looking for a I mean, I can't approve the instruction as it's written. So
Okay.
it's
And what-
denied as it's written.
Do you have the case that you're referencing?
I'm looking right now,
So
yeah,
then-
hold on.
I mean, Muji lists 3 cases, I think, on the instruction.
I'm not on my normal computer, and this doesn't have all the software that mine does. All right, let's see. Oh, I don't have it here.
Your Honor, I just think it's highly prejudicial to, without, a thread. I mean, I guess the daughters, I can't believe there's a GoPro. She, that's.
I understand. So that one's denied as written.
So is the burden on us to now
If you want the
revise it?
instruction, I need one that's consistent with the law and the facts of this case, along the lines that I just outlined.
Okay.
That it be a permissive instruction.
So James, or Peter, can I delegate this to you? So a jury instruction that's consistent with the law and the facts of this case.
Right.
And the specific wording you don't like. So
This wording, no, because it doesn't require, well.
Right, but
The
what do you
jury
want?
the jury has to
If?
determine three things. One, that it existed. Two, that it was available to the plaintiffs and not the defendants, which I guess the evidence, that is available to the plaintiffs. And then thirdly, that,
Plaintiff destroyed it.
that the plaintiff destroyed it.
Then can we argue?
And then the last part of that is, if they make those findings, and I'd like to see the authority, if you could take a look, Peter, for the authority that I'm referring to. If they make those findings, then they may, but they're not required to assume that it would have been negative for the plaintiff's case. I'm not using probably the best terminology, but you get the idea.
Can we then argue against that?
Sure, absolutely you can.
Then bring up evidence.
Absolutely.
That the spoliation could have been the ski patrol or Deer Valley, because Deer Valley, I know our client thought that, he asked me before we even took this case, he asked, well, don't they have surveillance cameras there? And I said, no, a lot of resorts don't, and Deer Valley didn't at the time.
Well,
Now they
there's,
do.
that evidence isn't before the jury. Your argument has to have some thread to the evidence.
Are we, okay.
But whatever this instruction ends up being, you can certainly argue the facts as to the different elements that are in this instruction.
Okay. We'll wait for that instruction then, Your Honor.
Okay, I will wait for it as well. So instruction 28, introduction of tort damages. The objection is that should be changed because they're not asking for economic damage. Is that right?
Yes, and I think we gave a counter instruction down below, Your Honor, on that, on page 16. That.
Are you okay with the counter instruction?
Okay, page 16, may I read it for 1 second?
Yeah, sure.
So I would prefer, if something's simpler and more accurate, I would prefer just say, rather than you must decide how much will fairly compensate her, we just, I hope I'm following your brain track here. That Ms. Paltrow's has agreed that it's just $1. Is that the issue we're addressing, whether to do this big generic conversation about Gwyneth's damages?
Yeah, it's just following the Muji and with some changes.
I think we should change Muji just because it's simpler and to the facts, just to say $1. Rather than you must find, I guess they could decide they only want to give her 25 cents, but I think it's confusing to the jury. It's sort of like if we stipulated that they have $300,000 in medical bills, we should just say we have stipulated that there are $300,000 in medical bills. We wouldn't say we think you should decide.
So I understand that you want to simplify it. Is it an incorrect statement of the law, I guess is my question.
Is it word for word Muji?
Mr. Sorensen?
I don't have the reference below. Sorry, it's been a number of weeks since we crafted this.
All right, well, I understand both parties' position on that. Moving on to 29. Is there anything you want to respond to on their objections there? They object to the use of the $1 amount as previously stated, and they're asking for a compromise there.
I'm reading it. Okay, I'm looking at the top of 17, and that's their
No, that's yours. The bottom of 17 is what they're proposing.
Thank you for orienting me.
Excuse me, can I just borrow the Wi-Fi? We're trying to get another computer on the phone.
So, same issue, $1. Why are we making them think about Ms. Paltrow's number of economic damages? They brought in the fact that there's potential lawyer fees involved, and we don't want them speculating about that. So,
I think we're
Ms.
moving to
Paltrow is
$1.
seeking economic damages.
I mean, on the verdict form, do you want to just put $1 in her blank so that if they get to a yes, I mean, how do you want to deal with the $1 claim, or do you want to leave it open so they might award more?
The person defending that is Kristen Van Orman for.
Oh, that's true. That's true.
And I don't feel comfortable.
Okay.
So what if they came back, we want to give Gwyneth,
There, Your Honor, we did submit our proposed verdict form. So, I think that what we defer to what we've already submitted there for the special verdict
Okay.
form.
All right.
so the confusion, I think, Your Honor, what if they came back and said, we want to give Gwyneth $1 million? All right, we've sort of set them up that they have the power when they don't to order more than $1. And then it just sets us all up for potential problems.
Right. All right, I understand. I will take that under advisement. Number 33, pre-existing conditions. There is a Muji on this, and the court would just follow the Muji.
I think it's an issue for us, Your Honor, of the 2018 Muji or the current Muji. We prefer the 2018 Muji, but
Is that the second, Muji second, the most recent?
I think ours follows more along with lines of the 18, so not the current, but the previous Muji.
Okay, so it looks like the only thing that they object to, Mr. Owens, is the if any. That's bolded and highlighted on page 18. Is that right?
I don't have the old set. I mean, I would go with the new Muji as the current state of the law, which law I don't like, but it is the state of the law.
Well, would you object to if any on there?
Yeah, there's no if any in Muji 2018, CV 2018. So I'll just follow the Muji on that.
What's my view?
34? I mean, you can certainly make that argument.
I think we've stipulated to 34, Your Honor.
Okay, 34 stipulated. 45, hit and run. I think I've already addressed that.
When we say stipulated, was it a modification?
No.
As modified?
Well, I don't know if it was a modification or not.
The problem was we had agreed to some of these before they actually were filed with James, and we had gone back and forth. And so this was one that was listed as sort of being in disagreement, but we had actually previously stipulated, so.
So at the top of page 20, that's the defendant's proposed instruction on mitigation, and the plaintiff agrees to it. Okay?
Is that right?
Yes.
Yeah, that's what we.
Top of,
And I should put on the record, Mr. Egan had to leave because we have 4 experts staying at a hotel right now.
Okay.
To prepare for tomorrow.
okay. Defendant's instruction 45, hit and run, I think I've already covered that. It was,
You have, Your Honor.
it's been requested and denied for the reasons stated earlier. 46, I've already given the demonstrative
Which?
Instruction. I did give the instruction again, and I verbally inserted the word animation. I suppose I could take and modify the jury instruction that was already given and substitute it for the one that they received at the beginning of the case that contains the word animation.
I think that's fine, Your Honor.
Mr. Owens?
I think I heard you correctly.
Basically take the jury instruction that I gave the jury orally and take the one that was read in the opening on demonstrative exhibits and change and add animations to it so that we can substitute it in their package.
And animations?
Yeah.
Yes, we have other demonstratives that are not animations. But I
Right.
think you covered
and
that.
it won't exclude those. It'll still contain the language in the MUJI of charts and summaries. Chart summaries, including animations. I think I already covered 47. I think there was an instruction on, there is, in the opening instructions, there's already an instruction on Deer Valley Resort's dismissal.
May I comment on the animations briefly?
Sure.
Your Honor, we had 7 20-second animations. Not all have come in. I wanted them all in. Your Honor ruled that that was duplicative, or I thought maybe that was the word you used, but while we had Eric Christiansen on the stand, and then our expert, Dr. Bogger, was not permitted to talk about the animations. So, and I think our witnesses tomorrow, we're not going to be able to probably get the animations in through them. So I think we were prejudiced by this kind of being cut off, having to formally go through every step because the plaintiffs wouldn't agree to anything. And then, so I do feel like the defense was prejudiced in not being able to introduce all of their animations through the expert, or excuse me, through Eric Christensen and our Mr. Bogger today. So I'm just putting that objection on the record. If there's a way for me to mitigate that, I'm happy, I'm all ears to get the animations all in.
Yeah, I'm not going to tell you how to do your job.
I would like you to.
They were duplicative. They were becoming, I mean, the 3 were fine, but additional ones were duplicative as to that witness's testimony. And at the pretrial order on all of these animations, I thought laid out what needed to happen in order to get them in.
Okay, I'm just putting that on the record.
Okay.
I think they each added a little bit different viewpoint. They were done by different views, but we can proceed.
Okay. Instruction 48, this is tied in with your directed verdict motion, so I'm going to leave that in abeyance right now on the post-accident negligence claim.
Thank you, Your Honor.
So I think that covers all of those.
I think it does. Okay. Oh,
Let's, yeah.
Can we inform the court and the parties that we intend to call Dr. Bain via Zoom for his trial testimony? We'd like to get that pre-approved before we go through the great expense and preparation of having him at 9 a.m. on Thursday the 30th.
As rebuttal.
As rebuttal, 1 hour.
Do you have a sense when you're gonna rest your case?
No, but let's look to the time frame. I'm gonna tell you my latest thoughts, and I can tell you that they change hourly.
No, we've mentioned this many times before, Your Honor.
Let me think for a minute here.
We mentioned it earlier.
Yeah, I know you did.
Hours ago is not.
And my response is the same as it has been for the defendants. When they rest your case, you can put on your rebuttal. So, and I realize that that puts you in a difficult position with an expert that may not be available, and we certainly want to make any accommodation that we can. But as the plaintiffs were entitled to put on their case uninterrupted, except by whatever exceptions you guys agreed on, I think the defense has the same right.
All right, so as I understand.
That's fair, Your Honor. Thank you.
I'm reading this document, and I'm trying to interpret it. This is the court's timekeeping?
Yeah.
Thanks. Because I'm thinking aloud, but I am trying to be responsive to your question, when do you think I'm gonna rest? All right, so as I read this, both sides have had roughly the same amount of time, 15 hours. Both sides have about 9 hours total. So 4.5 hours each.
Isn't it more like 8 hours remaining?
Let's see, I'm looking at
5 tomorrow and
40 hours total, and about 30.4 are done.
I think you have to look at it a little differently.
I should?
Yeah, just what's available tomorrow and what's available on Thursday.
Okay.
So it's, hopefully we'll get 5.5 hours in front of the jury tomorrow and 2 3/4 hours in front of the jury on Thursday. So that is what you got left to split.
And that is not for closing arguments. That's
Yeah, it
just-
is.
Oh, that includes closing
Yeah.
arguments.
Yep. Otherwise, we're giving closing arguments in the afternoon on Thursday.
Yeah, I could agree with that, Your Honor.
I mean, I'm fine, yeah. Otherwise, that's what we're doing. I
Does
mean,
this-
maybe we bleed into the afternoon a little bit, if we have unforeseen things pop up, but that would be my hope.
Your Honor, just, I want to help counsel understand that he may only have 3 hours and 85 or 95 minutes tomorrow or something, 3 hours and 50 minutes tomorrow. Is that the way, how I interpret this? Because it's 7.75 hours left remaining.
Well, I don't know. That's just an estimate. But yes.
So his experts, his case has less than 4 hours.
5.3, 6, 7.5 hours, 7.5 hours, plus 45, that's 8 hours and 15 minutes if everything goes great. That's left to be in front of the jury.
I wonder if the distinction, so this last 45 minutes we agreed not to count toward anyone, does that, is that?
Was that counted against
recognize
anyone?
the 8 versus?
You had that 26 minutes because you didn't say it. Van Norman said that.
Okay.
You didn't agree to it.
And which side was it added, were they added to?
It was added to defense. It was 26 minutes.
Well, will you give me the new numbers, not including it? In other words, take that out of the defense.
What did we agree to?
Can you give that to me?
Actually, a total of 33 minutes because they went to 5:07.
Okay.
So I will.
Can you give me new numbers and then I'll put them on the spreadsheet? Okay. So that changes that dynamic by 33 minutes.
Now, it's good, by the way, you're keeping us on track. I heard you today say strictly held to this, and then I heard you say earlier, I think, like, in an ideal world. I may have misquoted you. So are we like to the minute on this?
I could just tell you what's happened in the past. In the past, one party has gotten to the end of their case and they haven't used up half the time, and they say, we're done. You know, the other side can use the rest of our time if they need it. I've had that scenario. And then, but I've also had a scenario when they've gotten to the end of their time and they're asking for more time, and it's not on the books where it would be available, and they had to sit down mid-question. I don't want to do that. I mean, and that was an unusual case where, well, I'm not going to go into the details, but I don't want to do that. So a natural stopping point close to the time that you're entitled. So in other words, when you get down to 5 minutes, I'll let you know, and you should wrap it up. And if you go over 30 seconds or a minute, or depending on the questioning that's going on with the witness, or in this case, you'll probably be in your closing arguments, right?
Yeah, under this plan,
I will be giving you 5 minute warning while you're in your closing arguments.
And this includes their rebuttal time?
Yes.
And if we go over, we don't get a closing argument.
Right.
Your Honor, one other question.
I mean, I'm not making a prejudgment here, but if I apply the rule strictly, yes, when your time, half your time is gone, if you haven't given a closing argument or you're not done with your closing argument, theoretically, you'd be cut off at that point. I don't want to have to make that decision, or I don't want to have to cut you off. So I'm hoping that you'll figure it out.
It's nice that we're even talking about, like, how to do closing argument. That means our trial's coming to a close, which is lovely. One way James Egan and I have split the case up is I've focused on liability and he's focused on damages. Is there any objection if we choose to bifurcate those issues in our closing arguments?
In the past, when I've been asked that, I've allowed it, as long as they do truly bifurcate between damages and liability. And you guys can do that too.
And their rebuttal on closing is also included in their time?
It is.
As much as I whine about this, I actually kind of like it. Can the parties, let's say at the end of the day tomorrow, stipulate that each side can have 30 more minutes?
We'll take that under consideration.
I'm not offering it.
Yeah,
I'm not offering
I'll
it. I may
consider
choose.
it. I'll consider it.
I'm wondering if,
because I want to consider I need to consider the jury, you know, and when they'll start to deliberate. But I'll certainly consider it if you guys do that. I mean, if the evidence closes tomorrow, then you've got 2 hours and 2 3/4 hours to give your closing arguments. Well, maybe I would want to call the jury back at 8:30 so I could read them the closing instructions, and then they would start. Then you would start your closings at 9 o'clock, and you'd each have half of that time to allocate between the plaintiff's argument, the defendant's response, and then any rebuttal.
so I know I'm just telling everyone I want an hour for closing. So I'm just sort of building that in. I think plaintiffs said they wanted an hour for closing. So just kind of knowing that's the thing. And okay, can I give my lineup for tomorrow?
Yes.
So Dr. Black is a radiologist. Dr. Hesch, Hoesch, is a neurologist. Dr. Eastfold is a neuropsychologist. Dr. Askenazi is a neuropsychologist. Potential remaining witnesses, if we get to them, would be Dr. Sanderson, Brad Falchuk, Jenny Sanderson, potentially Gwyneth Paltrow. I think we're going to run out of time. But
Are you going to rest tomorrow, do you think?
so I think it'll depend on the time.
Okay. We'll have to watch it then.
Can I ask a hypothetical, Your Honor? If they rest, Is it possible for it to go to the jury sooner, or we dismiss?
No, because
it's going to the jury Thursday.
We'll need to resolve the directed verdict motions as well as the jury instructions themselves, and we'll need tomorrow evening to do that.
But the jury could be dismissed
Yes.
early tomorrow.
Yeah.
Thursday.
I mean, it could.
You can guarantee we are taking our full day tomorrow. I mean, but I guess I should say never, but in terms of our timing.
So in terms of the court personnel, I need to move on to get to the other instructions. I'm looking at Paltrow's objections to plaintiff's jury instructions, starting on page 4.
Do you have the docket number, Your Honor? It's got to see my face. Counsel, do you know your docket?
969. And I think the special verdict form is going to be pretty straightforward. I think the plaintiff's special verdict form most closely follows the Muji special verdict form, and I think it's perfect for this case. So I will. I don't think we need to talk about it today, but that's essentially what will be put together. I don't think they don't differ that much. So.
May I look at it when the courts printed it out? May I look at it one last time? Like
of course.
This is what we're giving, and then,
yeah.
Okay, thank you.
Yeah, you'll have a copy. And I'll read it to the jury as well, so we'll go through it all together before the jury, before you start your closing argument. So 969, did you find that?
We did.
Okay. So page 4, nature of the case is already resolved, stipulated facts. Wasn't really, there hasn't been a stipulation other than the fact that we did today. If you want to put that in jury instruction, we can certainly do that. Otherwise, I've read it to the jury. Fault, we already covered fault.
Your Honor, what was that last one you said?
The stipulated stipulations between counsel, there's only been one stipulated fact, and that was the one done today. So if you want to submit a jury instruction on that one, that witness did not see the accident, I will certainly read that. Page 5, fault defined, we already addressed the fault instruction. Stay in control. I'm trying to remember which instruction that was.
That was the reckless instruction, Your Honor.
Okay, I'm looking at it. It's on page 13 of plaintiff's instructions. This was based on the Summit County ordinance. I'm assuming that if the ordinance is adopted into that other instruction, that covers this one?
This is their objection, but I would assume that, Your Honor.
Okay.
Your Honor, I don't remember, so Christensen was asked about this, Bogger was asked about this, but no one laid the foundation that this is, quote, the law, end quote.
Isn't that what the court does, though?
So,
in other words, facts were introduced that could be applied to the law. In this case, it's the Summit County ordinance. I don't think a witness has to testify what the law is. In fact, they couldn't.
As a legal conclusion.
So, did any witness even mention the term Summit County ordinance?
I thought there was, but I don't know that that's determinative for the reason I just stated.
I think
there's no witness that testifies that as to negligence either. They just testify as to the facts, and the jury decides if it fits negligence.
All right, well, my thought process is if it's not admitted, this is a civil claim, so it's not like a criminal matter where like the definition of homicide is the law. I guess I don't think then we just, why don't we give them the statute on inherent risks? I mean, it seems like someone sort of has to build in that this is the law.
Inherent risk is a immunity statute, not a safety statute.
I understand that's your position.
No, I'm talking, sorry, I was talking to counsel.
Okay. So I've got, I mean, there's extensive argument here by the defendants. I'll consider all of it on this stay in control of instruction.
Maybe one more piece of information. So that last Supreme Court case, Donovan versus Sutton.
Right.
They specifically did not decide, as I recall it, that
look to the summary at the end. It's where Justice Peterson repeats what the holding is.
As Donovan has failed to persuade us that the facts here implicate Section 316 of the Second Restatement of Torts, even if we were to adopt it. So we leave that question for another day.
Are you looking at the appellate court decision or the Supreme Court?
Thank you for asking me that. Utah Supreme Court, Donovan, last sentence
Okay.
of the entire opinion. To the extent that that helps us, like, not admit into evidence the statutes, I would defer to it.
Okay. Thank you. Then there's an instruction, downhill skiers have the right of way. Anything that you want to add to the objection? I mean, in response to the objection, Mr. Peterson? I have the objection here.
Your Honor, I think maybe two other witnesses referred to it, including, in addition to Bogger, Graff, and Christensen.
Are you on?
It meaning?
Are you on instruction on page 14? Downhill skiers have right of way. So the plaintiff is asking for an instruction on page 14 of their proposed instructions. Downhill skiers have right of way. The defendant on page 7 of their objections have listed their objection. So do you have any reply to their objection?
If I gather this correctly, they want to roll or wrap in the skiing safely or staying in control with the downhill skier right of way instruction, and I think we'd prefer that they be separate.
And we object to the Donovan inherent risk part of it.
Yeah.
Okay. Under advisement. Next one. Skier's duty in the event of a collision. I think that's kind of wrapped up in what the court decides on the ordinance.
I think you're right, Your Honor.
And again, this directed verdict tomorrow morning is going to be
Okay.
on that issue.
All right. Court damages we covered on page 9 at the top. And collateral source payments. What's the response to the defendant's objection on the collateral source instruction? And I realize.
Is that a Muji instruction?
It is.
Do we have the Muji?
2024, and you basically follow it in your proposed instruction.
So we just want to stick with the Muji, Your Honor.
Okay, I'll take that under advisement.
I have one sentence on it if you want.
Is it more than you've already done?
That would require me to know what I've already done.
Okay,
But,
go ahead.
I suspect in closing, they're gonna say, hey, he incurred a lot of economic damages. But we're, out of the kindness of our heart, because he was in the VA system, we're not claiming those. And I don't want them to do that in closing.
Are you gonna argue that?
We've been over this a lot. No, we're not planning on arguing that.
This is a pure non-economic damage case.
You essentially made a judicial admission that you're not seeking
We have, Your Honor.
economic
We've
damages, so they
stipulated
could
to
not
it.
make that argument.
Thank you.
Gone over it many times.
Are you still requesting the collateral source instruction even though they're not claiming economic damage?
So we are objecting to collateral source payment objection. Is this correct? They want it and we don't. Yeah, why would we have it? The whole thing is discussing economic damages that aren't being claimed.
You still want to maintain the collateral source instruction, counsel? Plaintiffs?
We'll defer to what,
Yeah,
we think the Muji is appropriate. If it is a concern that it's gonna be raised, it's been an issue here. We've had VA records all through here, so, I don't know.
yeah, I think it's a useful instruction, Your Honor, in case the defense insinuates that we've got VA coverage, and they did in their opening.
I don't recall doing that. I'm not gonna do it in closing.
It's the insinuations that and also the assumptions by many people that, insurance or retired military people or VA coverage is out there. So we think it's a useful instruction.
Your Honor, this does remind me my opening. I said he is a vet. He has care through the VA. His VA treating providers assessed him neurologically, neuropsychology-wise, and they found he's average to above average in every category. None of that deals with like collateral source dollar amounts. There's no reference to that.
And I think also, he didn't pay anything.
It's never come up.
Okay, I've got the new totals on time, if you want to jot these onto that spreadsheet I gave you to correct at the end of day 6.
Thank you.
For the plaintiff, it's 15 hours, 19 minutes. For the defendant, it's 14 hours, 50 minutes.
The defense went down?
Yeah, it took.
Yes.
Oh, that's right.
Took away the time from the reading.
Okay. Moving on, demonstrative exhibits, I think we already covered that.
I think you're right.
Special verdict form, I think I just discussed that. I think that covers it all.
I think so, Your Honor. Thank you.
On this jury instruction number 24, is the best way
Spoliation.
yes. Do you prefer that be filed by pleading or emailed to all the parties?
I guess at this point, I have no preference. I mean, whatever way you decide you want to do it.
Hey, Peter,
If you do file it in the court docket, also email it so that it gets to me faster.
yeah,
Got it.
and if I may, there was a filing or an email that went out and it had the incorrect email for me, so I never got it. And it was from the defense. So, Steve, and if you guys could make sure you have the right email, it's on our pleading, every pleading, because Jackie at Bob's office noticed and said, Hey, Lawrence, you didn't get this because they sent it to the wrong email. It just misspelled the first part of my email address.
Do you know who that was? Who sent that?
I could find out.
It came through sometime earlier this morning, I don't know.
Yeah, I haven't done any emails this morning, but yes.
Well, it came through on the, like, last weekend, like Friday or something, and I never knew about it because it didn't come to me.
That would be very irritating. And your correct email
It's
address?
on all the pleadings, every pleading we've ever filed.
Okay, thank you.
It's L. Bueller. Sometimes the small L looks like an I and it goes to my wife Isabel, so that's why I always try to capitalize the L.
I promise you that was unintentional.
I know it was. I just wanna, since we're getting down to the wire here, we need to make sure these things get through.
Mr. Owens, how much time are you requesting for your directed verdict motion in the morning?
Does that count against his time, Your Honor?
We'll come early.
Okay. So it won't. I just wondered if it
It's
did.
not time in front of the jury, so I haven't been counting time not in front of the jury.
Okay. And,
I envision
how, we need,
less than 15 minutes.
Okay, so if we were to start at, say, 8:15 tomorrow, that would be sufficient for you to make your motion, you to make your counter motion, and hopefully meet a rule? Or not
yeah.
counter motion, but your opposition arguments?
right, but it's hard to make an opposition argument until we get it, so if we get it just before,
It may be oral.
and,
What I'll be looking for is for you to marshal the evidence that's come into the case that would support me denying the motion. I'd be looking for you to put in front of me the facts of the case that would give me what I need to grant the motion. In other words, the absence, pointing out the absence of whatever critical evidence that there is. And making a record with those facts. Both of you make it by witness and what they said. That would be helpful.
okay, this is the directed verdict, I'm sorry, I was what's the directed verdict in a sentence?
You have rested now. Maybe you were gone for part of this meeting, but, so, I don't think I have to preview it, but, because I haven't thought it all out, but I will preview it.
I thought you mentioned it to the judge today, or just this evening.
I'm thinking of things every minute.
I know.
But, one aspect of it, at a minimum, will be, a directed verdict on post-collision allegation of negligence, which would include this idea of you gotta leave your name, you gotta fill out paperwork, and that there are no damages. It did not cause any damages, even if true. That's what I'm thinking at the latest moment.
Okay. All right, so, but be prepared for anything on the directed verdict motion. It can be made orally, and he can make whatever motion he wants to make. So be prepared to marshal the evidence to support all of the elements of your client's claim.
Okay.
Anything else for today? Okay, so we'll reconvene tomorrow morning at 8:15 for the motions.
Your Honor, we're just trying to figure out how to do this Zoom. I know you've already spoken about it, but I guess Friday is out because the case will be in closing argument or going to the jury.
Thursday.
Excuse me. Thursday. So tomorrow is basically the last time for any of the rebuttal witnesses we might present.
Or as I indicated earlier, I'd consider asking the jury to come early on Thursday.
Okay. Something like 8:45 or earlier, because
Earlier.
Just to be fair to counsel, it would be Dr. Bain to rebut what Dr. Scher said today. And it might be, we think we could do it in 15 minutes, maybe a half an hour. They may want to have another half hour, so maybe 1 hour.
And then you need to figure out the technology to get him here.
Yeah, I think we can do that. Your Honor. We can plug into your media kit.
Okay.
So I'm all for I don't think we ought to torture ourselves unnecessarily. If the jury's gonna get the case by noon, I don't think it's that important that they get it by 11.
Yeah, if each of you hold yourselves to 1 hour, make that commitment. Does your hour include any rebuttal?
Yeah, we would like a rebuttal, Your Honor.
But does that hour include your rebuttal time?
Well, if we have enough time, we might want a longer one, you know. I'm not as succinct as Bob Sykes.
I guess what I hear Mr. Owens saying is why not just start at 9, let him do the Zoom call at 9.
Yeah, I'm not agreeing to anything, but I don't like this idea of let's get everyone here earlier than 9 if they're gonna have plenty of time to deliberate. That is what I'm saying.
What's your witness say, Mr. Bueller? When is he available?
He's got some flexibility on Thursday.
Thursday morning?
Thursday morning
Yeah,
hours.
for sure,
He's got a couple
tomorrow
hours.
at 2. That's what we had,
Yeah.
but we talked to him about an hour ago, and we think we've got.
About tomorrow at 4:30. At 6:30 his time.
I'm not gonna be
We can
done.
Find out, but I think Thursday might work early if, what? We could do it first thing. He's 2 hours ahead, so we could do it at 8:30, 8:45.
Or even 9 o'clock?
Or even 9 o'clock.
We could.
Any other rebuttal witnesses expected?
Well, we had some, but given the new calculations, we might be cutting.
We're gonna see how our time is shaking out on tomorrow.
All right.
We're in the mood to cut rather than add.
So it sounds like the defendant will likely rest tomorrow. And if they do, then it sounds like you will have time to do this short Zoom examination on Thursday morning at 9 o'clock. But that's all tentative and depending on what happens tomorrow.
I don't think we'll end up resting tomorrow, Your Honor. I don't.
The other option, which I don't like, but it was raised by one of my co-counsel, we could do another trial deposition.
Right.
And, but that, we'd have to have a stipulation of defense counsel or an order from you to do that. And right now, I'd move that we get such an order if we're, depending on, because we know we can get them at 2 tomorrow.
Well, just alert your witness that it might be 9 o'clock or it might be later. On Thursday morning.
We already agreed to do it once. We're not gonna do a second trial deposition on the last day of evidence. We're not agreeing to that.
All right, we'll see you tomorrow at 8:15. Thank you.
Thank you, Your Honor.